uh, bodies and organs, colleagues, ladies and gentlemen, all protocols observed, good morning. Good morning. Thank you very much. I think we are going to have to be a little bit more lively than that because we have 2 days of a packed program ahead of us. So we will need a little bit more of life to carry us through. Greetings from the Center for Human Rights at the University of Pretoria in South Africa. We are here to attend this conference on the implementation and domestic impact of the decisions of the African Court on Human and People's Rights in partnership with a number of other partners that I'll get to later. And we are really incredibly privileged to be able to host this meeting alongside you. I am personally immensely honored to present my regards to you this morning and to join us in the conference, which is, as you may know, happening on the sidelines of the 73rd public session of the court. As one of the organizers of this conference, the Center is privileged to welcome you to Arusha. And we really sincerely want to thank you for taking your time out of your very busy schedules and the responsibilities that you hold to join us for this very important engagement. For the Center, this conference is a flagship area of work. It's within a broader area of work that is around human rights, implementation of human rights in the African region, and is aimed at enhancing the effectiveness of the African human rights system, including the work of its organs and institutions, including the court. Under this broad umbrella, we have undertaken a number of initiatives, including a similar conference that was aimed at the implementation of the decisions of the African Commission on Human and People's Rights, which we held in September of last year in Pretoria, South Africa. As has been noted by the moderator and also in the concept note for this conference, African states have widely accepted the core African human rights treaties, in theory at least, and have embarked on different processes at diverse levels to domesticate these international treaties at the national level. However, there isn't a similar consistency in terms of, and commitment in terms of compliance and implementation of the jurisprudence of African human rights bodies, including the court. And this non-implementation and lack of compliance with these decisions is, in our view, undermining their effectiveness in delivering justice to victims of human rights violations across the continent. The trend of non-implementation cuts across all decisions of all organs, so it's not exclusive to the court. It is a trend that we see in relation to the decisions of the committee, in relation to the decisions of the African Commission as well. So this calls upon us as stakeholders invested in the effectiveness of this system and ultimately in the furtherance of the rights and freedoms of African citizens to reflect on why this is the case and what can be done to turn the tide. Your Excellencies, ladies and gentlemen, this is where our dialogue today sits. This conference brings together a mix of representation, including participants drawn from the judiciary, particularly the African Court in this case, public and policy spaces. We have a number of government representatives in this space, academia, civil society, law, and other human rights practitioners. We obviously represent very different interests, but all these interests converge at the optimum protection of human and people's rights across the African continent. I cannot speak for everyone, but as an academic myself, I can say that we are always looking forward to the jurisprudential discourse emerging from the decisions of the bodies, and in particular the court, because we are interested in how it advances the cause for justice and how it contributes to the discourse on human rights in Africa and beyond. As a civil society organization, we see the decisions of the court as handy tools to support our advocacy and the pursuit of accountability for human rights implementation. As litigants, these decisions offer hope and an affirmation of dignity for people whose only opportunity to access dignity is through this forum. I hesitate to speak on behalf of states because we have state representatives here. So they probably can speak to what these decisions represent for their constituency. But jointly, we aim to reflect on the state of implementation of decisions of the African Court during these 2 days, to think through the reasons we see as why there is an apparent non-implementation of the decisions, but especially and fundamentally, what can be done to improve and accelerate implementation of the decisions that we have received. In the end, I think it's important to just say that we are all on the same side. And therefore, even though we may not, it may not seem likely that the different interests we represent here could speak probably in one voice, we aim for an engagement in the next 2 days that is largely conciliatory, constructive, and instructive as to get to the goal of implementation together. Your Excellencies, colleagues, I think it would be important for us to just keep in mind some contemporary issues that influence this gathering this morning. One is that a culture of the rule of law is a prerequisite for human rights progress. And it is a prerequisite for the implementation of human rights. So definitely we ask ourselves, how far are we in the African continent in as far as fostering and nurturing a culture of the rule of law? And secondly, that we have some emerging and in some cases fledgling pushback on the human rights agenda across the continent, but even across the globe. How does this phenomenon count and contribute to our current discourse around the implementation of the decisions of the African Court? It's not something that we can afford to ignore, because that pushback affects not just our thought processes, our political commitments, but also the commitment of resources that make it possible for us to implement these decisions. The third issue, which I find very intriguing, is the changing demand for accountability, because the implementation of decisions is largely, or litigation of human rights is largely about enforcing accountability for human rights. But there are also challenges that come with governing a new generation, and maybe also the need to contend with the evolving notions of justice from generation to generation. I think, for instance, it's very interesting to observe what's happening across the continent. We don't have time to look at everyone, but I stand here having been following in the past 2 to 3 days the demonstrations that are happening just across the border in Kenya in relation to the tax bill. Those demonstrations are led by young people, or what we popularly like to call Generation Z or Z. These people have a very different mode of engagement, a very different understanding of what accountability looks like, a very different understanding of what demanding accountability from leaders look like. And I think it is a fundamental question to ask ourselves as we sit in the seat of policymaking and decision-making. Are we speaking for and to, on behalf of that generation? Is the manner in which we construe justice consistent with how they view it or how they benefit from it? Especially considering that a majority of those of us sitting in this hall are not from that generation. That generation constitutes more than 50% of the African population. Are we engaging effectively? Do we have the potential to engage effectively? Do the systems we currently have in place speak to that generation? I think that this changing demand for accountability means that we need to demystify the human rights discourse and to dismantle the powers or the towers that we have set up for delivery of justice. And that the rule of law and the decisions of this court need to become common parlance that is no longer elitist and that is not sophisticated. We need to demystify it to be able to speak to all of us. I think there is definitely a place for the traditional justice system and the traditional notions of justice, but it's probably not serving us very well in this moment. Your Excellencies, colleagues, it has been said that ideas are useless unless used. And by the same token, I think the decisions of the court are useless unless used through full implementation. And similarly, I think, as we all know, people don't always remember what we say, or for that matter, what the court said in those decisions. They remember what happened as a result of these pronunciations. And that is our challenge here today, to improve the implementation of the decisions of the African Court so we can actually have an impact on the ground. This gathering has been made possible through the support and collaboration, of course, primarily with the court, with the support of the Office of the Registrar and inputs from various partners that I have to acknowledge at this juncture, particularly the Coalition for an Effective African Court, the German Development Corporation, GIZ, the Raoul Wallenberg Institute, and the Open Society Foundations. We thank you all for your respective contributions to this cause. In closing, I thank you once again for taking time to join us and for sharing your wisdom, skill, and experience over the next 2 days. And please allow me to welcome you to this conference and to wish you all a very fruitful deliberation during the conference. Thank you.
Thank you so much, Professor Nkata, for that welcome address. And indeed, we will not remember the words that were said, but what was done after those words were said. I would like to call on Justice Modibo Sako, who is the Vice President of the African Court on Human and People's Rights, to give his opening remarks.
Honorable Ben Kyoko, doyen des juges de la Cour africaine des droits de l'homme et des peuples.
Ladies and gentlemen, representatives of the court, Deputy Registrar of the African Court of Human and People's Rights, Madam Malota, representative of the African Commission of Human and People's Rights, Mr. Adan Sike, representative of the African Committee of Experts on the Children's Rights and Welfare, Professor Nkata, Interim Director of the Center of Human Rights, University of Pretoria, Madam Sophia Ebi, coordinator for the Coalition for the Efficient African Court. Dear participants, ladies and gentlemen, in 2011, the African Court gave its first decision. And that's 5 years after the beginning of its operations. Actually, though, it was a little bit slow when it started. The first is what we need to understand that that's no longer the case today. And today, the court has given 404 decisions, including 140 decrees. And this encouraging dynamic has not actually been followed by implementation on the ground. The concerned states, I'm talking about the execution of the decisions. And so we have very little results to rejoice for in the courts are below 10%. And so this conference on the implementation and domestic impact of the decisions of the African Court of Human and People's Rights, where judges and the staff of the court have been invited, comes after the conference organized in Dar es Salaam in October 2021. A reminder, the objective was to analyze how the decisions of the courts are received, are implemented, or rather received and implemented at the national level. During the conference of Dar es Salaam, we saw that the law implementation of the decisions of the court does not reflect the commitments made by the African states during the creation of this court, which was to guarantee to the African people the possibility to have access to an efficient African system for protection of human rights. As recommendations were done to ensure that the decisions of the court were undertaken, the ownership of the challenge of the law execution of the decisions by the member states of the African Union, the organs, the universities, the organization of the civil society, media show the importance of the realization of the Africa that we want. The different issues we're going to talk about during this conference are going to inform the way forward. I would like to underscore some of these things. We need to debate on see how we can together work to ensure that these decisions are implemented by getting contributions from the different experts to see how we can do a comparative analysis with regard to the implementation of the decisions of the court, the role of the different stakeholders with regard to the implementation of these decisions. With regard to this last point I've talked about, it is important to understand that the Article 29, paragraph 1 of the protocol, with regard to the execution of the decisions of the court, the internal regulation of the court came up with a procedure of monitoring and the implementation of the decisions. They were supposed to come up with a committee to see how these decisions are executed. Ladies and gentlemen, with regard to the different experts invited to this conference, I'm sure that we're going to come up with solutions, propositions, suggestions that are adapted to the African context, taking into consideration the socio-political realities of the continent. If taking into consideration that we need to ensure that the human rights decisions are undertaken. And we are going to work with the Center of Human Rights from the University of Pretoria. We commit to review the different recommendations and the conclusions that are going to come up this conference to see how they can help our different countries move forward. With regard to this new commitment of the African Court, on behalf of the President, Imani Ndao, I wish you success in your deliberations, and thank you very much for your kind attention.
Thank you so much, Justice Sako, for the opening remarks. I would like to call on Ms. Sophia Ebi for her opening remarks as well. So we'll be able to go to you.
Good morning, everyone. Habari za asubuhi. I request to stand on the protocol already established. My name is Sophia Ebi, and I am the coordinator for the African Court Coalition. Of course, I see so many familiar faces and some of the unfamiliar faces. For those, at least for the benefit of those who do not know about the African Court Coalition, we are an independent NGO of whose mandate is to advocate for an effective, independent, and accessible African Court on Human and People's Rights. We are based here in Arusha, Tanzania. In some of the objectives or our mandates in the efforts to advocate for an effective African Court, implementation of the decisions of the African Court on Human and People's Rights is one of the issues that we have been working on. We have implemented a number of activities under this particular subject. We have published, we have publications on the implementation of decisions of the African Court, but we've also been organizing dialogues with different stakeholders. And actually in 2021, when the African Court had its implementation conference in Dar the same year, just before that, we also had a convening in Zanzibar, where the main objective that we discussed was implementation of the African Court decisions. And we also had participation of state actors, and I'm also happy to know that we have a representative from the state here today with us, but we've also been working with partners at national level to enhance implementation of the African Court decisions. And it's also fortunate that we have one of our member and also a partner that we've been working with in Ghana to enhance implementation of the African Court decisions. He's here, and he will also make a presentation. I think if it's not today, then it's tomorrow. With that, you will also have an opportunity to hear what we've been doing at national level. So these are just some of the activities that we've been organizing around this particular area. But now, you know, most of the time when you come to speak and some other people have spoken before you, either they made your work a bit harder for you to do more, or they can make it much more easier. And in this particular space, I am glad that the Vice President of the Court, Justice Modibo Sako, and Professor Nkata, they have already raised these issues. And I really wouldn't want to repeat what they have said, but more to just insist on the importance of implementation of the African Court decisions and regional human rights decisions in general. We do understand that implementation can be a complex process. And this is also why we have various stakeholders here with us today. And I would really like to appreciate all of you who have taken your time to use your intellectual property to help us in this process to enhance implementation of the African Court decisions. This is very much appreciated. But also I would really like to thank the African Court for this partnership that they have been giving us as the coalition, and also the Center for Human Rights for giving us this opportunity and partner with us, knowing that we have been working a lot around this issue and we are still working on this. So it is really important to have these various stakeholders, but also, as Professor Nkata said in her remarks, it is really good to hear from the state representatives because we have to start, or we have to strategize, especially for us as the civil society organizations. We have to strategize given the different challenges of implementation that are there in different countries. And I hope we are going to hear all these presentations from various people who are going to make their presentation on different aspects of implementation. And I really look forward to that. And I can just say that, anyway, I was part of the organizing committee, so I've seen some of the papers and there are so many ideas. So I really look forward for us to have these discussions, and I hope they are going to be fruitful ones. And also, I also know that so many are looking forward to the recommendations as into what is going to come out of here. Because I also know, as I've said, the court had organized an implementation conference. We've been doing that, but I think we also, at some point, we need to move from just sitting and conversing, and then we need to go into actions. So even for us at the African Coalition, we're really looking forward for the discussions and the recommendations that are going to come out of this. But I would also, again, like to really appreciate our partners who have made this convening possible, OSF, GIZ, the Raoul Wallenberg Institute. As a matter of fact, some of these partners came at the very last stage of the preparation. So we really, really appreciate that. And with that, I wish all of us the fruitful deliberations. Thank you very much.
Thank you so much, Ms. Abi, for the opening remarks as well. To go to the next stage, which is literally the introductory session, I would like to call on Folusho Adegalu, who is the Program Manager for the Litigation and Implementation Unit, Center for Human Rights. Folusho, over to you.
Thank you very much, moderator. Good morning, everyone, and welcome. It's good to see that we're all in this room. And I would like to stand on the existing protocol. As introduced, my name is Folusho Adegalu. I work as the program manager in the litigation and implementation unit of the Center for Human Rights. So the unit is the host unit within the center as an institution that has been working closely with our collaborators on this conference. So in this short time, I would just want to explain to us what to expect over the next 2 days in terms of also breaking down some of the formats in which we have planned this conference and which will guide us for the next 2 days. I would also, within 2 to 3 minutes, give chance for questions, comment, and clarification that anyone have just when I make some of the explanation, and that will be what I'll be doing now. So I think all of the speakers before me have really spoken extensively on why we are here, the reason for us to look at the implementation of the decision of the court. But how do we go about this 2-day conference? So as you would see on the program, maybe if you can just also go through the program with me as I speak, I think that would be grateful. So we have the, mostly after the introductory session, the other sessions move into panel. So we have panel session, and the format for the panel session is that each presenter on in a particular panel session, an individual on a panel session, will have about 10 to maximum 12 minutes to make their presentation. And we would really implore us to stick to this time because, as we can see, it's a very packed day. And I think the reality of us living here in that time frame really depends on how we manage to stick to the time. So for each panel presentation, this table and chair that is up here, the chair of the moderator will invite the chair of the panel session and either the 3 or 4 presenters to come and sit here for their panel session. Now, when that is done, then the job goes to the chair of the panel session. So the chair of the panel session calls the presenter in turn on the program, and each presenter comes to the podium to make their 10 to 12 minute presentation. There's a screen here in front of you. You would see if you have PowerPoint, and it's also here. So you have a pointer for your presentation, and you can decide if you want to do from the front or you just want to, talk to us from this side. So after each presentation for an individual, they go back to their seats, and then the chairperson calls the next person on that same panel session to come and make their presentation. Now, when that final presenter for that panel session is done, then we move into the question and answer and comment session. Now, also for the comment, question, and answer session for each panel, there's a particular format for that as well. So for some of the session, you would see that the African Court has specific representative that have been designated to respond to a particular session. And for some, it's left empty. So the order is that after all of the presentation has been taken and the last presenter has gone back to their seat, the chair of the panel session yields the floor to the court as the first who has the first right of audience. So in instances where they are designated person, we would anticipate that the designated person probably respond first, but also in instances where there are no designated person, the floor still passes to the court and the court exercises its discretion whether it wants to respond or not. Then after that, we then yield the floor to everyone in the room to ask questions and maybe comment and remarks. Then when all of that is taken, so we're taking all of that as a group, and then each of the panelists, we identify the questions or comments that relate to them as we're getting it from the floor, and then the chairperson will yield the floor back to the panelists from this chair, and then they respond in turn to their question. And after that, to now wrap up that particular panel session, the chairperson will give about 2 minutes concluding remarks, just tying together some of the key things that have emerged from that panel session. So that is how we anticipate the panel session, and that is really the format of the presentation. So maybe before I before I go to, there are some slight changes, and but we will leave that to be announced by either the moderator or the chair panel or chair of the panel to tell us about the slight changes. In terms of some of the key outcomes from this conference that we have so far. So the presentations from this panel, the paper presentations, which we have selected, we expect our presenters to further develop this paper, and then we'll have it published as a special issue of a journal towards the end of the year or early 2025. Then the second immediate outcome is that as we are having this session, we will be taking note of some of the key outcomes, and we will have a brief discussion as the center with our collaborating institution, and we would have the conference outcome and way forward session. And from that, we will also continue dialogue after this conference with relevant stakeholders based on the outcome of this conference. So I think that's just a short description of how this conference will go in terms of the program and also the immediate expectation. And just to now say one other thing, and when Prof. Murungi was speaking, she did mention the fact that as the center, we are interested in the influence of the jurisprudence of African human rights bodies. So there are two things on the program that are closely connected to the conference, but also in a way, it's a separate activity on its own. One of them is the case discussion on the second day. So the case discussion is part of the activities of the center to engage in analytical jurisprudence of decisions of human rights body. But because we are looking at the court, we just understood that there's no better space to have that kind of conversation than the room that we will have for the next 2 days. And also, there is also a session on day 2 at 12 o'clock, which is on advocacy campaign on individual access to the court. So that is a little bit separate from the conference, but it's also attached to the conference because it's part of our advocacy campaign at the center to look at, to ensure an increase of access to the court through ratification of the court protocol, and most importantly, the pursuit of the Article 34.6 declaration. So that is really a brief overview of the program. And like I said, the aim and objective of the conference, I think all of the previous speakers have spoken to that. So I would not speak much about that. At this point, I would just want to see if there are 1 or 2 questions or clarification, and just before I wrap up. Okay, it looks like everything is well understood. In the light of that, on behalf of the organizing team, I would like to thank our donors as well, OSF, RWI, and GIZ. And also on behalf of the organizing team, I would also like to thank everyone that has worked to make this happen. I'd like to thank Fatma, Dr. Oras, and Dr. Segis from the course that we've been working with, and also our partners, Sophia and Rebecca from the coalition. And I would also like to thank all of the team from the Center for Human Rights, our comms persons, Simpiri, Zainab, and Brian, and Ruth. I wish us a fruitful 2 days. Thank you very much.
Thank you so much, Mr. Adegalu. Now we've come to the part where we get to set the scene. In this room seated, we have human rights scholars, we have practitioners, we have representatives of civil society organizations, we have partners and stakeholders, we have state actors, we have representatives, judges of the African courts, and as well as staff of the African courts. And this is to discuss the challenges relating to the implementation of the decisions of the African courts, as well as strategizing around the most practicable solutions with which to improve compliance regarding the implementation of the decisions of the African courts. I'm sure maybe Justice Stella Anuka may not remember, but I remember in 2017, we were in Banjul, and then she had told me when I met her that she was going to run for the judge of the African courts. And 7 years later, she is seated here. as a judge of the African courts. And I think that brings so much joy to my heart that indeed, I remember the word she said to me at that time was that whatever you do, be the best in what you do. And so it's with great pleasure that I would like to introduce Justice Stella Nukam, who's the judge of the African Court on Human and People's Rights. Over to you, Justice Anukam.
Good morning. Are we excited to be here this morning? Okay, I've been introduced. I also want to join others to stand on the already established protocol. And before that, I also want to give honor to whom honor is due. And I say that on the behalf of the Vice President who is here and the judges that are here. We want to thank truly from the depth of our heart the interest of the organizing team in this particular topic, which is of great concern to us. You can imagine a judge gives judgments and no implementation. It's indeed very worrisome. And we are glad that you gentlemen and ladies have decided to converge here today to look at the issues, why we are where we are at, and with the hope of moving forward. I thank you sincerely. I want to mention the Coalition for Effective African Court. I thank you. And also the Center for Human Rights, University of Pretoria, and all other stakeholders that are here. I joined the Vice President to say thank you again and again. In the African culture, it's never too much to say thank you. So now I go straight to my paper, which is setting the scene. Want to set the scene towards improving implementation of the decisions of the African Court. With the few minutes that have been allotted, I'll go straight to the paper. By way of introduction, we believe that the first issue we probably have to explain is the nature of our judgment, because we realize that perhaps some states or some state parties, they really have problem understanding how to bring about the implementation of our judgment. So is the judgment of the court a foreign decision, or does it on its own inherently become implementable? So that question I want to first quickly address. The international courts, they share a challenge with us when it comes to the implementation of their decision. And when I talk of international courts, all other international courts, even ICC, ICJ, the ECOWAS, and I guess our sister court here, the Eastern Court of Justice, same thing. Why non-compliance is easy to establish? The reasons thereof may be difficult to identify and address. The satisfaction that is drawn from litigation should go beyond the decision itself and translate into reality through actions taken by the respondent state or whoever is the judgment debtor to comply with the measures ordered by the International Human Rights Court, for example, thereby guaranteeing the effective enjoyment of rights, human rights. The implementation of the judicial decisions of the African Courts on Human and People's Rights, I will just shorten it to say African Court in this paper, has been the subject of constant attention in various gatherings and initiative involving experts like we are gathered today. This mobilization is evidence when the enforcement of our decisions should seek to achieve the realization of human rights, and that is the concern, and contribute to the effectiveness of the court's mandate to protect human rights across the African continent. However, the available statistics, and I will share some with us later in this paper, show that the level of enforcement of our decision is not encouraging. This observation is not unique to the court. What do we do? As a result, various issues may arise that require discussion in the context of the topic being presented today. And I will try to address these limitations in threefold. We look at the legal status of the African Court's judicial decision. This paper, we also address the implementation mechanisms, in particular the challenges and achievement thereof. And finally, the prospects and way forward in respect of improving the implementation status. That is from our perspective, but I know some we may gather more at the end of this conference. Now I begin with the legal status of judicial decisions of our court. In view of the dilemma often raised on this issue, it is primarily in a discussion on the implementation of the decisions of the courts to make some observations on the nature of such decisions. In this respect, permit me to make a distinction from the onset between foreign decisions and international decisions. A foreign judgment, as some of us may know, is defined as a judgment delivered in its original jurisdiction and seeking enforcement in an alternative jurisdiction. This would be, for example, a decision handed down by the Supreme Court of Nigeria and whose enforcement is sought in the Republic of Ghana. On the other hand, an international decision is one delivered by an international court or tribunal and which is enforced within the territory of one or more states against which the decision was rendered. This is the case of a decision of the European Court of Human Rights in respect of France, the enforcement of which is undertaken on the territory of the said state. So decisions of the African Court should be included in this category. That is, it's an international decision. In order to understand the nature of this decision, it is necessary to consider the law that is applicable to them. One, foreign decisions are governed by national law and the civil law practice of the exequatur, a Latin word meaning let it execute, otherwise known as domestication or incorporation in common law jurisdiction, which consists of affixing the national judicial seal to a decision given in another country, so that the said foreign decision is enforced in that country of destination, as though it had been delivered in the latter country. As a general rule, the exequatur is granted under the following conditions. One, the foreign decision was issued on the basis of a law identical or similar to that applied in the country of destination. Two, the foreign decision was issued by a competent court and in accordance with the rules of fair trial. And lastly, the foreign decision does not conflict with the domestic law or is not contrary to a decision given by a domestic court. So those are the three considerations. With reference to judicial decisions, in this an author, G. De Haro defines enforcement as the right to the realization of substantive rights. The passage from the judicial rhetoric to the realization of the result actually expected by the litigant. Political enforcement refers to all the measures taken by the political authorities to give effect to a judicial decision. This may include legislative measures. When it comes to international decisions, they are recognized as such in view of their legal recognition in the instruments creating the bodies that handed them down. For example, the decisions of the African Court are international by the very fact of the provisions of the protocol establishing the court. Firstly, the decisions of the court are binding and therefore enforceable inherently. This is clear from the protocol establishing the court. Precisely Article 28 of which provides, and I quote, the judgment of the court shall be final and not subject to appeal. Petition closes. The binding nature of the African Court's decision is expressly confirmed in Article 30 of the same protocol, which provides that states undertake to abide by the decisions rendered by the court. Secondly, the decision of the court are enforceable as provided for in Article 30 of the protocol, which stipulates that the states undertake to ensure the enforcement of the said decisions within the time limit fixed by the court. That is why most of our decisions, you find that we do under monitoring and implementation, we disclose and we state clearly the time limit. Finally, the same decisions may be subject to enforcement procedures that are independent and separate from those applicable to foreign decisions. Read together with Article 30, Article 29, Sub 2 of the protocol provides that decisions shall be transmitted to the Executive Council of the AAU, the African Union, which shall monitor their execution on behalf of the Assembly of Heads of State and Government. It is clear from these considerations that the decisions of the court, African court, are international and are enforced through a political process. Further, as per practice, decisions of the court are transmitted to the representatives of the state that participated in the proceedings in the court, whose decisions are to be enforced. That is the respondent state. As a matter of principle, such decisions are further forwarded to the Ministry of Foreign Affairs, which in turn forwards them to the Ministry of Justice. In any event, it is the executive branch representing the state in international proceedings, including before the African Human Rights Court, which transmits the decision to the competent national bodies. That is to say, we transmit and we expect the executive arm to in turn transmit to the relevant competent national body or agency. And it's their responsibility to ensure that the internal agencies are duly instructed and that necessary procedures for enforcement are initiated. The issue of the recognition and enforcement of international decisions has been unequivocally settled in international law. The International Court of Justice ruled on this issue, among others, in the case of Germany versus the United States of America, also known as the Lagrand case. Having clarified the issue of the nature or legal status of the African Court on Human and People's Rights decisions, it is worth now delving into recent developments regarding the procedures or mechanisms of enforcement of these decisions. That takes me to the second pillar of this paper, which is the mechanism for the implementation of the decisions of the African Court on Human and People's Rights, our experiences and challenges. Political implementation and emerging approaches to compliance monitoring are the main aspects of this discussion. And our first question is, should states that do not comply with the court's judicial decisions be mentioned in our annual activity report? Recall that the protocol requires us to submit an annual activity report whereby we mention the status of compliance with our decisions. And that particularly is Article 31 of the protocol, which states that the court shall submit to each regular session of the assembly a report on its work during the previous year. The report shall specify in particular the cases in which a state has not complied with the court's judgment. Before 2018, and in accordance with this provision of the protocol, the court expressly used to indicate in its report to the assembly the states that had not complied with its decisions. The AU Executive Council took note of this and reflected same in its decision examining the court's activity report. So it was just noted. However, from 2018 onwards, the Executive Council of the AU objected to the court mentioning states that have failed to comply or failed to implement decisions, and Council resolved to remove the reference from its own decision as well. For its part, the court has retained the same reference in its activity reports in accordance with Article 31 of the protocol. This development poses a challenge to the court since Article 31 of the protocol leaves no doubt as to the obligation of all stakeholders, including the court and the states as well as the AU organs, to make specific reference to states that fail to implement the court's decision. This is a regressive trend given that Article 31 is part of the framework for the enforcement of the court's decision as envisaged by the AU member states that adopted the protocol establishing the courts. My second consideration is the question again, is compliance monitoring under Article 29 of the protocol establishing the court effective? Want to see how effective this provision is. Article 29 of the protocol, which gives the AU Executive Council the power to see the execution of the African Court on Human and People's Rights judgment, raises question about its effectiveness. It is clear that no monitoring mechanism has yet been set up by the Council, Executive Council within the African Union, thereby rendering Article 29, if we may say, ineffective. However, a framework for monitoring the execution of the African Court on Human and People's Rights judgment has since been awaiting adoption by the AU Executive Council. And this is pursuant to his own decision of January 2016 and same in June 2018, wherein the Executive Council requested the court to propose for consideration by the PRC, that is the Permanent Representative Council, a concrete, I'm quoting now what the decision says, a concrete reporting mechanism that will enable it to bring to the attention of the relevant political organs at any time situations of non-compliance with decisions and other matters within its mandate, when the interest of justice so require. Ladies and gentlemen, this is an opportunity for all stakeholders at this conference to advocate, to join us in advocating for the adoption of this legal framework, which is still pending, which we think will improve the enforcement of the court's judicial decision. The framework document on compliance monitoring awaiting adoption by the Executive Council largely reproduces existing monitoring practices. These are the political monitoring provided for in Article 29.2. We have not reinvented any wheel in Article 29.2 of the protocol, and the judicial monitoring provided for in Rule 81 of the Rules of Procedure of the Courts 2020. In addition, there's a diplomatic approach which provides for the involvement of all AU political organs from a progressive standpoint. The implementation and compliance monitoring framework also includes an approach of technical support to states in the implementation of decisions, which is in line with international law on international cooperation as a means of enforcing decisions of international human rights courts. The third question I want to look at is the emergency of a judicial approach to the implementation of judicial decisions of the African Court on Human and People's Rights. The compliance hearing. Following the adoption of the new rules of procedure of the court on the 25th of September 2022, the court has strengthened its implementation and compliance monitoring process. This is reflected in Rule 81 sub 3 of the rules, which provides, in case of a dispute as to compliance with its decisions, the court may, amongst others, hold a hearing to assess the status of implementation of its decision. At the end of the hearing, the court shall make a finding and, where necessary, issue an order to ensure compliance with its decision. This is the court helping itself. The court has already adopted guidelines for the holding of compliance hearings. Pending the holding of its first hearing, the participation of respondent states' focal points in how such hearings are organized can be discussed here. It is interesting in this regard to note that to date, we have 23 AU member states that have designated focal points, which can act as entering or contact points for states' participation in this hearing when they are held. It is also important to note that a number of applications for compliance hearing are currently pending before the courts following the Rule 81.3, having been lodged mainly by Pan-African Lawyers Union, that is PALU. The court will, of course, consider these applications in accordance with the procedures applicable before it. These applications obviously provide an opportunity to test the judicial mechanism for monitoring the enforcement of decisions introduced by Rule 81 of the Rules of Court in 2020. I'm beginning to wrap up now. The last is the administrative monitoring of the enforcement of decisions. How effective is it? This involves sending the states concerned a notice to submit a compliance report and sending regular reminders. Very few states submit a report on the implementation of the court's decision. One of the main challenges of this mechanism is the contestation of the administrative procedure for submitting compliance reports, and also the poor reporting by the respondent state concerned. In the absence of an implementation report, there is a possibility that states challenge the court's activity reports on the compliance with its decision. This can obviously weaken the compliance monitoring mechanism established by the state themselves, in particular through Articles 12, 29, and 31 of the protocol. This is therefore an issue that needs to be discussed here more extensively at this conference. Procedure for monitoring the implementation of the African Court on Human Rights, as I'm wrapping up, we want to consider 4 bodies that we think may help us in this regard, or stakeholders. We want to begin with the AU Executive Council. What is expected of Council? The adoption of the monitoring framework developed by the African Court on Human and People's Rights will be a remarkable step forward in improving the level of compliance with the African Court's judicial decision. So we urge Council, and I believe this conference will join us to urge Council to adopt that framework that is pending before the PRC. With regard to the African Commission on Human and People's Rights, this is our sister body and also a major stakeholder in this fight for the protection of human rights across the continent. That is the Banjul Commission. What can the Commission do? The Commission could use its promotion mandate to try to improve the execution of the court's judgment, either through advocacy or by encouraging states to execute the court's judgment. PAP. What role can PAP play? PAP is the Pan-African Parliament. The Pan-African Parliament could also adopt legislative measures to call on states to respect the judicial decisions of the African Court. Next is the national human rights institutions. What role can they play in this regard? The African Court has signed a memorandum of understanding with the network of national human rights institutions. And I think this MOU was signed early this month. And one aspect of the cooperation relates to monitoring the enforcement of the court's judicial decision. This is an avenue to be consolidated. As regards the national focal points, the court's gateway to the states, they are the hope for monitoring. We also hope that they will also have a role to play in monitoring. The implementation of the framework documents governing relations with the focal points will be an asset. What is still needed is a real commitment on their parts. As I close this paper, I want to round up by saying, ultimately, that is after all said and done, improving the level of compliance with the decisions of the African Court on Human and People's Rights, judicial decisions, requires a collective effort. Everyone should take ownership of the mandate to protect human rights and therefore take ownership of the challenges. Before I leave, just permit me to share with us some statistics on the level of compliance with our judgment so far. As at today is 21. I can say as at today, 2024, although this statistics is based on 9th of June, 2024, we have the statistics on the execution of the court judgment as follows. Total implementation, 2. And that is in the case of, that is in application number 013/2011. And the substance of that application was rightful claimants by the family of Norbert Zongo and others, and the respondent state Burkina Faso. The judgment was delivered on the 28th of March 2014 on merits, and on the 5th of June 2015 on reparation. What were the measures ordered? The respondent state was ordered to pay 25 million CF to each of the spouses and their children and daughters, as well, certain amount of money. And then also there was a call for more investigation with the view to prosecuting and trying those responsible for the murder of Norbert Zongo. What did the respondent state do? The respondent state paid the amount, and on the 30th of March 2015, the public prosecutor of Faso lodged a request with the investigating judge to reopen the proceedings in Norbert Zongo case. This request was granted on the 8th of April 2015, and in December 2015, 3 soldiers were arrested as suspects in the murder of Zongo and his companion. On the 28th of November 2016, the respondent state published the court judgment as we ordered in its official journal and in one of the daily newspaper. And in July 2017, the respondent state also indicated that the summary of the judgment has been published on its official website. This is what we like, and in the promotion of human rights. Then also we have another case, the Issa Koneto versus Burkina Faso as well, judgment of the 5th of December 2014 on merits, and 3rd June 2016 on reparation. The measures ordered were: 1, amend its legislation on defamation to make it compatible with Article 9 of the African Charter and Article 19 of the Covenant and Article 62, Article 19 of the ICCPRO, yes, and Article 62 sub 2C of the reversed ECOWAS Treaty. A, by repealing custodial sentences for acts of defamation, and B, by adopting its legislation to ensure that other sanctions for defamation comply with the criteria of necessity and proportionality in accordance with its obligations under the African Charter and other relevant international instruments. These are the measures taken by the respondent state, Burkina Faso. On the 11th of April 2018, the respondent state submitted a report detailing the measures taken to comply with the judgment. The report states, amongst others, that all the changes ordered by the court regarding the discriminalization of defamation have been implemented through the promulgation of law number 057/2015 and law number 058/2015 of 4th September 2015 on the legal regime for the written press in Burkina Faso. The official summary of the judgment was published in the official gazette on the 15th of November 2015. All payments were made as ordered, and the petitioner's criminal record was expunged. In addition, the certain amounts were also paid by way of compensation for non-material damage, that is non-pecuniary damage. So we have, that's all for total implementation as far as the report we have received is in the court. Then regarding partial implementation, we have numbered 6. One involving Côte d'Ivoire on our judgment on merit of the 18th of November 2016. The measures ordered were amend the law number 2015-335 of 18th June 2014 on the Independent Electoral Commission to bring it into line with the African Charter and other human rights instruments, of which the respondent state is a party or a signatory. Measures taken. On the 28th of August 2019, the registry of the court received an email sent on behalf of the respondent state, in which the respondent state explained that following public consultation, it had adopted a new law amending the composition of the electoral management body. On the 19th of November 2019, the applicant filed a report stating that although the law had been reversed to include non-governmental membership, it had not sufficiently addressed the issue of the impartiality of the Electoral Commission. So the applicant is not fully satisfied. They also consider that the process of reversing the law has not been inclusive. Another partly implemented in this decision is that of 044/2019, which is on Subi Gohore versus the Republic of Cote d'Ivoire, where judgment on merit and reparation of July 15, 2020. The others that were given by the court are take the necessary steps before any election to ensure that the new election to the Bureau, based on the new composition of the electoral body, are organized at local level. Also take the necessary measures before any election to ensure that the process of nomination of members of the electoral body by political parties, in particular opposition parties, as well as CSOs, is led by this entity, not by the state. On the basis of the determined criteria with the power to organize, consult, hold election if necessary, and the present required candidate, and then to report to the court on measures taken within 3 months from the date of notification of the judgment. The measures that were taken by the state so far, the respondent states that these entities already decide among themselves who to appoint. However, they have been asked to submit their own criteria to government so that the respondent state can formalize them. The respondent state also indicated that it will submit a further implementation report once this formalization process has been finalized. For the sake of time, I think this paper is with us. I will leave it with you for the purpose of your record and reference. There are many others, so time is against me now. But we want to say that we have observed that in some cases, though we have not received reports, we have observed that some state parties have actually implemented a certain portion of our judgments. And we get this information from the media sometimes, or from the Banjul Commission sometimes. For example, in the case involving Libya, though there was no formal report before the court, we observed that Gaddafi was freed following our decision, and that we equally noted. Then we also have the case of Ajavon involving Benin, where we ordered an amendment to their laws on establishment of CREATE, and the report reaching us, though not directly from the respondent state, is that was done. And so on. So we have that. We also thought we could share that with you, and also to urge states that when they do implement our decision, they are obliged to formally send the court a report to that effect. So, ladies and gentlemen, I hope I've not bored you with statistics, but I think those are just to inform us on what is going on within the court, and also to set the scene for discussion. So on that note, I want to again say thank you to you all for listening to us this morning. Asante sana, merci beaucoup, and enjoy the other parts of the session and the others, and even tomorrow. I hope we'll have a full house like this tomorrow, and we'll all be here and arrive at outcomes that will take us to the next level regarding the implementation of the decisions of the court. And I thank you.
Thank you so much, Justice Anukam. Indeed, when it comes to the implementation, it takes all of us, not just the judges, but every single one of us in this room and beyond. And now, takes us to the signing of the renewal of the Memorandum of Understanding between the African Court and the Center for Human Rights. Okay, I would like to call on Justice Modibo Sako, who's the Vice President earlier introduced of the African Court of Human and People's Rights, as well as Professor Nkata Murungi, who is also the Acting Director, Center for Human Rights, introduced earlier to actually sign the renewal of the MOU. While we go through the process, while we wait for them, please note that immediately after the signing of the renewal of the MOU, there will be a group photograph as well as tea break. Because we're running out of time, I'm hoping that we can stick to 10 minutes. It's quite short, but it's just to allow us to go through the day as fast as we can. For the group photo, there will be directions outside, but it will be on the grass, not outside of the hotel, but it's within the precincts of the hotel, but just right there. When you go past the restaurant on the grass, we'll be taking the photo. It's already been set. So I think now we can officially sign the renewal of the MOU. It is official. Thank you. Thank you. I think I'm saying it's official the third time. It's just to stress the importance of the renewal of the signing of the MOU between the African courts and the Center for Human Rights. On this note, I would like to usher us for tea break, but firstly, the group photo, as we call it, the family photo. If a picture wasn't taken, it never happened. So I think I would implore you all to please rise and go through the door, and there will be ushers there to usher you to the grass where we're going to be taking the pictures. Thank you so much. I would be out there in 10 minutes to ensure that everybody gets back in the room. So if you see my face, I'm only doing my job. Thank you. Hi, everyone. I'm hoping the people outside can hear me. If we don't finish the tea break now, we'll probably finish the session today at 7 p.m. And I don't think we want that, but let me see. Hi, everyone. Hi, everyone. Please, let's go back in. We don't want to finish today at 7 p.m. Please, let's go back in. Victor, I'm going to start calling names. Dr. Cristiano, come in so that we can finish on time. I don't want us to finish by 7 p.m. Yes, please come in with your tea and coffee. You can absolutely come in with your tea and coffee. Please come in with your tea and coffee. Let's start. Okay, we get started. We have to start building, so you know that. So let's just start. Oh, we're going to use the chair. Yeah, I'll do that now. I'll do that. So you want all the. Yes. And then with questions. Is there a microphone? Yeah, there'll be microphone. I don't know. There are microphones on the thing. You have to press it. On now. So I think it was like I'm not sure because I'll pass. Okay. Welcome back, everyone, from the tea break. I hope it was a good break after all of the opening pleasantries. I would like to start and go to the crux of the issue today, which is the panel session 1, assessing the influence of decisions of international human rights bodies, which is a conceptual discussion. For the chairperson of this session is Professor Rachel Murray, who's the Professor of International Human Rights Law at the University of Bristol. And she's also the director of its Human Rights Implementation Center. The next person, the panelist, is Dr. Tarisai Mutangi, who is the head of the Postgraduate Programs Faculty of Law, University of Zimbabwe. And today he will be discussing exploring the concept of political will and its impact on the implementation of decisions of the African Court on Human and People's Rights. The next person I'm calling needs no introduction, Professor Franz Vision, who's virtually, but he is the Professor of Law and the former Director of the Center of Human Rights, which is my alma mater. And then Professor Yare Fall, who is a Senegalese lawyer and president of the Senegalese section of Avocats Sans Frontières. He will be discussing the reflection on effectiveness and sovereignty, the necessary balance. Just to backstep a bit, Professor Franz Vision will be discussing enhancing the impact of the African Court decisions, the concept of embeddedness of African regional human rights norms. The last but not the least is Professor Clara Burbano Herrera, who is a professor of international human rights law at the Faculty of Law and Criminology of Ghent University, Belgium. And she will be discussing the symbolic impacts beyond compliance and analysis of the precautionary measures adopted to protect human rights defenders deprived of liberty in the Americas. I'm not sure if they're all here. I see Professor Murray is here. Please, you can come forward and come to the stage. Mr. Yare Fall and Professor Clara. Okay, everyone is here. Over to you, Professor Murray. You can want to be up here, whatever. But they are already the speakers there that you can use the microphones. Yeah.
Good morning, everybody. As just introduced, I'm Rachel Murray. I'm Professor of International Human Rights Law and the Director of the Human Rights Implementation Center at the University of Bristol. And thank you so much to the African Court and to the organisers. And I'm really honoured to be chairing this session. So as just briefly mentioned, we're going to kick off with looking at some underpinning concepts that lead to the sort of failure or success of implementation. I'm going to introduce each of the speakers. They'll give their presentations, and then we'll have a response from the court and then questions to the floor. So I understand that Professor Franz Vision wants to speak first and is online. Is that correct? Just waiting to see if there's a connection.
Yes, please. Rachel and audience, that would be very kind. Should I just start? Thank you so much for the opportunity. And I will try to share the screen and work from there. So Thank you very much for the opportunity, and apologies to be disruptive of perhaps the sequence. And, I'm here in Bishkek in Central Asia, and I hope everything will go fine. But if I drop off, hopefully that will not be too soon. So as you see, my talk is about embeddedness as a concept. And I suppose in the ordinary sense of the word, embeddedness would suggest some form of an intimate or a very comfortable relationship. Here, the relationship is between the international and the national, and how the international is then located within the national. And this is really the focus on embeddedness is part of a recognition that the primary obligation to perform human rights obligations lies with the state. So the idea that the state must be given the fullest opportunity and support to ensure that these rights are realized is at the heart of this contention. So the idea is that impact and effectiveness of international human rights will be enhanced with a greater embeddedness. And that leads to greater legitimacy and strengthening the authority of the court ultimately. So examples of embeddedness would be in a constitutional sense if the treaty would be given a status of an integral part of national law. And also, and this is the focus of my presentation, if national courts would actually decide cases and give remedies in line with treaties and also the jurisprudence of the treaty body. So we are making the contention that the embeddedness that we're looking at is the decisions by national courts that follow not only the African Charter, but also the jurisprudence of the African court in this particular instance. Now, as far as remedies are concerned, the African court, as we know, gives remedies that are quite individualistic, focused, and then also remedies that are much more systemic and communal in their ambition. Structural or root causes are being addressed by those remedies. These are called I suppose, the guarantees of non-repetition. And my contention is that it is particularly the guarantees of non-repetition, if applied by national courts, that can lead to the greatest impact of the court's decisions and of the African Charter system at the domestic level. And in terms of the ways in which the court has given effect to these guarantees of non-repetition, basically there are different manifestations. Some of them are training programs that need to be undertaken, but the main has been constitutional and legislative measures that needed to be adopted by the state. And if we look at the numerous legislative and constitutional measures, we can categorize them into those in the political domain. For example, the famous one in Tequila and Tanzania, where there is a call for the change of the constitutional legislative measures in Tanzania to allow for independent candidates in elections. And then APDH and Cote d'Ivoire, the direction from the court that the state should amend its laws to ensure a much broader and independent electoral commission. There are many other examples that I'm listing here, as you can see. In the other domain that is quite dominant in terms of these guarantees of non-repetition, we find in the criminal justice domain, for example, the famous Konate case dealing with criminal defamation law, that custodial sentences in that context should be rectified. And then we also have a number of cases dealing with legal assistance in Tanzania, that the law had to be changed in order to make it clear that accused in serious cases are entitled to free legal representation as a matter of course, and other examples. But sometimes we see that these constitutional legislative measures that are required can be quite broad. If we look at the Lido case, Cote d'Ivoire, the hazardous waste case, we can see that among others, the court orders that the respondent state must provide for its laws to ensure that corporate entities, including many multinationals, are also, going to be held accountable for the hazardous and toxic waste being expelled. We also have, for example, in the Ogiek case, the constitutional legislative measure that is wide-reaching in terms of the rights of the Ogiek that need to be recognized, recognition of the indigenous people's rights, which is quite comprehensive. The first measure then, in terms of how we usually look at the questions of impact and implementation, would be to say, but at the very least, in respect of those 4 states against whom those remedies were directed, had those states, implemented these guarantees of non-repetition. Now, there are all these cases, and usually we have 4 success stories that we can show that there has been such effect being given at the domestic level. The Konate case, we see that there's a report in the 2018 activity report that shows the state has complied with the measure as prescribed. The case against Cote d'Ivoire about the independent electoral commissions, the fact that there was an amended law actually led to another case, the Bigahore case, where the issue was whether the new law was actually in accordance with what the court required. And then we find the Wangwe case against Tanzania in another case dealing with the issue of independence of electoral mechanisms. And interestingly here, we see that the case that was initially directed against Cote d'Ivoire now becomes also relevant in the decision that the court makes in respect of another state, namely Tanzania. We also then have the free legal assistance cases, starting with Onyango, Tanzania, and then most recently Swaga in Tanzania, where we see that the Legal Aid Act of 2017 was enacted to allow for the introduction of such free legal assistance. But in the 2023 case, the court found that that was still falling short because it was not allowed as a matter of course. Interestingly enough, I mean, side effects and maybe going beyond what the court required, we also see that a system of paralegals was introduced in the Legal Aid Act, which was beyond what was technically required. And then the Ajavon case with the Economic Crimes and Terrorism Court in Benin, where the court quotes in its 2021 activity report media that had shown that that has been complied with. That is when the case is directed to a specific state and the state implements what was required. But the more interesting question is, what about other states? What about states that are not party to the dispute? Now, we know Article 30 of the court protocol determines that the states undertake to comply with the decisions against them, to which they are state party. And that is the obligation under the protocol. But people have looked at this idea of the decision of the court settling the interpretation of a particular matter, the so-called res interpretata. Scholars, also Professor Murray's students have dealt with these issues. And the contention is then that the court's interpretation, at the very least, can be used as a form of very highly persuasive authority in respect of other states. Why? Because of the logic involved. If the court follows a system of precedent, which it does not formally follow, but to a great extent, we see that the court does have a consistent jurisprudence, then one wants to preempt or prevent needless litigation, because if the court had decided a particular matter in one way, the likelihood of the court deciding a similar matter, even if it's involving another state, is very, very great. So this idea of res interpretata would say that the matter has been interpreted. This applies to all states. They should, at the domestic level, in the adherence to the principle of embeddedness, they should take measures through the courts and through the legislature to ensure that the domestic law is aligned with the interpretations of the court. From a legal basis, we can also say that Article 1 of the African Charter, which calls on states to adopt legislative and other measures, that also gives a legal basis. And we can read this together with the Vienna Convention on the Law of Treaties, Article 26, Article 27, which I think people are familiar with. So this is then an argument that we could see a broader effect. And here we talk about impact as opposed to implementation, because it is the influence of the African Charter and the court's judgments rather than the direct implementation. We should also look at advisory opinions. Advisory opinions, by their very nature, actually give directions to the member states and the state parties to enact laws in line with what the advisory opinion sets out. I mean, some of them that deal with this particular issue. We have the vagrancy advisory opinion of 2020, for example, that clearly calls on the states to review and amend their legislation in line with the principles that are set out in this opinion. And it reiterates that the state parties to the Charter have a positive obligation to repeal and amend the laws that deal with vagrancy in their jurisdiction. So this clearly is an advisory opinion, but its effect is certainly, in a sense, erga omnes to all the states parties to the African Charter. The court also makes the point that it's not only the state parties to the Charter, but all AU member states that should be taking into account the jurisprudence of the court in advisory opinions. Why? Because all AU member states are entitled to bring requests for advisory opinions. So in that sense, there's a broader and even broader potential for impact. We have a very clear example, in this case of State versus Henry Banda, Malawi 2022, where we see how the High Court in Malawi uses this advisory opinion in a decision. I can just highlight there on the slide. The court is in agreement with the African Court's advisory opinion position, and it elaborates at quite some length. And it, in the end, does not decide specifically that the laws are against the African Charter or unconstitutional because of technical reasons, but it strongly suggests to the executive and the legislature to review the said provisions. So we see that already there are fledgling signs and trends towards these kind of embeddedness by domestic courts. So we can also identify the measures that can be replicated, because once we have seen, okay, these are all the contentious measures that need to be taken by states in terms of legislative reform, these are all the advisory opinions. In a sense, my contention is that one should make some form of a compilation, an analytical compilation. All the guarantees of non-repetition are not replicable. It will depend on whether there are issues that are relevant in other states, and also some of these guarantees for non-repetition might be very specific and to unique circumstances. But from those, we can also extrapolate broader understandings of this term. So the experience also shows that there are examples of African courts already doing exactly what we are saying here. We have seen, for example, that the Konate case, which we refer to, that guarantee of non-repetition was basically influential in 3 courts at least, Kenya, Lesotho, and Malawi, in dealing with issues of criminal defamation. These courts referred to the Konate case and basically gave it persuasive authority in order for the domestic law to be interpreted, not only in the light of the Charter, but in the light specifically of how the African court had decided the issue. We also see that in Tequila, even though it was never implemented in Tanzania, we see that it becomes influential in another country, South Africa, with the Constitutional Court in the new Nation Party deciding, that the law is unconstitutional based, among others, on reference to the Tequila case. However, the idea that we can solve the issue of embeddedness by waiting for litigation to come before the national courts, I think clearly is problematic. If we are saying that the impact of the court's judgments can be increased through this process of litigation before African courts, we are saying that it is in a very reactive way, very unpredictable way, and a way that is quite limited in scope, that the process of this res interpretata being applied at the domestic level in Africa will occur. Because the conditions for the wider application, that is the application of the court's judgments to third parties, third states, would be that there must be a similar rule in the municipal law of that state, first of all. There must, secondly, be domestic litigation on the compatibility of this law. That, in other words, assumes that there is a litigant, maybe there's a complainant, and there's capacity to bring this case. And that in itself is also quite unpredictable. There must be an awareness and an understanding by the litigant of the court's jurisprudence in order for the case before the domestic courts to actually be based on the court's judgment. And then there must be competence and receptivity of the domestic court. In other words, there must be knowledge and also a preparedness to rely on the African court's judgments. And there must, in many instances, also be a collaborative relationship between the national legislature and the judiciary. So the existing African jurisprudence now applied beyond the dispute cannot depend only on cases incrementally, haphazardly being brought to the national jurisdictions. We need an intervention from national legislatures that we will basically have this idea that by creating the law in place at the national level, we would preempt to a great extent the litigation at the international level. And this will require some form of a review, analytical, compilatory review of the court's case law on the guarantees of non-repetition by national parliaments. So national parliaments, in essence, as we've seen in the Council of Europe happening, they are to do these reviews of how does the court's jurisprudence impact on our legislative agenda. And the role players that need to take part in this process would obviously, for example, be the Assembly, which can recommend the adoption of national laws and the recommendation of a practice by national parliaments in this regard. The African Court, through its compilations, through its contacts, should be influential in providing technical expertise in bringing this analytical survey together. The African Commission obviously has done so before and can contribute by development of software instruments. The African Commission on International Law, I thought that is an interesting aspect where the AEU-CIL could actually make a big difference. If you look at the Cote d'Ivoire case with the hazardous waste, then the Ogier case about indigenous peoples, that we could find that the studies could be undertaken. That's exactly why the AEU Law Commission is there. And that could feed into what is done at national level in terms of legislation and also at the Pan-African Parliament. At the PAP, we can have the development of model laws. So there should be a continuous scrutiny and conversation between the Pan-African Parliament and the African Court's jurisprudence in order to advise national parliaments going forward. But the issue is, in many instances, there is no jurisprudence by the African Court. The court is relatively limited in its jurisprudence. And what happens if a national court now is faced with an interpretation, but there is only the African Charter and not any decision by the African Court? So in this regard, it is, I suppose, possible for an advisory opinion on the meaning of a particular rights content to be referred to the court, but that needs to be done by a state party, an AU organ, or an African organization. But if the matter arises from the contentious case before a national court, we could, I think, see, and I'm suggesting we think about the possibility of the national court, which is now faced with a case in which the African Charter needs to be interpreted, but there is no guidance by the court. The African Court should then, perhaps the national court should be under Article 4.1 of the Court Protocol, be seen as a constituent part of the member state. Member states can refer cases to the court for advisory opinions. And in my contention, we should consider this to potentially include the judiciary as part of the member state. Others have also intimated that this could be possible, but there may be issues around independence and how the referral by the court in the name of the state may affect its independence. So the alternative to that possibility would be that there should be eventually some form of formal recognition that national courts can request advisory opinions. We have in the European system, Protocol 16 to the European Convention that allows a request related to matters of principle to be referred to the Grand Chamber of the European Court. So the proceedings in the national arena are stayed, and then the European Court then gives an interpretation that is used. That obviously facilitates a kind of interactive dialogue between the national and the international, and it reinforces the implementation of the convention, the theory goes, because it is in line with the principle of subsidiarity. We see on this slide a few examples of how in recent years, a number of courts in Europe had asked the European Court for such guidance in interpreting specific aspects. So I just here, and I'm going to skip this slide, I'm just saying that we are not saying that we are suggesting that conventionality control as understood in the inter-American system should be followed here. I think for reasons that perhaps could be explained at a different stage. So I conclude just by saying that there are constraints and opportunities to enhance this form of embeddedness that I'm advocating for. We can obviously look at legal factors and look at the need to have some constitutional provision that will allow for an integral part of international law to national. That would be the ideal. And obviously, we would also want to see that international law has a status, at the very least, that is equal with constitutions. It's an impediment in a country like Rwanda, clearly, because the hierarchy of laws is set out in that provision of the Rwanda Constitution. As you can see, the third layer of this hierarchy is referring to treaties and agreements. So constitution and organic law are superior to that. So I think that is a long-term issue that needs to be resolved through legislative reform. I think on the shorter term, we could look at extra legal ways of enhancing this idea of embeddedness, and very briefly to look at the importance of the dissemination of the court's jurisprudence. It just is not yet accessible to enough people. So especially national judges should be very, very clear about how they can access the court's jurisprudence, and then the development of some form of a tool that consistently tracks and analyzes the relevant guarantees of non-repetition. We have, for example, fact sheets in the Council of Europe, in the system, where rights are dissected and explained. That is a starting point, but we're talking here about something more comprehensive. Awareness raising, education, information. And I think judicial dialogue, we have these judicial dialogues, fora that the court organizes, but it is important that these should not just be high-level diplomatic engagements, but really become intensive working sessions where the judges at the national level seriously engage with the detail and the intricacies of the African court's jurisprudence and look at how that can be made applicable. And then obviously, if we want to see this form of a dialogue being institutionalized between the courts, the national courts and the African court, lobbying for some form of reform of the court protocol. Thank you very much. I'm not sure if I'm still audible. Yeah, I'm a little bit lost here, but I hope that was what I had to say. Thank you.
Reflection. that have been produced so far, the strategies that have been suggested over the years, have we pointed our strategies far enough to the ultimate actor of implementation with the state? It has been said already by earlier speakers that no one else implements court decisions but state parties. That is a fact. What we can only do as stakeholders is to seek to participate in that process and try to influence that process one way or the other, probably through monitoring and reporting. So my question is, how much do we know about state behavior as far as implementation is concerned? How much of the state behavior do we know? Hence, I'm talking about a concept called political will. Even the Director of Ceremonies, in a very first statement, she made reference to political will. And Justice Anukam, in a very revealing presentation setting the scene, I even saw it in the strategic plan of the court, that much as we can adopt these strategies as a court to seek to improve implementation, ultimately the decision lies with the willingness of member states to implement those decisions. She made reference to Burkina Faso as having fully complied or fully implemented decisions of the court, and there are only two. How much of that state behavior do we know? What were the reasons behind Burkina Faso behaving in the manner it did? If we see no action on implementation, we say there's no political will. The question is, what is political will? What is the purpose of political will? And how do we define political will? With the time that I have, I'll not spend much of the time trying to define political will. But at least I'll explain why should you focus on political will. I know as lawyers, most of us here have got legal training. This may sound to be a foreign discipline because political will and discussions are all founded in political theory or political philosophy. But if we claim that human rights are more disciplinary, why can we not bring that multidisciplinary nature of human rights to implementation and seek to understand, state behavior? But the question is, where is the level of political will? Is it at the national level? Is it at the regional level? Earlier speakers have already spoken about that. They've spoken about policy organs of the African Union and the role they play. So for me, the entire program from today and tomorrow is talking about the political will. If you are talking about national focal points, what is their role? Is to influence implementation. By who? By the state party concerned. Mobilization of political will. So the rendering of the decision of the court is a legal process, but its implementation is political. Whether it's payment of money is political. Someone has to make a decision. Let's comply with this decision. But what is political will? My exploration, as you can hear, the way I'm speaking from an explorator's view. My exploration in political theory and political philosophy is that it is not present. When we see no action in implementation of decision of the court, we say there is no political will. It's like oxygen. You start worrying about it when you're choking, when you're gasping for breath. When it's there, no one talks about oxygen. We've been breathing since morning, no one talks about it. But the moment you start to gasp for breath, then you realize there's something called oxygen. It's not present in this situation. Why did we not conduct a case study of Burkina Faso relating to the decisions that were fully implemented and say, what were the dynamics, what were the reasons behind this behavior? Because as well as you might think that the mere fact that a judgment is binding, you think that's good enough. It is not. Are the court judgments, hundreds of them, not binding? Do states don't know that those decisions are binding? They know. But why are they not implementing those decisions? What are the reasons behind that non-implementation? So my recommendation today, if I run out of time, as I know I will, but I hope the moderator will have some political will to allow me to, a little bit of time to finalize my argument, is to say our strategies cannot continue to hover around legal issues. I'm looking there at two publications. One is the de jure publication committed to dealing with status of implementation of decisions, not only of the African Court, but of other sub-regional courts. The other publication there is called Human Rights Adjudication Africa. It also reveals the reasons of why, number one, status of implementation. Number two, why there is no implementation. And several reasons are given. But my view is that we do not go further enough to interrogate. If the court rendered a decision to say there must be a constitutional review to allow independent candidates to participate, why is it that there is no movement or that implementation has not been fully implemented? So when I talk about political will, this is a summary. We are talking about the commitment that is within political actors to support a particular policy outcome. The commitment within political actors in any country, which is the respondent state, to implement the decision of the court. But it's complex. How do we know? So that gets us to analysis. How do you analyze in a political will? How do you know it is present? How do you know it is not present? It's not an easy thing. Probably we need to collaborate with scholars from political science for us to move together and get to a position where we know the reasons behind non-implementation and also understand state behavior affecting non-implementation. When African member states ratified the African Charter, we said there's political will. When they ratified the Court Protocol, we said there's political will. When those who ratified did not depose the declaration, we said there is no political will to depose the declaration. And those that depose the declaration, we said there's political will. And those who withdrew, we said there is no political will now. So how do we define this amorphous concept called political will? Seems to be changing. So others think that there's a political will for each decision. Same country, each decision. It has got its own political dynamics. But they say, you must look at these political actors and try to understand the incentives or disincentives that come with implementing a court decision. They also say elsewhere, politicians never give anything for free. The first question is, what is in it for me? That's a political actor. If we implement this decision, an election is coming, what are the implications? Are the people with us or they are against us because of implementing this decision or acting in this manner? That's a behavior of a particular actor. So we're looking at incentives. Not only that, there are also incentives and disincentives, or the political cost of those who support implementation or who support non-implementation, depending on whichever is convenient. Whichever supports the incentives of a political actor, probably that's why we see implementation taking those different trends. How about it political will at the level of African Union policy organs. It's another level of political will. They are gathered in a room like this, and they say remove reference to state parties that have not complied. Is it a sign of existence or non-existence of political will? The adoption of the framework. The decision itself would say it is presence of political will. But the indefinite absence of a decision to adopt or to reject the framework as proposed by the court, what do we say about political will? But another question is, do we know who yields power in any particular situation? They call it applied political economy analysis. It's there even in the home. Children, they conduct their own political analysis. If they want some gifts from the father, and they know he's a strict man, they go through the mother. They know who uses power. They know she can influence the release of those goodies to us as children. It's a basic thing. Development agencies out there, when they implement their decisions, they don't just implement. They conduct political economy analysis. Who yields power in a particular situation? Who is blocking this? Who will support this and target those influencers? Do we know, in respect of each judgment rendered by the court, do we know who yields power in its implementation? Do we know the influences? Or we think if we speak to the president, it's good enough. But do we know the interest he or she holds in relation to the implementation of a particular decision? Who yields power? Are we talking to the right people? In our strategies, are we talking to the right people? So, but let us not confuse political will or its absence and also inability or incapacity. There are cases in which the state party does not have capacity to implement a decision. They are there. But there are also cases where we know this can be implemented, but there is no movement. So if I was a legal officer, talking to the bureau to explain to them why there is no implementation of that decision by this state, the bureau will ask the question, was there implementation? And they say no. They will ask why, and they say there's no political will. And should ask a further question. Why is there no political will? In other words, it is not good enough for us to dismiss non-implementation by simply saying there's no political will, when we have not taken any specific action to better understand state behavior in respect of each and particular decision of the court. So for me, I don't think I'm going to present a paper for publication. As you can see, I'm exploring political philosophy. I'm exploring a concept that we do not define clearly, but we explain our political reality through political will. So in conclusion, I have 1 minute. I saw indication 1 minute. In conclusion, you could see that easy or clear indicators of political will include public declarations by senior government officials. We are not going to comply with the decision. It's a public declaration, maybe the easiest one. And if they make a declaration and there's no action to implement the decision, therefore we should say there is no political will. Or there's no passage of national legislation to facilitate implementation, in spite of clarion calls to that effect. There would be other indicators, but we must formulate those indicators within political theory to better understand state behavior. Because they say political will is present when a political actor is willing to commit precious time, energy, allocate funds, and political capital to achieve specified change. In this regard, the implementation of a decision, and is prepared to take risks and to incur opportunity costs to that end. we can safely conclude that such an actor is exhibiting evidence of the existence of political will. I conclude again. We have stayed for too long at this mountain. We have already revealed the reasons of non-implementation through literature. We know the status of non-implementation. Let's take the next step. Let's engage the primary implementer to try and understand state behavior. Let's make case studies of those countries who are champions of implementation. The other ones, I don't know what to call them, but they are definitely not champions. Those are not implementing. They have a different name for themselves. But nevertheless, we also need to understand state behavior, state actors international. That is why we have national actors who interact with these actors at the national level, at the individual level. We can understand state behavior and accordingly strategize with more impact. Thank you very much.
Thank you so much, Dr. Tarasai, for pushing us all to actually look at this concept of political will, which I think is often attributed as an inability to do anything or attributed to success of implementation without actually pulling apart what it actually means and that it's incredibly complex. So thank you again for your insightful presentation. So our next speaker is Mr. Yare Fall, who is a lawyer registered with the Senegalese Bar and is president of the Senegalese section of Avocats Sans Frontières. So over to you.
Merci.
Thank you very much, Madam Moderator. Vice President of the Court, dear judges, dear colleagues, dear delegates, good morning. It's clear from the program of our work that the aim of this conference is to create a platform for intellectual engagement between stakeholders of the African Court on Human and People's Rights on improving respect and implementation of the court's decisions and rulings. I have to admit that as soon as I received this program, my attention was quickly drawn to the first subject, which was eventually assigned to me and which is entitled, I would like to cite this, assessing the influence of decisions by international human rights bodies, a conceptual discussion, and of the citation. What a clever plan this is. Indeed, the first step towards understanding the issue seems first and foremost to identify the concepts surrounding this. As someone once said, I don't want to know the answers. I try to understand the questions. The issue that seems to arise in this subject is that of the effectiveness of the international legal instruments with regard to the state's sovereignty. We can all agree that the personification of the state is its sovereignty. There can be no state without sovereignty. But we must also recognize that international legal instruments which are the guarantee of world peace and justice, and whose implementation has cost millions, if not billions of dollars, it can only be theoretical rather, and ineffective. This is a waste that we Africans cannot afford ourselves. In the interest of intelligibility and clarity, and for the sole purpose of submitting the results of my reflections to your esteemed attention, taking care also to remain within the framework of our discussions, I've taken the liberty of rewarding the subject in the following terms: effectiveness and sovereignty. How do we make the necessary balance? The British American philosopher Aldous Huxley once said, the fact that men learn little from the lessons of history is the most important lesson that history teaches us. End of quote. Now, inspired by this maxim, which is full of equity and wisdom, and to illustrate our point, we think it might not be a bad idea to give a brief historical overview of the genesis of international legal instruments, which are the final analysis, no more than the result of the evolution of the world. Indeed, how many wars, how many human lives have been lost, how many acts of the most despicable barbarity took place before the international community realized that recognition of inherent dignity of the inalienable rights of all members of the human family is the foundation of freedom and peace in the world. The trigger was actually the Second World War, with its 50 million deaths, which traumatized the whole world. But it was above all Europe, then the world's great power, that paid the heaviest price. The loss of life was dramatic, and the discovery of the atrocities perpetrated by the Nazi regime shook people to the core. Many European economies were in ruin. Many industrial and agricultural infrastructure were destroyed. Entire towns were razed to the ground by bombing. Communication infrastructure was damaged, and food shortages were widespread. It was during this period, moreover, that most of the international legal instruments of a generic nature were adopted under the aegis of the United Nations, with the basic slogan, never again. The Universal Declaration of the Human Rights, adopted on the 10th of December 1948, which develops the humanist principles proclaimed in the preamble of the Charter of the United Nations, marks the first stage in a process that led to what we can, or rather what can now be described as the international legal order. And under the impetus of the commentators and other legal experts, based on the fact that human beings are not only universally, but also indissociable, the two conventions, or rather covenants on the civil and political rights, and economic and social and cultural rights are followed, giving rise to new concepts. This is how the advocacy of feminist movement led to the emergence of the notion that human rights, we need to talk of human rights. When we talk of human rights, we need also to talk about the rights of women. And we had the demons of the past, which started to resurface, first with the Cold War, then with the decolonization movement. the economic collapse of Europe gave rise to two new superpowers on the international scene. We're talking about the US and the Soviet Union that divided the world into two ideological spheres during this period that we call the Cold War. Even if the two great powers were not in direct confrontation, on several occasions, they brought the world to the brink of atomic war. Fortunately, this Cold War came to an end in 1989 with the destruction of the Berlin Wall and the collapse of the communist regimes in Eastern Europe. In between, we had decolonization movement known as the Independence Sun, and then the Vietnam War, which seriously challenged the hegemony of the Western powers. This geopolitical and geostrategic development was accompanied by the emergence of the international scene of new states that are deeply attached to sovereignty, which for them constitutes the freedom already enshrined for individuals, with the idea that all the world states are of equal dignity, now accepted, but later exacerbated by the globalization. International and legal instruments started to proliferate in all areas alongside those with a universal vocation. Regional specific instruments also appeared. From a general conception, we effectively moved to the analytical conception, given the emergence of new ideologies and the quest for new freedoms. As for the regional proclamation, initially confined to Europe, it was later extended rather to the Americas, Africa, and to the Arab Islamic world. Today, only the Asian continent does not have a regional convention. In so doing, states voluntarily undertake through conventions to respect a certain number of legal obligations, the main purpose of which is to recognize the rights of their citizens. Thus, in addition to the normative affirmation of individual rights, and depending on the instrument, provisions is made for mechanisms that are more or less binding on states, the main purpose of which is to ensure that they comply with their treaty commitments. But while it's true that the international affirmation of rights and freedoms is one thing, guaranteeing respect for these rights is quite another. In the field of human rights, even more than elsewhere, the effectiveness of the guarantee of this particular guarantee depends on how to justify these rules. No international protection of human rights can seriously be implemented if it's not accompanied by appropriate legal mechanisms. Indeed, what is the point of adopting a legislation or setting up a monitoring mechanism if at the end of the day, breaches are not punished? This is where the issue of the effectiveness of international legal instruments comes is sovereignty. Yes, as already stated, there can be no state without sovereignty. Sovereignty is to the state what breath is to human beings. But at the same time, we might avoid going back to square one by sacrificing fundamental rights. We must be absolutely careful not to fall into the situation of the cautery on a wooden leg. The myth of Sisyphus is instructive in this particular respect. We need to go back to respecting the fundamental rights, but also we need to ensure that the primacy of the sovereignty is done through subsidiarity. Now, to come back to the subject of our discussion, which is the African Court of Human Rights, it should be noted that both the Charter and the Protocol establishing... Mr. Fogg, you have 2 minutes. Now, to come back to the African Court, we're talking about both the protocol and the charter, rather, the protocol establishing the court, reaffirm the commitment of the signatory states to the principles of human and people's rights and freedoms and duties contained in the declarations, conventions, and other instruments adopted by the Organization of African Unity. This simply means that our continent, with all geopolitical, geostrategic indicators, are at crossroads with the globalization unfolding before our eyes. And in this context, it should be noted that just as no human being is an island, no state or group of states can also live as an island. The irresistible globalization that is unfolding before our eyes, this is creating an international public space that is constantly expanding. The slightest incident occurring in any corner of the world becomes viral almost immediately. The era of independence has taken place of what I can call here, I'm in my house, I do what I want. This can never be applied. No state, however powerful, wants to be on the list of rogue states. We have experienced a period of instability in our countries, calling into question the very legitimacy of the courts and resulting from the criticism, which frankly does not stand up to any serious legal analysis. The court's critics have wrongly argued that it will hinder state administration, and yet simply entering into the international commitment is already part of that sovereignty. It is therefore not at all a surrender of sovereignty, as the Permanent Court of the International Justice rightly pointed out in its ruling on the 17th of August, 1943. Furthermore, the principle of the exertion of domestic... I'm sorry, Mr. Farr. You asked me to prepare a text of about 8,000 words. I spent a lot of time doing this. Kindly give me more time to finish my presentation. And we're talking about, with regard to the international, Mr. Fallon, 1 minute, but I think I've already sent you my speech, so kindly send it to our colleagues because you have interrupted me several times. Thank you.
Merci beaucoup, Monsieur Fall.
Thank you very much, Mr. Fall.
Interruptions. Everyone was asked to prepare papers, which we all have, and so they will be. There's a lot more depth to these presentations than I think you can give in a few minutes. Thank you so much for that discussion on the sort of historical context, which I think reminds us why sovereignty is so fiercely protected, and I think links very well with the discussion on political will that Dr. Tarasai mentioned. I'm conscious, I've been told we have to finish by 12:30, but we have one more speaker, and I don't want to cut her too short, and I also want to hear from the court as well if they need to respond. And we probably might not have chance for questions, but maybe if people keep the questions to the end of the next session, that might be the easiest way of doing it. So over to you, Clara, Professor Clara. Let me get it. Professor Clara is a professor at Ghent University.
Thank you, Rachel. I have a PowerPoint presentation. Good morning, everyone. My name is Clara Burbano Herrera. I am a professor of human rights and director of the program for studies on human rights in context at Ghent University. And it's my real pleasure to be here today. I would like to thank the organizers of this event for having invited me to this conference. And I appreciate the invitation very much, not only because the topic is relevant, but also because this is an academic event organized by African institutions in an African country, where the majority of the participants are Africans who are discussing African human rights issues. So being a Colombian scholar working in Europe and talking about the Inter-American human rights system is a little bit a challenge, but I would also like to add that I feel privileged and honored to be here with you all. I sincerely believe that this exchange of ideas and knowledge between scholars and experts from different continents from the global south is not only relevant, but also useful. It may help us to come closer together and understand our differences, but perhaps it will also allow us to see how much we have in common. Perhaps the human rights problems that we face in different regions and the ways in which international human rights bodies and academics deal with them can somehow inspire us to think and rethink the way how we analyze them. In this way, perhaps together we could rethink both in theory and in practice how to help close the gap between the formal recognition of human rights and the real enjoyment by all, especially those belonging to vulnerable groups, those who have been excluded from public policies from decades. As the title of my presentation suggests, the purpose of this brief presentation is to analyze the impact of the precautionary measures adopted by the Inter-American Commission of Human Rights for the protection of persons deprived of their liberty in Nicaragua. I will argue that in contexts where the rule of law is under attack, international human rights bodies, such as the Inter-American Commission of Human Rights, have an important role to play in protecting people at risk through the adoption of precautionary measures. I will also argue that despite little or not compliance of precautionary measures, especially in context of repressive regimes, the direct and symbolic impact of such measures is nonetheless significant. In that sense, I will divide this talk into three parts. In the first part, I will explain the scope of the key concept, precautionary measures. In the second part, I will describe the context in Nicaragua. I will show that the use of precautionary measures in this country is characterized for two factors. The first factor is that they are granted in a context where the rule of law and human rights are under attack, with a clear violation of the principle of separation of powers. The second factor is that the penal code is used by authorities to punish those who are critical of the state. I will explain that in this context, the Inter-American Commission of Human Rights has adopted precautionary measures to protect persons deprived of their liberty. Most of them are imprisoned because of their critical voice towards the state authorities. Finally, in the third part, I think I will not be able to elaborate. I want to explain the terms compliance and impact, and then I will propose an analysis of the impact of the precautionary measures at three levels, including the micro, the meso, and the macro level. Before I start, I would like to make two clarifications. The first one is when I talk about persons deprived of liberty, I mean under arrest, in detention, or in prison. And the second clarification, the ideas I am presenting here are the result of an article that I am co-writing with my colleague, Professor Ifhak, who unfortunately couldn't join us today. With regard to the first point, the scope of one key concept, precautionary measures. In the Inter-American human rights system, precautionary measures can be defined as an instrument that aim to prevent irreparable harm to persons who are in a situation of serious danger. In short, the function of precautionary measures is exclusively to protect persons at risk and to prevent human rights violations. Serious and urgent situations are clearly present when there is an imminent risk to the right to life, the personal integrity of the right to health of persons deprived of their liberty, involving, for example, risk of torture or serious danger arising from harsh conditions of detention. Precautionary measures do not prejudge the merits of the case, and they are not a declaration of the international responsibility of the state concerned. With regard to the point two, although declarations and documents of the Inter-American human rights system emphasize the importance of the rule of law and its close connection with democracy and human rights, it's a matter of concern that in some Latin American countries, there is a persistent tendency towards the establishment of authoritarian presidents. Mr. Daniel Ortega is the president of Nicaragua. He began his term in office in 2007. And today, after 4 consecutive elections for 5 years terms, the last one in 2022, remains in power. Since 2018, a repressive regime has been gradually implemented in Nicaragua. The repression has affected a diversity of people, including students, professors, political opponents, journalists, priests, and human rights defenders. In general, anyone who expresses his or her critical opinion towards the state authorities is at risk. Reports indicate that between 2018 and 2023, at least 2,000 people have been arbitrarily detained. 355 people were killed. More than 2,000 people were injured. More than 3,000 civil society organizations had their legal status revoked, and 12 universities were closed. In addition, Nicaragua denounced the Charter of the Organization of American States in November 2021. In this context of repression, violations of human rights, and attack to the rule of law, the Inter-American Commission has carried out several activities with the aim to protect persons at risk. For example, the Commission has held public hearings, organized country visits, issued press releases and reports, received petitions, sent diplomatic notes, requested provisional measures, and decided precautionary measures. The Commission has stated that while killings perpetrated by the state authorities represent the most serious form of violation of human rights and the rule of law, they are by no means the only one in Nicaragua. Other violations include arbitrary deprivation of liberty, attacks, disappearances, physical, psychological, and sexual violence, stigmatization, smear campaigns, criminalization, individual and collective threats. In this context of repression, the Inter-American Commission has adopted precautionary measures to protect persons deprived of liberty. Our research shows a significant difference in the number of precautionary measures adopted before and after 2018. The data shows that between 2010 and 2017, the Commission adopted a total of 4 precautionary measures, none of which were related to persons deprived of their liberty. In contrast, from 2018 until 2024, the Commission granted a total of 128. Of those, 47 were issued regarding individuals deprived of their liberty. Our findings indicate that a total of 166 persons deprived of their liberty have received protections through precautionary measures. The data set comprises 96 men, 44 women, 1 transgender woman, 5 anonymous individuals, and 20 families of people at risk. In the majority of the cases, the Inter-American Commission of Human Rights was protecting the right to life, personal integrity, health, and fair trial. The analysis of the precautionary measures adopted showed that persons deprived of the liberty face 3 types of danger. Most of them experienced a combination of all of 3 at the same time. The first type of cases concern issues related to the legal context. The precautionary measures granted show that persons deprived of the liberty were illegally detained, persecuted, and punished without a due process, without access to a lawyer for offenses related to conspiracy, anti-peace activities, drug trafficking, illegal carry-on of weapons, and common crimes. Some people were sentenced on the same day that they were arrested. Those who express dissent towards governmental policies are subjected to investigation and criminalization. Criminal law is used as a tool for control and repression. The second type of cases are related to the probable conditions of detention. The analysis shows that the situation of danger is linked to the lack of access to drink water, lack of access to food, overcrowding, lack of mattresses, and in general, inhuman treatment. The use of the solitary confinement and lack of access to hygiene products of women. The third type of cases are related to the right to health. Persons deprived of liberty who are ill, including the elderly, do not have access to the medicine or medical treatment they need. The authorities also denied relatives to provide medical support. It should be noted that some of the beneficiaries are over 60 years old. With regard to the third point, in order to assess the degree of compliance and impact.
So sorry, Clara, just two minutes. Sorry.
With regard to our third point, in order to assess the degree of compliance and impact of precautionary measures, it's necessary to begin by clarifying what is meant by compliance and impact in this presentation. I have to start by saying that compliance of a precautionary measure is not the same as its impact. Compliance is related to the action or actions that the state concerned takes to obey with the order given by the Inter-American Commission. For example, actions related to compliance could include the transfer of a sick detainee to a hospital, additional prison staff. The impact is related to the effects of the precautionary measure on the beneficiaries, direct impact, and on society at large, indirect or symbolic impact. The impact of the precautionary measures could be the recovery of sick detainees who have received adequate medical treatment, direct, or the increase of prison, or the decrease of prison overcrowding, indirect. It's not always the case that compliance generates a positive impact. A measure may be implemented, complied, but it may not achieve the desired effects. For instance, the state hires additional prison officials to control violence inside the prison, but they are not trained according with human rights standards. In fact, the new staff intend to control violence with more violence. Compliance or lack of compliance affects the beneficiary of a precautionary measure directly and most prominently. However, when a precautionary measure has effects beyond the beneficiary, we refer to indirect or symbolic impact. I will stop here. I wanted to explain the compliance and different kind of impact, but I think I am almost ready with the article with my colleague Ifhak. So if you want to know more about those terms and how we are applying specifically in relation to Nicaragua and persons deprived of liberty, you are very welcome to read it. So thank you very much. I'm sorry I was a little bit, I took a little bit more of my time. Thank you.
Thank you, Prof. Clara, just for some fascinating comparative perspectives and the focus on precautionary measures, which often gets less attention, I think, than other decisions. And the project is ongoing, so we look forward to hearing more. So I now just want to give, I know we're well over time. I was asked to finish at 12:30, but I want to just give space to the court if there are any comments at this stage. Yes, please.
Bonjour à tous.
Hello, everyone. Thank you to all the presenters. For their very serious and practical presentations, but of course, there are so many questions that remain unanswered. My question is the following. Do you think that for a national judge, taking into account decision of the African Court or any other institution, if their country has not implemented it, do you think it's easy for a national judge to do it, to refer to a decision that has not been implemented by its state, but because it's a decision that has protected certain principles? Thank you. Yeah, thank you. Yes.
Thank you very much. I have a little clarification to seek from Dr. Fariza Utaki. And the question has to do with understanding behavior. I would like him, if time permits, to throw more light on how and who should take up this responsibility, and how bringing it down, engage the primary non-compliant states, and how we go about finding out why they behave the way they do. Whose responsibility would that be, so that we can know the direction to go from this conference? Thank you.
Thank you. Can I just request from our organisers whether there is enough time to get response from the panel members? So I would just hand the floor back to our panel members for any responses, very, very quick responses before we finish. So anybody wishing to respond? I think there was a question directed at you, Dr. Tarasai, or do you... Please go ahead, Mr. Fall.
Yes, I would like to give my opinion on the question related to asked by the judge. National judges must, of course, take into the state is not the one to decide. And therefore, when a decision is given at the international level through ratification, of course, this decision is part of the positive national laws. Therefore, the national judge has no problem taking into account these decisions and applying it in the state as the case may be.
Thank you, Honorable Judge, for asking that question. And my quick response is that the want to act, the want to find out is based on our strong points as stakeholders in the implementation process. An academia can do that. Non-governmental organization can do that. Even in NHRI, when it monitors, what is it monitoring? Without telling us where there is a logjam in the process. What is it monitoring? It must be able to then inform us through its own reports or its own findings for us to know who is responsible for particular action, inaction or action. Then that then informs other stakeholders, including the court now. If the court were to do an implementation hearing, it has information, deeper information about what is happening on the ground. If it is engaging governments through a follow-up process or visits that you do to countries, it knows the dynamics that are happening on the ground. It doesn't have to be the court itself. I'm saying so because you also want to avoid some diplomatic discomforts that may come with why is the court zooming into us in this particular manner. That is why we are together. Others can do it. Share that information that informs each one of us strategies in terms of how we engage at our different levels with the national actors. I hope that answer is clear, Judge. Hopefully it is clear. Thank you.
Thank you, Doctor. Prof. Clara, do you want any comments? You don't want to come back on any comments? Okay, thank you. As suggested, because of our time limits. Everybody hold tight to any questions and comments that they have, and they can be picked up in the next session. And I was also asked to give a summary of what's been said. I don't suggest I do that. We've got lots of food for thought already. Got 2 minutes. I can give a summary, or it's better. It's okay. Okay. So I will try and just flag up a few key things from this morning's presentations. I think there are a couple of things. Firstly, issues around influence, impact, implementation. What do they all mean? I think sometimes the things are implemented where the courts had a role, but not necessarily a decisive one. And looking at all of those, what are known as compliance constituencies in the state, other actors who play a role in pushing compliance with these decisions. There are a number of points that came out about the reasons why implementation occurs or doesn't occur. Dr. Tarasai's eloquent presentation on political will as a concept that's frequently mentioned, but often nobody goes further in actually looking at what this actually means, and that it is complex. And political will as a term doesn't capture this complexity. I think it's been described as a slippery concept in various discussions. And whose will is this anyway? And breaking down the state and the different elements within the state to understand, I think that goes back to some of the questions that were just raised about how do we identify who is accountable, who's responsible, whose budget does this even come from, who has the capacity to be able to push what's required through, and looking at the range of players at the domestic level. And I think underpinning this is state sovereignty. Mr. Fall's presentation and the impact that has, hard-won sovereignty, and what that means when you've got decisions from outside of the country coming in. And then I think the presentations also flagged up, well, what do we do? What do we do about this? And Professor Frans Wielen's presentation had a whole host of different ways in which this can be embedded within the domestic system through the national courts, particularly focusing on guarantees of non-repetition, which are often seen as the most challenging to implement, and using a preemptive approach, looking at what comes from the African court and predicting that this will be an issue. And again, Dr. Tarasai reminds us not to look at just legal issues, but also the political actors and how we collaborate with those from political science, and looking at the political will, however we define that, for each decision, not just overall, where it becomes rather vague and opaque, in order to understand state behavior and not the state as a sort of homogenous entity, and identifying who has the power and the targeted approach that we can see. And then I think Professor Clara provides some really fascinating insights from another regional system where a lot of attention has been paid around implementation from both of those organs. And I think there are lots of lessons that we can learn from her research. So I am going to stop there. I just want to please ask you to join me in thanking the excellent panel for their presentations, as well as Professor Frans, who may still or not be here. So thank you. Thank you.
So it's just a bit of quick announcement. We have made a bit of changes to the program. As you can see, we are running a bit out of time. So please, our presenters for the next sessions should bear with us. Slight adjustment of 5 minutes here and there. We have discussed with the chair of each session, and they would inform you accordingly. And also for our lunch break as well, we will maybe a bit of concealment here and there, because we really don't want to keep us here till past 5:30. Thank you.
Thank you so much once again to the panelists and the chair for the last session, panel session 1. So we're going to move on now to panel session 2. As Felicia said, we're running out of time. So, Mr. Lloyd, I will be putting you on the spot. Hopefully, we're able to finish at exactly 1:30 so that we can actually proceed for our lunch break. It's been a long day, albeit we started early. So panel session 2 will be discussing the role of state focal points in the implementation of decisions of the African human rights, looking at the prospects and challenges. And what the session would do is highlight the implementation of decisions at the national level. The session will also discuss the prospects, the challenges, and areas of stakeholders' collaboration and support related to implementation. As we know, implementation cannot happen without, again, political will of the African Union member states. The chair for this session is Mr. Lloyd Kuveya, who is the Assistant Director for the Center for Human Rights, University of Pretoria. And then our panelists, Dameda Daniel Gills Antonio, who is the Technical Legal Advisor to the Minister of Justice and Legislation, the Republic of Benin. We have Ekwelinda Maheva Neriza Epps Menduga. I thought my name was long until I read out this name. She is the Deputy Director of Agreements, Treaties, and Monitoring of International Commitments, Ministry of Foreign Affairs, Cameroon. And then we have Mr. Matthews Gamadzi, who is the Senior Deputy Director, Assets Recovery, Malawi. And then last but not the least, we have Leongi Boke-Exi. Apologies if I am pronouncing your name wrongly, but please feel free to, when you get the mic, to actually pronounce your name. Advisor to the Ministry of Human Rights Research Officer at the Office of the Public Prosecutor of the Council of States, lawyer at the Bar of Central Congo, RDC, Republic of the Democratic Republic of Congo. So, thank you so much. Mr. Lloyd, over to you. A round of applause for them, please, as they get to the stage.
Good afternoon, all protocols observed. It's not easy to manage and control state delegates. And I've been given the unenvious task of doing so, and I'll try my very best. And I just want to plead with the presenters that you will have 6 minutes each to just give your quick interventions and insights on the role of state focal points in the implementation of decisions of the African Court. I just wanted to say one thing, that this issue of implementation is not just us in the African continent that are grappling with it, but most recently, there was a decision taken against Switzerland by the European Court of Human Rights. So it was an issue on climate change. Then the Parliament of Switzerland voted recently against implementing the decision of the European Court on Human Rights. And people are saying it's actually unprecedented in the European continent. But I think, as we have already heard in Africa, we have had so many situations of non-compliance. And I think we've been given by Justice Anukam earlier the statistics. What we're going to do with the panel that we have today is just to look at what challenges have states faced in implementing the decisions of the court, what are the opportunities existing for improving and accelerating implementation of the decisions of the court. So, I'll then plead with the panelists to maybe just spend 6 minutes in making that presentation, just your maybe 5 quick points. We will not take questions, but we'll give an opportunity to the court. We'll give them 10 minutes to sort of respond, because we have only 1 hour for this panel. 30 minutes have already been knocked off, so we have only 1 hour. What I will do is I'm going to change the, in terms of who presents first, I'm going to change the order. We're not going to start with Mr. Antonio. We're going to start with Matthews Gamadzi, who is the Senior Deputy Director, Asset Recovery in Malawi. If you may come and give us your 5 quick points. Thank you very much.
Thank you very much, Mr. Moderator. My name is Matthews Gamadzi from Ministry of Justice in Malawi. Due to time limitations, I will quickly go to my presentation. Firstly, I'm a member of the Human Rights Section, which is a focal point for all human rights issues in Malawi. State party reporting, engagement with treaty bodies, including the African Court and other African human rights institutions. So in terms of the challenges that we as focal point officers face, first and foremost is lack of awareness of the court itself among key stakeholders. And this includes even government lawyers from the Ministry of Justice, Foreign Affairs, judges, Malawi Human Rights Commission, and even civil society organizations. So although we've had a few cases, but broadly on how the court works, the procedures, very few stakeholders are aware about them. The second challenge that we've had is the perceived conflict between domestic decisions and decisions made by the court. For instance, a court in Malawi may decide that a matter is statute barred, but when the applicant now approaches the African court, he finds that they're granted remedy. So the conflict in terms of jurisprudence between domestic courts and then the African courts, it's something which is very problematic. Related to that, is also misunderstanding of the rules or principles that are made before the court. By way of example, is a principle of non-exhaustion of local remedies. We've had situations where our courts think an applicant hasn't exhausted local remedies, but when he or she approaches the African court, he's also granted a remedy. So the other conflict in terms of the jurisprudence as well. The other challenge, of course, that we also faced is the communication lines, issues of the court, maybe emails bouncing or taking longer to be responded to. For instance, when I was appointed a focal point officer for Malawi, the first thing that I did was to write the registry requesting about the position of all the decisions, but I never got a response up to now. Then in terms of going forward, the court should continue its awareness drive by continuing working with state focal points so that there is more outreach on the country about the court itself. The court should also consider appointing a focal point for specific countries or specific regions, because that builds a rapport, and then you can easily approach the court to ask on something. The court should also orient focal point officers. So there is need to do an orientation once, because we were appointed at the same time, we needed to be oriented on how we're supposed to go about our business before we even started. That hasn't been done. So I think it's very necessary. And we also need more capacity building workshop for focal point officers because they're updated on human rights developments as well as sharing of best practices. The court should also, whenever they issue documents, for instance, practice directions, the court should make sure that it shares those documents with focal point officers in good time so that we can also distribute to our concerned institutions in Malawi, and also utilize the human rights section, which has national task forces that work on different treaties, for instance, African Charter on Human and People's Rights. I think my 6 minutes is now done. Thank you very much.
Thank you so much, my brother, Mr. Gamadzi, for leading by example. And I'm hoping that the other panelists will do the same. One of the things that stand out about Malawi is almost like Burkina Faso in terms of compliance and also ratification of treaties of the African Union. And I think we ought to commend the government of Malawi for that. I just want to move on now to Tanzania. Tanzania has also ratified the court protocol and signed that with 34-6 declaration, but unfortunately withdrew in 2019. But from Tanzania, we've got Mr. Richard John Kilanga, who is Assistant Director, Division of Human Rights, Implementation and Observation in the Ministry of Constitutional and Legal Affairs, Tanzania. My brother, if you could come forward and give us your 5 minutes presentation. Thank you so much.
Thank you very much. I feel very greatly honored to be in this room today. Tanzania is the host country of the court, but it's also the country with the most highest cases in the African court. So, because of the time limitation, I would like to mention very few points. I agree with the first presenter concerning the point which he has given, political will, but also the lack of awareness among the stakeholders is a challenge, especially on the issue of human rights and how should be implemented and protected within the country. Also, another point is the difference between the principles. For example, on the issue of nationality, under the international laws, it is provided that the one who alleged that he's a nation of Tanzania is the one who should prove his nationality. But when you come in this court, it is the country which should prove. So that's the principle, one of the challenge. Another challenge is the priorities between the African states, but also with the African courts, because the government we know has its own priorities, which most of them may infringe the human rights. So the perception is very different. And another one is budgetary constraint. Some of the human rights which are required to be protected and preserved require budgetary allocation, which sometimes may not be very good. Also, another challenge we face is the coordination of different actors within the government. That is another challenge which we face in Tanzania. Another one is the competing different interests, but this also may be similar with the political will. Sometimes when there is a change in the government, there are a government which comes with its own vision, which must be implemented within a specific period of time. So those are the main few challenges due to the time, which I would like to expose to this session. Thank you.
Thank you so much, Mr. Kilanga, again, for really sticking to your time. But I think also you raised very critical points, which I hope the courts can then interrogate with you on the issues of different priorities between the African states and the court, the issue of different interests, budgetary constraints, where the state then might then feel unable to implement decisions that is sounding in money, and also the problem of coordination of the different departments in government, which then makes it maybe delays or makes it difficult for the state to implement. We now move on to another state that had ratified the court protocol, but also withdrew its Article 34.6 declaration in 2020, and that is Benin. To take us through the insights from Benin is my brother, Mr. Dalmeida Daniel Gilles Antonio. You've got 5 to 6 minutes for your presentation. Thank you very much. If you may give him a round of applause as he comes.
Thank you. Good afternoon, ladies and gentlemen. On behalf of Benin, I would like to thank the Vice President of the African Court, the judges, different institutions of having invited us to this conference. Benin was a pioneer with regard to Africa. We organized the conference, and lately we have been facing a lot of critics at the national level, at the international level, with regard to the executions of the decisions of the courts. And now we were one of the rarest countries to sign this protocol that ensured that individuals could seize the African court. Unfortunately, Benin withdrew this particular right for citizens to seize the African court. What's the situation today? A certain number of decisions have been given about Benin. Benin in 2016 that took a certain number of reforms with regard to the Justice Department. We created the court for economic crimes and terrorist crimes. This was a specialized court. And there are a certain number of people who say the African court with regard to the decisions given by this court, but Benin, of course, respected this decision, so we changed our law. And we have a single court to ensure that people can appeal. With regard to other decisions, there are some that are still being examined, analyzed. There are some that have given, or rather have provoked a lot of debate within the country. So we believe that we have some obstacles. First and foremost, the court came to the country 2.5 years ago, and we presented our complaints to the court, saying that the court, whenever people go to the court, they give their decisions without taking into consideration a certain number of principles that the applicants must have actually, or rather, finished all the necessary recourse measures at the national level. We needed to ensure that the applicants, first and foremost, use the national mechanisms, or the national mechanisms before seizing the African court. And we try to respect the principles of a democracy, separation of powers. A certain number of decisions actually calls upon us to review our laws, that the parliamentarians have to review a certain number of laws. And this is something that is within the prerogative of Parliament. And of course, we try to work using the jurisprudence given by the West African, the ECOWAS Court. We also have the Constitutional Court which is the highest jurisdiction with regard to the protection of human rights, that is doing a wonderful job every Thursday. All the judges that go against the African Charter of the Human and People's Rights, that are corrupt, sanctioned. Something else, given the separation of powers principles, the executive cannot give instructions to the judges to come back on a certain number of decisions. So, but this brings about some issues. The judges can give decisions against the executive, but the executive do not have any mechanism actually to try to defend themselves. We need to continue discussion and to see how, in a holistic manner, we need to ensure that the decisions of our African court are applied. But we're also saying that the decisions given by the voodoo court, we have voodoo courts. We need to ensure that they are also respected. I had not presented myself in the beginning. My name is Daniel Dameda. I'm a judge, former chair of the court, resident brother of the Court of Appeal. We have two courts, special courts. I'm currently working at the Ministry of Justice, national focal point for the African court. The court has a wonderful future ahead. Thank you very much.
Thank you very much, Justice Antonio. And I think it seems Benin is already applying the principle of embeddedness that Professor Filion spoke about earlier. Well, we hope that at some point Benin will reconsider its decision to withdraw its Article 34.6 declaration. And also we hope that the Benin courts will then continue to apply the regional instruments that it has already ratified, even though it is no longer giving direct access to the courts. Thank you so much for your presentation. Then the next presenter is Madame Ekwelinda Neriza Epsemenduga from Cameroon. She's the Deputy Director of Agreements, Treaties, and Monitoring of International Commitments. Cameroon has not yet signed the Article 34.6 declaration. It ratified the protocol in 2015, and we hope that with elections coming up next year, Cameroon will consider signing the Article 34.6 declaration. Over to you, Madam. We have got 5 to 6 minutes. Thank you.
Bonjour à tous.
Good morning, ladies and gentlemen. I would like to thank the organizers of this conference for having invited the Republic of Cameroon to make a presentation on its experience with regard to the monitoring of the implementation of the recommendations formulated by the mechanisms for the protection of the promotion of human rights. I've been listening attentively the different presentations that have been made in panel number 1. I understand why this panel came before ours. There are a certain number of questions that were posed that will enable us to get some solutions with regard to my presentation. Cameroon has an interministerial committee for the implementation and the monitoring of the decisions formulated by the August for the Protection of Human Rights. This committee was created in 2011. It has 13 members, including the National Human Rights Commission. We need to say here that with regard to the monitoring, the Ministry of Justice and the Ministry of Foreign Affairs are at the heart of this process. They are the focal point designated for the monitoring of the implementation as a focal point. Their work is to work as an interface between intergovernmental authorities and the mechanism, the African Court, the National, or rather African Commission on Human and People's Rights, but also to ensure a daily follow-up of these activities with regard to defend the country before these organs, as well as for the effective implementation of decisions. With regard in particular to the implementation, the focal points formulate propositions. Once a decision has been given by the organ and communicated to the state. So they formulate the proposals for the implementation after analyzing the particular decision given. Now, this means that a decision that is taken by an organ cannot be automatically executed. First, it has to be analyzed, understood, and then they come up with the formulation of proposal for implementation, on taking into consideration the decision itself as well as other aspects. Cameroon has some best examples with regard to the implementation within the communication introduced by the African Commission by the victims of the post-electoral violence of the people from the northern part of the countries. Cameroon managed to indemnify these people to the tune of 2 billion CFA francs. There's also the car of Albert Mukom, who was given 100 million CFA francs. This is about 100,000 euros. Abdoulaye Mukom was also rehabilitated, and he was also given back his job and even promoted on other aspects. After a decision given by the court, Cameroon trained the security and defense forces to ensure that they respect human rights, and also sensitization against torture, and also providing mechanisms for having access to justice, and also to ensure that the different actors or the government, including at the prison level, are sensitized on human rights. Now, we need to ask ourselves, who is in charge of the implementation of the non-implementation of these decisions? We talked about the willingness, political will of the countries. Yes, first and foremost, it's the country, the state, the government that is responsible with regard to the implementation of the decisions of the different organs. But this implementation sometimes is complicated. Why is it complicated? To implement a decision, we need to understand it first. The nature of the decision would constitute an obstacle with regard to its implementation of the focal points. Have to get into contact with the organ that has given the decision to ensure that the organ educates and sensitizes on the nature of the decision. Another difficulty on the national responsibility, the negotiations with the applicants. Once the decision has been given, we say the state has to indemnify this person, has to free this person from prison. So negotiations have to take place with the applicants to understand really how to move forward. And this is not easy. And here, we also see the responsibility of the applicants with regard to the non-application of the decisions, because we have to identify the applicant, if the applicant is alive. With who should we negotiate the implementation? We need to understand and agree on terms, the amounts and all that. And so this is quite complicated, and this can impact on the implementation of the decisions or delay the execution. So these are some of the aspects that we wanted to share with you. Now, with regard to some propositions, it's good that countries have focal points designated on behalf of the organs, but to facilitate exchange and monitoring of communication between state and the organ in question. I'd like to share the experience that we had with the African Commission of Human and People's Rights. The focal points of the Cameroonian government were designated, and the people in charge of monitoring of decisions were identified. This enables us to exchange, to have updates with regard to the implementation of the recommendation formulated by the Commission. Thank you very much for your kind attention.
Thank you very much, Madam Linda Menduga, for your very insightful presentation. And you mentioned, I think one of the features that you mentioned is the issue of high-level coordination and the issue of negotiating with the applicants to facilitate quicker implementation of decisions, and also the issue of communication and identification, clear identification of who the focal point is. Thank you very much. We now move on to the last presentation, and this will be from the DRC, Mr. Liongi Bweke Eggs, who is an advisor to the Minister of Human Rights and Research Officer at the Office of the Public Prosecutor. Now, DRC ratified the protocol in 2020, and we're looking forward to it signing the Article 34.6 declaration in the not too distant future. One fact also to know about DRC is that it has filed a case against the Republic of Rwanda, if I'm not mistaken. I think that's one fact that we also need to know. And so I'll give you 5 to 6 minutes to present and give us your insights on the role of our state focal point in implementation of the court decisions. Thank you so much.
Thank you very much for the organizers for having invited us here to represent our country, the DRC, to this conference as a focal point. We have noticed a number of difficulties with regard to the implementation of the decisions of the African Court of Human and People's Rights, as well as other decisions of international jurisdictions. The first colleague did not exhaust their time, so I might have more of the time. So we need to talk about the framework documents developed by Professor Serge Frederic, who is amongst us. These documents regulate the relations between the focal points and the African Court of Human and People's Rights. In the second part, we're going to talk about the internal mechanisms for monitoring of the implementation of international decisions, and then finish by undertaking a certain number of activities we've undertaken as focal points within our country.
So the framework has an origin. This comes from the declaration on the executive committee level in the second session, in which the focal the countries were called upon to put in place focal points related to the work of the court. So the court sent a memo to the states with regard to implementation of this decision. As a result, on 5th April 2025, our country designated a focal point So what is the domain of activity of this framework? This is a document that needs to be improved because there are some modifications to be done. And we think that the contribution of all focal points would be determining for in terms of this work to enrich the document. So among the tasks for the focal points, there's a series of activities that are judiciary and non-judiciary. Judiciary activities are related to the participation of the defendant countries in the court. And the focal point is supposed to undertake the following tasks: monitoring of the memos sent by the court. It should ensure that they receive alerts on the progress of the judicial decisions issued. So as much as possible, the focal points have to go to the ground to facilitate the court in its mission. Focal points have to participate physically or through a video conferences in the ceremony, official ceremonies of the court. And collaboration between focal points and the court. Of course, is free. Therefore, the court can help from time to time the focal points in undertaking their mission. Second part of my presentation is going to deal with the status of judicial decisions at the international level. So all decisions have to be implemented. So these decisions have to be implemented, and when everything goes well, when the loser does not implement the judgment, but they can not sometimes implement the decisions. So they could ask for the implementation. And over and above these decisions, they have the power to push for the implementation, but the applicants have to settle cases between the individuals and the cases. So a question arises: is there an extra state organ for implementation of the decisions? In terms of the African Court, we shall note that an additional protocol to the African Charter has just declared that they have to commit to the decisions that have been issued by the court in all cases. And Article 80 states that in line with the protocol, the state parties have to conform to the decisions of the court. This is to say that when a decision is emitted, this has to be implemented in good faith. This implementation of the decisions of the court and is in line with the ratification of the instruments, including the African Charter. To understand the status of these decisions at the international level, we are going to refer to certain decisions given or issued, because the African Court, of course, DRC has no jurisprudence on that. So we're going to refer to two cases, that one of Jeremy Katanga and a former rebel who was sentenced to 2 years of prison. He when he covered actually he served 7 years. And of course, five were to be served in DRC and 2 at the international level, as it was requested. But what happened when he came to the country? Our international jurisdiction ignored this international court decision and then sentenced him further to a very exorbitant sentence. So, as a focal point of our country, this one was done recently. So there's the minister who was supposed to undertake this task. So there was a communication to be sent, which was involving the conflicts in Rwanda. So there was. Following the incursion and rebellion undertaken by Rwanda in our country, this is in violation of the human rights. Therefore, DRC complained at the African Court to accelerate the procedure. Unfortunately, the court responded negatively to DRC. And responded actually in very late. Our country is facing a lot of turbulence, elections, and therefore sometimes we had a lot of delays in the communication. So many activities that we undertake, but we need to say that I will stop at that point. But the challenges of DRC vis-a-vis African Court is awareness creation. The court, I think, in April sent a letter to the fact that to the effect that they would like to undertake a sensitization awareness sessions. And I think the court would have come during that time because the court is not well known. There's another obstacle, of course, the liturgy that has led to a lot of delays, and therefore we need to reinvigorate our activities at the ministry level so that our presence is more marked and explicit. So this is a challenge that we are facing as DRC. And through the focal point, we are working to ensure that we cooperate with African courts. The document is there. I think we can read it for further information. Thank you.
Thank you very much, Mr. Leongi Bokex. I think what we have heard from Cameroon and DRC is that they've made commitments to cooperate with the courts. Should the courts hand down any decisions against their countries, and that they are willing to utilize the focal points. I've also been informed that there are other delegates that are following online who were not able to come and attend. There are about 24 focal points that have been established, and I think this is an ingenious, really establishment to ensure that the decisions of the court are complied with, this setting up of a domestic mechanism. So now, looking at our time, we are supposed to finish at 1:45, which means that we have 15 minutes, which we are going to give to the courts for certain comments or responses. And then we then break for lunch after the distinguished state delegates have given us 1-minute responses each. Thank you. I'll now hand over to the court if there are any comments. And then the rest of the distinguished delegates, please reserve your questions for the afternoon if you have any questions or comments to make from the presentations by the state focal points. If there's no one from the court, I will then hand over the opportunity to other colleagues who might want to interrogate or to comment or input. Yes, sir, Judge.
Thank you. And I will thank the panel for the good work done. I would like to make a comment and ask a very short question. What we must appreciate, we as judges of the national courts, we must appreciate is that when we deliver judgment, we look at our national constitution as the supreme law. But when the matter goes up to the African court does not recognize your constitution as the regulatory law in the African court. The reason is that you have your national constitution, then you have executed a charter and saying that I will comply with the charter. And therefore, where your national constitution does not align with the charter, the court will ask you to align it with the charter. And in the case of Tanzania, where a judgment comes before the court and judgment is given, and the reason is that we have other commitments, we don't have budget for it. I beg to differ, because every country, whether developing or whatever, whenever you make a budget, you have contingency fund to meet unexpected expenses, including these things. So to say that because of that, there is no funding, I beg to differ. Then another issue is about the judgment in which whether a person is a national or not a national, who has the burden of proof. It is not a very simple to say that in international law, always the burden lies on the person. It depends on the circumstances of the case. If the person is saying that all my documents are with the state, when I was born in a village, I wasn't given a birth certificate. Who should prove that the person at the time of his birth was given birth certificate or not? It borders on the state. Here we talk about evidential burden. When does it shift? And it shifted. So when it shifts, and you think that based on this, the country is withdrawing, it is very unfair, because we are looking at the human rights of our people and not ourselves. And if we are in the hands of affairs, the next day we may become ordinary persons on the street, and we may need the assistance of the court. Thank you. Thank you.
Thank you very much, Judge. So I think Mr. Kilanga from Tanzania, I think you've heard the views of the judge on those three issues, and prepare your response to that later on the issue of the difference between your national public policy and with the constitution and what you have ratified at the regional level. And also the issue of budgets, that it's not an excuse for non-implementation, and then on the issue of burden of proof. Thank you so much. I'll take 2-3 more hands. Judge Anukam. Yes, Judge.
Let me also join to appreciate the panel for a job well done. Of concern to me is one issue that was raised concerning the misunderstanding of the principle of exhaustion of local remedy. I think one of the panelists raised that issue, and I really wonder why there should be any misunderstanding, because the jurisprudence of the court is very rich in that regard. It's actually very clear for anyone who sincerely wants to know. And then, moreover, Article 56 of the Charter, sub 6, clearly says, raises this issue of exertion of local remedy, which the court recognizes and actually is tied to, absolutely, the issue of exertion of local remedy. And I think that's where the issue of sovereignty also comes in. Because like every other international court, of course, we will only step in where there is any issue with the manner in which a claim or an application has been handled at the domestic level. So primarily, it's the responsibility of the domestic courts to do what is right and in accordance with beyond their constitution in accordance with the charter that they are signatories to. It's as simple as that. So I really don't know where the misunderstanding lies. So perhaps the person who raised it may want to throw more light so that we understand, because this is it's very fundamental to us. And with the admissibility is first and foremost. First, we have to establish that we have jurisdiction over an application. And then the next thing is admissibility. I will follow the whole 7 of them, as clearly stated in Article 56. So if there's an issue, perhaps we will appreciate to know where it is, and also regarding our jurisprudence in that regard. Thank you.
Thank you very much. Judge Antonio and Madam Menduga, if you may respond to this issue of exhaustion of domestic remedies, if you wish to, but specifically Judge Antonio, you may do that. And I think the Judge Anukam has said that, I mean, clearly, it's set out clearly for everyone. So yeah, we'll hear from you what you think. And then, so Judge, I think we'll take your intervention as well. Thank you. Yes.
Merci, Monsieur le Président. Juge Rafta.
Thank you, Judge. Sorry, Chair. I did not get the second part of this day. So if my question will be out of topic, kindly stop me. I would like to talk about the notion of sovereignty, which is treated as something very dreadful. The notion of sovereignty, as we know, in international law, is the basis of the international law. It is like the cornerstone, which of course is quite resistant. It was invented when the sovereign, that is the monarchies, could discuss of a subject as they wanted. That was in 16th, 17th centuries. And that is when the notion of sovereignty appeared, according to certain authors, of course, including Jean Bottin, who is one of the most famous. This notion of sovereignty can no longer today be read or understood as it was in 17th, 18th, 19th, and beginning of 20th centuries. It is a notion that has evolved over time, and it has evolved with international law. So this appeared, of course, as the law of war. And then there was the principle of constitutional autonomy, which is an absolute principle. And of course, all that is no longer the case. Sovereignty, of course, is the cornerstone, which has really been resisting, but it is a cornerstone that is evolving. But currently, the states no longer in facing subjects, as it was the case for the monarchies. But today, the states are, facing citizens who have rights, and not only internal rights, but also international laws. International laws. So when a state accepts an instrument related to human rights, at the same time they are accepting the fact that due to their sovereignty, they can introduce some modifications to its sovereignty. I'm not those of the school of Net, but when a state subscribes to an international treaty, then they accept to apply it in good faith. And if they do not apply it, then this, of course, has to do with international responsibility. Thank you very much.
Thank you so much. So we've got, I think, three very pointed and really important questions by the honorable judges, Rafa Benako, Justice Ajay, and Justice Anukam. And I'll ask the presenters, because we need to finish at 4:45, just 1 minute each perhaps, and to respond to those very important questions. I'll start with Mr. Kilanga from Tanzania on the 3 questions that were raised by Judge Ajay from Ghana. Thank you. You can use that microphone in front of you too. Just switch it on. Switch it on and then.
Okay.
Yes.
Thank you, the Honorable Judge, for your comments regarding our presentations. I would like to start responding to the comment by referring to the decision of the Executive Committee, which was given during the 40th ordinary session held on 2nd and 3rd February 2022 in Addis Ababa. It says, the AU Executive Council requests the court to have a deeper appreciation of reasons causing member states to withdraw their declaration required under Article 34, Sub-Article 6, and assure member states that such reasons are no longer there. The comments from the judge, I agree, but what also I have presented is from the experience. It is true that when the states accede or try the international agreements, it has to meet the obligation under those treaties or fulfill the obligation. But in reality, as I've just said, most of the cases in the court are from Tanzania, and most of the litigants are criminals who have been convicted in murder case, rape, and armed robbery. Most of them are the ones who come to the court, and the court give the judgment. Some of them are for reparations. So that is the experience. For I said there's budget allocation and priorities. So sometimes to comply with the court, then the states face a very intriguing situation because it has some. I don't think that it is not obligated to fulfill or to implement the obligation, but that is the reality on the grounds. That is a conflict interest or conflict in terms of the either to implement the judgment of the court, especially concerning the reparation in terms of money, and also providing eminent social service like water, education, and service. So I agree with the comment of the judges, but also what I represented from the practical experience. But also I urge the court also to consider the decision of the Executive Council, which also urged the court to consider those reasons. On the ground of nationality, I think this is also the conflict between the domestic court and the African court. So that is the perception. I'm not saying what the court is doing is not right, but it's from the experience which I've gained so far. Thank you very much.
Thank you very much, Mr. Kilanga. Perhaps I think there might be even further conversations at another platform regarding the issues that you're raising about what you are calling the realities on the ground versus, the decisions of the court and the treaties that you have ratified as a state. I think, that there will be need for further conversation on that, because really, I think once a country is ratified, it is then bound by those instruments and also by the decisions of the court. Thank you for your response. Then on the issue of exhaustion of remedies, Judge Antonio, maybe in 1 minute you can just give your response, and then I'll ask. I don't know if between 2 or 3 other state delegates, if you may respond on the issue of state sovereignty, if you so wish, one of you. Just 1 minute. Thank you, Judge Anton, 1 minute.
Oui, merci, Monsieur le modérateur.
Thank you very much, Mr. Moderator. I would like to thank the judge and other members for this concern raised. I would like to say that through the application 03 of 2019 regarding the Beninois in Gabon, the court condemned or sentenced condemned the Republic of Benin because Mr. Jamal Adavo had been freed by the tribunal for having, committed some crimes 20 years ago. But the Supreme Court would have followed the matter, the appeal court, but even if eventually he had spent part of the sentence in prison. When you look at Article 56, paragraph 5D says, in the decision, the court sentenced Benin to pay this and this to the children, to the wife, because they had signed a contract. So there was a lot of prejudice. But yes, but the court, through a measure or a decision, requested Benin to. But Javon, did he appeal? And from that time, if the court notices that Benin did not do this in good faith, then the African court would have continued. But since we did not have, as long as we do not have this justification, then the African court cannot move forward. So it is as if the decision was rendered, but the local remedies are possible. So the proof is that the Supreme Court has not been mentioned in this. Of course, we can improve things, and therefore we can discuss. Because what we can see today is what we are seeing in different countries. The opposition, people says yes. Those who find themselves in trouble, then today they are on the other side. So we really need to ensure that we do things to satisfy all the citizens, as we can see in Europe, in European Court, and elsewhere. Thank you very much.
Thank you very much for your interventions, Judge Antonio. I'll just give one of the delegates to respond on the issue of the limitation to state sovereignty when it comes to the decisions of the court. Okay, Ms. Matthews, maybe you can take it.
I don't want to attempt to respond on state sovereignty, but the issue of non-exhaustion of local remedies, because I was the one who posed that fact as one of the challenges that we've had in Malawi. I'll give an example with the decision of one of the decisions that the court made against the Republic of Malawi. It's a case concerning Charles Kajoloweka. After an assessment, he was ordered to pay some costs that he deemed exorbitant. So because he was aggrieved, instead of applying for a stay and then appealing to the Supreme Court to reassess the cost, he rushed to the African court. So in Malawi, authorities were saying, no, before approaching the African court, he had a remedy, application for a stay of that decision for the cost, and even appealing to the Supreme Court. So these are the issues that I was referring to in terms of interpretation of exhaustion of local remedies, because the understanding is that you have to at least to reach the Supreme Court And then if you don't get the particular remedy that you are asking for, then you can proceed to the African court. So there's been a confusion from the Office of the Attorney General, even the courts themselves, because they don't understand why they had to skip the Supreme Court and then opt to go to the African court. Thank you very much.
All right. Thank you very much. I just want to thank our delegates, state delegates. You will be given an opportunity because I think tomorrow there will be another panel where the three of you are also involved. So that discussion can be taken to that panel, and you will have another opportunity to give your interventions. But I just want to thank you so much. If we can give a round of applause to our state delegates. I think one takeaway from this panel is that I think there is great need for the court to interact with the state focal points that have been established, especially on a number of issues about the court's decision-making processes, issues of state sovereignty, issues of admissibility, exhaustion of local remedies as part of the requirements under admissibility and so on and so forth, and just explaining also the jurisprudence of the court and the relationship between the African court and the domestic courts. I think those issues are some of the things that the court can perhaps have a discussion with the state focal points. Thank you so much to the panelists, and also enjoy your lunch. I think we're about to go for lunch now. I'll hand over to Arusha to let us know when we're supposed to be coming back, or to the moderator. Thank you very much and for your patience.
Thank you so much, everyone, and to the panelists and the chair for the second panel session. We've come to the end of the first part, and I'd like us to go for lunch right now. It is exactly 13:53. We're going to be back here at 14:53 exactly. We're going to be back here at 14:45. Apologies for the rush lunch, but the agenda is quite full, and we're trying as much as possible to ensure that we're able to work through time. Okay, so the lunch is in the restaurant. I'm sure some of you do not know where the restaurant is. So once you get through the door, there would be some of our colleagues there to guide you through the whole lunch process. Thank you so much, and bon appetit, and have a great lunch. Good afternoon, everyone. Can we all please be seated? We're about to start the second half of the session. Please be seated so that we can finish off and go home. Well, Felicia. I'm just going to give everyone 30 minutes so that we can officially commence. 30 seconds. I know you all wish 30 minutes because it's lunch. I hope you all had a good lunch. And I'm hoping you're not all sleepy. I wish I had an energizer, but I do not. But I'm hoping that somehow, somewhere, I'm going to learn an energizer so that we can do one before the end of the day today. Welcome back. And now we're back to the third session, which is perspectives on implementation of human rights decisions by African Union bodies and United Nations, of course, the bodies. So joining me on stage right now is the chair, who's Advocate Tom Nyaduga. I don't know if he's here. Okay. Miss Eunice Malota, who's a representative of the African Commission on Human and People's Rights. Mr. or Miss Adiam Zememphis, who's a representative of the African Committee of Experts on the Rights and Welfare of the Child. And Mr. Clement Phoebe, who's the legal officer of the Pan-African Parliament. And then we have the ACHPR respondents, who's Dr. Sejona Ajolohun, head of legal division, as well as Dr. Serge Umbumenye, senior legal officer. Over to you, Chair, Advocate Tom.
Honorable Vice President of the Court, Justice Modibo Sako, in absentia, distinguished judges, the African Court, colleagues in your different capacities, good afternoon. This is normally what is called the guillotine session. And if you made a mistake of taking all the 3 courses, I don't know how I can excite you to listen to me and the panelists, but I'm sure the topic itself will make you be attentive. Before I bring the panelists, I wanted to preface my role here with 1 or 2 preliminary remarks. When you look at the program, I just wanted to add a little bit of information, which is very important, and which is what brings me here. I'm a former member of the African Commission, in other words, a commissioner. But in my capacity as an advocate, I've advocates or litigated before the court. And I have a client who is here, who is very much interested with our discussions, because the decision that was rendered by the court really has not been implemented. Daniel Kobe, are you in? Oh, Daniel is not back. He's an Ogiek. He's the one who brought, one of those who brought the case to the commission, and then later the commission brought the the application to the court. Now, having said that, the topic before us, we have listened to quite a number of presentations this morning, but the significant part of the presentation this afternoon gives us the perspectives of implementation in the other human rights system, the UN human rights bodies. And I think the comparative perspective at this point, even though the next one will also touch on comparative perspective analysis, but I think it's important we hear whatever the presentation from the panelists will be in this regard. I wanted to add a bit of a statistic to what was mentioned this morning. You know, we've been talking about the African states not implementing, but we also need to bear in mind regarding the African court, we're talking of probably 13 states. The current 9 which have deposited, if my numbers are not wrong, and the 4 which withdrew. So out of the 400 decisions, you just distribute them among those 13 states. So what happens to the rest, those which have ratified and not deposited, and those have not ratified? And the same can be said for the Committee on the Welfare of the Child. Since establishment, I think, if I'm not wrong, and we have a representative, well, probably barely how many cases? 5? If apart from the Senegalese one, the Ugandan one, and the Nubian, I don't know, maybe she'll update us with information. For the commission, where I served, when I left, the Center of Human Rights had done a study, and there were about 14% since 1988, and this was around 2009. Only 14% had been implemented. I don't know the numbers if we are to compare it with what the court said this morning, how many communications have been adjudged so far and how many are implemented. But I wanted to highlight some of those few facts so that we take them into account. Without much ado, let me call now Eunice Malota from Banjul. It's one of my favorite cities in Africa, where I served for 6 years. I'm sure she will do me justice. Karibu.
I'll need help with this microphone. Okay, I turned it. Okay. Okay. Good afternoon, honorable judges, ladies and gentlemen. Allow me to stand on the existing protocol. My name is Eunice Malota from the ACPHR, and I am on secondment from Attorney General's Chambers, Botswana. I'll be presenting the ACPHR's perspective on implementation of human rights recommendations. And I am the focal person on implementation at the Commission. And I bring you greetings from the Acting Secretary of the Commission, Mrs. Abiola Idoho Oju. This afternoon, I will discuss 4 issues: the mandate of the ACPHR and its various mechanisms that issue recommendations, the legal framework governing implementation and the practice, challenges concerning monitoring of the Commission's recommendations and the Commission's efforts in addressing them, and finally, recommendations on the way forward. As already indicated, I'll start off with the mandate of the Commission and its various mechanisms that issue recommendations. As you know, the mandate of the Commission is to promote and protect human rights pursuant to Articles 30 and 45 of the African Charter on Human and People's Rights. In the discharge of this mandate, the Commission issues recommendations emanating from its various mechanisms. We have recommendations from the communications procedure. So far, the Commission has considered 847 and finalized over 659, including 197 on admissibility. We have recommendations from state periodic reports in the form of concluding observations, and 141 reports have been considered so far. We have mission reports from either promotional or fact-finding missions, and we have conducted 3 missions on average per year. We have recommendations from special mechanisms outputs. These are your letters of urgent appeal, your press release, your resolutions and declarations. A lot of these have been issued. And then we have recommendations from commissioners' intersession activity reports presented at every public session of the Commission, and the Commission's activity report presented annually before the policy organs. With that introductory background, I will proceed to discuss the legal framework governing implementation and the related hands-on practice. According to the legal framework, that is our charter and the rules of procedure read together, implementation is a state function. Monitoring implementation is a Commission function. Now, with that in mind, let's explore the legal framework with respect to the various mechanisms of the Commission and see how the Commission is faring with respect to monitoring the implementation of its recommendations in practice. Under the communications procedure, where provisional measures have been granted, the state party concerned is mandated to report back on the implementation of provisional measures within 15 days of receipt. Most states rarely report back, if at all. In practice, the Commission will proceed on procedure until a decision on the merits is taken. Follow-up is done through the Commissioner Rapporteur in charge of the concerned country. There is, however, no systematic follow-up on the state undertaken by the Commission. With respect to a decision on the merits, parties are required to inform the Commission in writing within 180 days from the date when the decision was transmitted to them of all action being taken by the state to implement the recommendation of the Commission. In practice, the Commission awaits the state to inform it. And if the state does not inform the Commission after the lapse of 180 days, there would be no follow-up on implementation by the Commission. The reason the Commission awaits the state party to inform it and does not follow up is due to a lack of human resources specifically dedicated to that purpose. With respect to state periodic reports, follow-up of the concluding observations is two-pronged. Firstly, follow-up is done during the presentation of subsequent state report, pursuant to the reporting guidelines. Secondly, it is also done within the framework of a promotion mission. The Commission has been successful in following up in this respect. However, this follow-up process is devoid of consistency, as states may not report consistently every 2 years, and missions to state parties are generally few and far between in any particular state, rendering the follow-up on implementation irrelevant in some instances due to lapse of time. With respect to mission reports from promotional and fact-finding missions, Rule 83(2) of the Rules of Procedure limits follow-up during promotion missions to concluding observations. However, in practice, follow-up is done on all recommendations during the promotion missions, emanating from all the mechanisms of the Commission. We have special mechanisms outputs, such as I have already mentioned, your letters of agent appeal, your press release, your resolutions and declaration, which contain recommendations, but not all require feedback on implementation. Letters of agent appeal, however, require an implementation update if the alleged violation turns out to be true. In practice, the Commission informs the state within that letter of agent appeal that its failure to give feedback on implementation will be reported to the policy organs through the Commission's activity report, and leaves it at that. No feedback, however, is required with respect to press releases, resolutions, and declarations. However, if it happens, it will be very much welcome. With respect to the Commissioner's intersession activity reports and the Commission activity reports, there are also recommendations on implementation directed at state parties. Practically, follow-up ideally is done by the Commissioner Rapporteur during a promotion mission. However, follow-up depends on the intentionality of the Commissioner during the promotion mission. Also, follow-up is also done through meetings or seminars or other such fora. Otherwise, currently, there is no systematic and consistent follow-up of recommendations of these activity reports. Now, this discussion...
Madam, you got 3 minutes more.
Okay. This discussion, ladies and gentlemen, was an exploration of the legal framework with respect to the various mechanisms of the Commission and the Commission's practical efforts in monitoring implementation of its decisions. As the Commission, we are very much aware of our challenges in monitoring implementation. Hence, regional seminars have been held in 2017, 2018, in Senegal and Tanzania, and recently in South Africa. Now, allow me to share with you our challenges concerning monitoring of the recommendations of the Commission. Firstly, there is lack of strategy. But I am happy to report that a comprehensive framework on enhancing implementation of the recommendations of the Commission to state parties was adopted during our 78th ordinary session. Our second challenge is inadequate human resources. Within the structure of the Commission, there is no implementation unit. But we have currently put forward a request for this structure to be put in place, and the policy organs are considering it at the level of the PRC. For the longest, there was no dedicated legal officer whose core function was to monitor implementation. Currently, there is only one person, in the person of myself. But I'm also happy to report that we are looking forward to receiving another senior legal officer who will be with the Commission on a short-term basis. Thirdly, no budget dedicated to monitoring implementation. We hope if this structure is approved, there will be a legal basis to apportion the budget accordingly. Despite the challenges, the Commission has succeeded in establishing a working group on communications that has developed a matrix on communications and audits the status of communications at every session. However, implementation is still a challenge in terms of statistics of implementation.
1 minute.
Okay, We have also enlisted recruited a data expert to assist us with the data, which will be very relevant for us in monitoring implementation. Let me quickly go through the recommendations. These ones are so important. Firstly, strengthen national human rights mechanisms. That is the first recommendation on the way forward. Let's start where we are. States have got national human rights committees. Let's establish interministerial committees within the already existing implementation, within the existing national mechanisms. Secondly, let's establish interministerial committees and equip them. Develop tools to assist them. Secondly, let's intensify diplomatic engagements with state parties. This is key. Thirdly, designate NHRIs to follow up on implementation pursuant to Rule 125 of the Rules of Procedure. When the Commission approaches state parties directly, state defense mechanisms automatically go up. States almost always feel that human rights bodies are aggressive and offensive in their approach.
You conclude at the UN, I would have switched off the microphone, but I will not.
Thank you. That it is not the UN right now, but thank you very much. NHRIs have an advantage over the Commission in the sense that they operate at a national level. That means they have easy access to accounting officers of all government ministries and departments through formal and informal means. These people know each other. They are even related. It is easier to bring up issues of implementation without feeling defensive about the conversation. So more can be achieved this way. Develop soft laws that will facilitate incorporation into domestic legislation, develop soft laws that will facilitate incorporation into domestic legislations of provisions requiring implementation by states of decisions of international human rights bodies. Fifth, budget allocation. If we have it in our local legislation, we can plan to set aside monies for that. And finally, intensify capacity building efforts. NHRIs and civil society should lead this effort. Unless and until we have invested in capacity building with respect to implementation of our recommendations, we have no right to expect states to implement our recommendations. And on this note, Mr. Chair, I conclude and I thank you for your attention.
Thank you very much, Madam Malota. Actually, I'm very fascinated to know that Madam Malota has been seconded to the Secretariat by a member state. That is the spirit we would expect to see. And I hope by doing so, it does not in any way eat away the independence of the Commission. But the fact that one of the challenges is resources, by seconding, and I'm sure it's Botswana which pays you. Yes, so it helps to ease the burden of lack of staff. I call upon Adiam Zememphis. I hope I pronounced the name correctly. There was a time actually the African Committee used to be left behind. In those days, it was in Addis Ababa, part of the AU Commission, but now they're based in Lesotho, their own secretariat. You're welcome.
Thank you very much, Chair. Warm good afternoon, honorable judges and ladies and gentlemen. May I kindly ask to be assisted to put the presentation. Thank you. So I will try to avoid repetition of what has already been mentioned by Ms. Onis, because most of the mandate of the committee and the commission are very similar. I will briefly talk about the source of decisions of the committee, the mechanisms of monitoring available within the mandate of the African Committee of Experts on the Rights and Welfare of the Child, how implementation looks like, just a brief overview on the status of implementation. I will not go in depth. The challenges that hinder implementation from the experience of the committee and some of the recommendations that the committee wishes to put forward as a way forward. I'm not sure. In the interest of time, let me allow me to proceed until the PowerPoint is fixed. The committee has, as it was mentioned, similar with the commission, it has a communications procedure whereby it receives communications on alleged violations. So far, the committee has received 24 communications. Decisions on the merits have been issued on 10 communications. And from the 24, 2 have been settled amicably, and there is another 2 communication pending to be settled amicably, and the others are still pending or have been declared inadmissible. So from the communications procedure, the sources of decisions that would actually require follow-up by the committee are the decisions on the merits, the amicable settlements, and also provisional measures that the committee issues. So far, the committee has only issued 1 provisional measure on a communication while it was pending. The other source of a decision or a recommendation that would require follow-up by the committee is the concluding observations and recommendations that come out following the state party report considerations. So far, the committee has received 72 reports. It has considered 70 of them and has issued 65 concluding observations and recommendations. The committee also, as per Article 45 of the Charter, has the mandate to undertake investigative missions. So far, 28 country missions have been conducted in various contexts, and recommendations have been issued based on the investigations. The committee also issues letter of urgent appeals, similar to the commission. So far, the committee has issued 9 letter of urgent appeals, and these are the source of the decisions and recommendations of the committee, which would require follow-up activities. The mechanisms that are available at the committee to follow up are emanate from the rules of procedures, but also the guidelines for consideration of communications and the guidelines for consideration of state party reports. So along with the rules of procedures and the guidelines, and of course the charter, there are some mechanisms that allow the committee to monitor its implementation. The implementation of its decisions. The first one is once a committee issues a decision, respondent states are required to submit a report within 180 days. There could be an extension for another 90 days. And if there is no report, as per the rules, the committee would have to report the failure to the assembly. The committee also has the mandate within its communications procedure to hold implementation hearings on decisions of the committee. So far, the committee have had 3 implementation hearings in the presence of the respondent state and the applicants. The committee also has a country visit as its follow-up procedure, whereby it undertakes missions to follow up its decisions. So far, there hasn't been a request that has been accepted by the respondent states to follow up on implementation of decisions from the communications procedure. The committee is successful in monitoring its concluding observations through country missions, but when it comes to communications, there is a bit of a challenge in getting response or authorization from the respondent states. There is also an opportunity for the committee to actually follow up on its decisions through the state reporting procedure. So during the state party reporting procedure, if it's a report submitted by a country to which a decision has been issued, then the committee would flag those decisions and the implementation of the same during the state party reporting procedure. For the state party reporting procedure, the committee also undertakes follow-up activities through, of course, as it's a cycle, through receiving periodic reports, by undertaking follow-up missions, and the outcome of all these findings will be included in the committee's activity report to the Executive Council. And specifically on the communications procedure, there is a provision within the guidelines which indicates that the committee would report non-compliance of implementation to the Executive Council and the policy organs as well. The committee also has recently established a working group on implementation of decisions, which focuses mainly on the issues of implementation, assessing the status of implementation at the committee, and coming up with mechanisms for the way forward. The committee also has enhanced its engagement with NHRIs and CSOs on implementation of decisions, specifically focusing on implementations of decisions to ensure implementation. I will summarize briefly the 3 slides that I have skipped in the interest of time. Those highlight some of the status of implementation of the decisions of the committee. There has been some progress when it comes to the communications, whereby from the implementation hearings, the committee has actually received positive trends by where states actually pay compensations, adopt and review laws that the committee had recommended. But full implementation is something yet to be achieved, as the recommendations are very there are a lot in one communication, so partial implementation could be achieved. But looking at each aspect of the decisions of the committee, of course, there is a huge lack, but there has been some positive trend from states that have reported, but also from the implementation hearings where the committee has found that compensations were paid, laws were reviewed as per the decisions of the committee.
3 minutes. 3 minutes.
Okay. The challenges, the first one is, of course, lack of capacity of the committee and other AU human rights organs in monitoring implementation. Both technical and financial resource is very limiting. In some instances, the committee was actually challenged by instability of member states. Like in the case of Sudan, the committee has, for instance, released a decision, but no follow-up can be done because of conflict and instability situations. The layers of actors involved in the implementation is, of course, an opportunity, but also poses a challenge, because while the committee engages, or the organs engage through the formal channels, diplomatic channels, implementation goes beyond that, because wide range of actors at government level are supposed to be involved. In some countries, there is a lack of national mechanism for reporting and follow-up at domestic level, which puts a challenge to follow up. There has been explicit or implicit expressions by countries towards non-compliance of the decisions, which is another challenge. There are gaps involving in domestic courts for enforcing the decisions of the committee and other AU organs. There is lack of response from states for requests for country visits or even to report. The issue of sovereignty has already been mentioned, so I wouldn't go there. There are no measures undertaken also by AU policy organs, even though the main mechanism for enforcing is for the policy organs, for the organs to actually report to the policy organs for further measures to be undertaken. We have not seen any progress in that regard. And there is also a lack of evidence-based verified information on the status of implementation to come up with a clear understanding of where we are. Moving on to the recommendations, there is a need to enhance follow-up activities by organs, and there is a need, of course, to have joint collaborations in terms of coming up with joint monitoring frameworks, as well as joint undertakings to push for political will. For instance, joint submissions to the policy organs by the 3 human rights organs can be something considered, so that the Executive Council and the other policy organs can also take this forward in a better way. There is a need to increase engagement of policy organs, as I've said, and then bring the wide range of actors that are involved, including NHRIs, various wings of state, targeting based on the kind of recommendations that have been granted by the organs. There is a need to engage targeted government wings. CSOs and litigant groups need also to come forward in the conversation. The organs need to, the committee needs to better engage with them. And there's also somehow a need to adjust the kind of remedies that the committee provides. The recent study of the Committee on Implementation of Decisions highlighted that there is a gap in providing measurable decisions that are easily understandable by member states for enhanced implementation.
1 minute.
Excuse the PowerPoint, let me just proceed. There is also a need to popularize the decisions of the policy organs. Very often, even when we do follow-up and monitoring missions, the technical people who are actually tasked to implement the decisions barely know about the organs, let alone the decisions they come up with. So there is a need to popularize the decisions at domestic level so that they get so that technical people actually get a good knowledge of what is happening at the organs level. There is a need to increase cross-referencing of decisions so that we can come up with concrete recommendations that can easily be implemented by member states. There is a need to ensure that the committee has access to the court for more implementation. As we all know, still the committee doesn't have a direct access to the court. So that is some recommendation that we think of from the committee side. We need to also encourage states to establish national monitoring, national mechanisms for reporting and follow up according to the standards that have been recently developed by the UN through the Human Rights Council resolution. And we also need to enhance collaboration in monitoring implementation of decision to leverage on the mandate of each other's. For instance, the committee is capable of following up on the decisions of the court through its state party reporting mechanism, the same with the commission. So that complementarity needs to be enhanced. There is a need to enhance the undertakings of the working groups from the side of the committee on implementation of decisions to actually have a clear assessment of where implementation of decisions are so that we have a better understanding on where we stand. And there is a need to have a joint and coherent framework and working methods in terms of monitoring, implementation, and other guidelines that relate to communications such as reparation guidelines, which the committee is currently still developing. So we need to align that among the 3 organs so that we have a coherent framework as well. And experience sharing forums on implementation among member states to document best practices is a key recommendation that I'd like to put forward, because there has been instances where countries have actually implemented and the mechanism they have used to implement can be documented and shared with other member states for learning purposes. Thank you very much.
Oh, thank you very much, Madam Zemfaren. There was a time I was about to stop you, but I remembered you are acting in the best interest of the African children. And we also had the Day of the Child some few days ago. Okay, without again wasting much time, let me call upon the representative of PAP, the Parliament. Oh, I left my glasses, so I can't even see the name now. My brother, we know each other, just come in. 10 minutes.
Yeah, thank you very much, Mr. Chair, for giving me the floor. honorable judges of the court, and honorable colleagues, I bring you greetings from the clerk of the Pan-African Parliament, who are supposed to be here, but could not because PAP is basically starting its session, and there are several meetings preparatory to the session, which is supposed to start on Monday. I prepared a PowerPoint presentation, but I think I don't want to use it so that I can go faster. The Pan-African Parliament is not a quasi or judicial human rights body. Therefore, the discussion on perspectives on implementation of decisions might not directly invite the Pan-African Parliament in the discussion. However, more and more we have realized that the Pan-African Parliament has a role, and I call it potential role, as far as the implementation of decisions of African human rights bodies, particularly the court, is concerned. And since Pan-African Parliament is not well known, I thought I was going to briefly introduce the Pan-African Parliament, and particularly its mandates, which clearly speaks to human rights, including implementation of human rights decisions. Then I will perhaps make some comparative perspective with similar institutions, and then I'll conclude. Pan-African Parliament is the legislative body of the African Union, established with the mandate to ensure the full participation of African peoples in the development and economic integration of the continent. And in so doing, the Pan-African Parliament is supposed to engage with the various bodies of the African Union, including judicial and quasi-judicial bodies, the policy organs of the Union, and other advisory organs. The Pan-African Parliament was established under the Constitutive Act of the African Union, yes. The Pan-African Parliament was established under Article 17 of the Constitutive Act of the Union. It's not helping. But it required a dedicated protocol adopted in CIRT in 2001 for the Pan-African Parliament to have an instrument under which it should operate. And so the CIRT protocol entered into force in 2003, 2 years after its adoption, and the Pan-African Parliament started operating in 2004. And in 2014, a new protocol was adopted, vesting PAP with increased powers. This protocol is not yet into force. However, currently the Pan-African Parliament is operating under a mandate which enables it to deploy 4 specific functions. First of all, a quasi-legislative function, which is exercised through harmonization of laws of the member states. Secondly, an oversight function, and I call it soft oversight, which enables the Pan-African Parliament to examine any issue, and that any issue can be a human rights issue, by the way, or non-implementation of a decision, and so forth. Thirdly, the Pan-African Parliament exercises budgetary functions, which includes making recommendations to the Executive Council of the African Union on the budget of the Union. And lastly, the Pan-African Parliament exercises representational functions, which includes parliamentary diplomacy, promotional missions, sensitization, or empowerment of parliamentarians and or national parliaments. Since 2004, the Pan-African Parliament has achieved quite a lot, including in the area of advancing the promotion of human rights, including advancing the domestication and implementation of human rights on the continent. When you particularly refer to Article 11 of the protocol of the Pan-African Parliament, you will definitely see that the Pan-African Parliament in its objectives and mandates has a role to play in terms of advancing not only human rights, but even decisions arising from human rights bodies. Secondly, the Pan-African Parliament has a unique position in relationship with parliaments of the member states. And as you may recall, in most of issues related to the implementation of decisions, particularly of the court, issues of legal or legislative enactment come into play. And that call for the Pan-African Parliament and national parliaments to work hand in hand for legislative development or reform where necessary. You would have remedies that may require the executive to take specific action, and Parliament in its oversight power is able to bring the executive to book. Thirdly, implementation of some decisions can sometimes require the allocation of resources. So I'm trying to catch up. And Parliament also has a role to play. And lastly, implementation of decisions sometimes can require some parliamentary diplomacy or some advocacy to be done vis-a-vis those who are supposed to take action. So therefore, it is our humble view that the Pan-African Parliament can actually use its quasi-legislative mandate or function to, for instance, propose model laws for the member states to adopt in facilitation of implementation of decisions. And I think tomorrow there will be a presentation on that. Pan-African Parliament can also encourage legal reforms or enactment where necessary.
3 minutes.
Under the soft oversight power, the Pan-African Parliament can examine any case of failure to implement decisions, can invite the failing states to take specific action, and where action has not been taken, Pan-African Parliament can mobilize national parliaments through the 5 members of parliament who sit at the Pan-African Parliament, can mobilize them to actually engage in written question or oral question addressed to the responsible minister. Thirdly, as far as a budgetary mandate is concerned, the Pan-African Parliament can, and the PAP members can ensure that national budgets have appropriate allocation for the implementation of decisions, particularly decisions from the court. Lastly, under representational function, the Pan-African Parliament can deploy its parliamentary diplomacy to actually convince, where necessary, the executive to carry out the implementation of specific decisions. And basically, when we, and I'm going to my last point, when you will look to other human rights systems, what the Pan-African Parliament can do may not be new, because the Parliamentary Assembly of the Council of Europe, which is the parliamentary body that is the most closer to this, to the mandate of the Pan-African Parliament, exercises those functions vis-a-vis decisions of the European Court of Human Rights. And if you compare the PAP protocol and constitutive instruments of the Parliamentary Assembly of the Council of Europe, you will see similarities. In spite of historical context for the two institutions, the mandates are similar, and it is possible that through national delegations, the Pan-African Parliament can trigger implementation of decisions of the court. In conclusion, Mr. Chair, honorable colleagues, the Pan-African Parliament can be an effective facilitator or enabler of implementation of human rights decisions, particularly those from the court. And this for the following reasons. One, this can be clearly read from the current mandate of the Pan-African Parliament. And deployment of this mandate, particularly in relation to decisions of the court, would have no legal, institutional, or budgetary implications. And it is in line with best comparative practices. It will be an exemplification of effective collaboration under the African governance architecture. Also, it will be a strong and practical example of collaboration within and amongst the African Union organs. Then it does not
conclude.
Thank you, Mr. Chair. I'm concluding in 30 minutes. It does not contradict, and rather, 30 seconds, rather it complements the mechanisms set out in the African Court Protocol, particularly under Article 29.2 and Article 21, vis-a-vis the role of the Executive Council of the African Union. Then the Pan-African Parliament's role will centralize citizens at the core of implementation of decisions of the court. And lastly, it harnesses and respects state sovereignty while empowering human rights victims. Indeed, I'm aware that the Pan-African Parliament and the court will be probably having an opportunity to sit and reflect on the possibility to work in synergy as far as implementation of decisions of the court are concerned. Indeed, Mr. Chair, thank you so much for the opportunity. Merci beaucoup.
Thank you, Dr. Senyona Ajuhuni. You know, I've interacted with many of these people for many years, and then I just happened to forget the names. Apologies that I couldn't pronounce your name initially. I'll now be giving the floor to a representative. Actually, there's supposed to be two I don't know why two, maybe one could have done, but the program says two from the African Court. And I'm assuming ECOSOC is not here because we did not have ECOSOC on the table. They are not here. So the representative of the court, please. I think you can speak from where you are, if you have a microphone. This is
Thank you, moderator.
Please, go ahead.
Yes, it is in respect of Palu. Sorry. What we have observed is that in almost every year, the president of each country appears before Parliament and tells Parliament the State of the Nation address. And they are to talk about basic human rights. When they come, do you ask them about how they have observed their obligations with respect to human rights under the African Court and the African Commission? Because if they appear before you and you ask them, when they are coming, they will prepare. And it will embarrass them if they fail to comply with the decisions of the court and the commission. Thank you, Mr. President. Thank you, moderator.
Is there any person from the court? One of the judges? Yes, please.
Thank you very much. I am indeed very pleased with the last presentation, PAP. And it made me again to revisit my own paper, the first paper, wherein I think I left out PAP. Indeed, now I think PAP should come first, or okay, it's number 3. I think I'm going to rate them as 1, because it's obvious that they are actually a very critical enabler regarding the challenge we are facing, especially as the presenter had said, the use of parliamentary diplomacy and through the state parliament or national delegations. I want to accord it a very due recognition of as a tool, effective tool to achieve our purpose. And I thank you.
Thank you. Do we have maybe, yes, Madam Judge?
Merci, Monsieur le Président. Bonsoir.
Thank you, Chair. Hello, everyone. I have a question to ask to PAP. Maybe I did follow well, but I would like him to repeat. He said that they are ready to respect the issue of the court in the execution of the decision, and also with respect to the sovereignty. Is it what he said? Because I really do not think that the court issues decisions that are contrary to the national laws, because the states have signed the protocol and the treaties. So the court has never condemned the state if they did not ratify the protocol, if they did not sign the treaties on human rights. So I would like to know whether PAP is going to help the court to say whether there is sovereignty or no sovereignty. So what we say often, the African court is there, created by the African states for the African citizens, and therefore we should ensure that this court succeeds in its mandate, which is protection of human rights. And the legislator is the African Union. They come from the African Union. It's just like the national judges who apply the national laws, which are created or formulated by the parliamentarians. So there is no way African institution will be created to go against the African countries. So probably he would probably need to add a caveat on what he said to ensure that whatever they're going to do will not be contrary to the sovereignty. And then something else, of course, I've just discovered that the 3 institutions, human rights, court, African court, and so on and so forth, we all have the same problem. We issue obligatory decisions, and the commission would not say it or issues the recommendations. So eventually we are all facing the same problems. So the problems come from the states, and therefore, as I always say, the states must ensure that they follow what they created, because they created it for Africa, for the citizens of Africa. Otherwise, they should probably say, no, this is not for us.
Honorable judges, actually, I was thinking even myself about the last comment, which you just mentioned about, in spite of the distinction of the binding nature of the court's decisions, on the one hand, for the court judgments, and then the recommendations for the others, but still the same dilemma. I'll be giving the floor to the speakers, 1.5 minutes each, but I wanted to add an observation based on my experience. I was on the commission starting 2003. Now, the interesting thing was that was the time when the new African Union Commission was also established. Professor Alpha Konare and his colleagues. That's when they transformed from secretariat to a commission. They developed a certain very good practice. I don't know if it still continues. Actually, all these organs used to meet in retreats and would brainstorm all these things together. This secretariat, the court was not in existence at that time, earlier, before 2006 or 5. The secretariat of the commission, the parliament, and the committee. And all these issues would be discussed in the presence of members of the African Union Commission. And then what next followed was we did, I remember, 2 retreats with the members of the PRC. Why this was useful was because the PRC prepares everything before the summit. And there's all this problem of the revolving door. After every 2-3 years, Addis Ababa representation changes. So you end up with new people. Now, I'm not sure if that practice still continues. So I thought I'd just mention that one. But I had 1 or 2 comments which I thought you might respond to the speakers. Madam Zemprem, you mentioned the partial implementation of some of the decisions of the committee. I think it's a best practice that there are some which are being implemented. I wouldn't mind if we mention them so to acknowledge, like Burkina Faso in the case of this morning. For the court, for the parliament, this oversight mechanism, how effective is it? Or were you talking about the future, or it's happening even now? You mentioned of those 4 categories of roles, so I wanted to know the oversight, if there's any practical aspect to it. Please, you can respond from there. Yeah, we start with the same order that we started. If there's any comment you have, Madam Malota. I know all the questions were addressed to the PAP, so, but still, if there's anything you wanted to add.
Thank you. Okay, thank you very much for the floor. I would like to conclude by saying we know that implementation of the recommendations is a problem, it's an issue, and we expect states to implement. Having the advantage of having worked or working for a state and having been a part of report writing and feeding the human rights treaty bodies reports, I know that it's not that states do not want to implement. States have their challenges, but I think those can be modified or mitigated by paying particular attention to capacitating states. I already mentioned it, and I believe that states need more than just being expected to implement. They need a system that works like the UN, for the AU organs to do the same thing that the UN is doing to improve their implementation capacities. They need to know exactly what is expected of them, and a lot of help coming from the AU bodies would assist a lot. So I would say let's focus on capacitating the states for this implementation to eventually take place. I thank you.
Thank you very much once again, Chair. Just allow me to start with highlighting some of the key good practices that we've seen in the case against, for instance, Kenya on the Nubian descent. It was reported that since 2019, the Nubian descent was included as an ethnic group in the registration so that it's easier for children to register. In the case of the Talibis case, the government of Senegal reported that it has allocated 100 million CFA to implement the decision of the committee, and also informed that it has drafted a curriculum for the DARAs to address some of the recommendations that the committee put forward. In the case of Sudan, the victim was granted a Sudanese nationality. It was an issue of nationality. And the government actually also revised the Nationality Act to take into account some of the recommendations that the committee has put forward. In the case against Mauritania, it was reported that compensation was paid to the parents of the children, the victims, and there were reports on implementing the sentencing year, so that it was an issue of increasing the sentencing year as per the law. And it was reported that after the decision, there were 6 trials, and the sentence was in line with the law that was in place, and the fine was also in accordance with the law as per the recommendation of the committee. So these are some of the good practices to highlight. But just to add on PAP, it's not PAP is, of course, a key stakeholder, but the committee has also learned, in addition to PAP, APRM and ECOSOC also play a key role in terms of in monitoring compliance of the decisions of the treaty bodies. So the committee is trying to actually work harder to enhance its collaboration with PAP, APRM, and ECOSOC, and it's really an opportunity that we should take forward. Thank you very much.
Yeah, thank you very much, Mr. Chair. I just got 3 questions. The first one on the State of the Nation address. Actually, you are right, Honorable Judge. We host almost at every session a head of state to address Parliament. But in terms of the procedure, that speech is not debated in Parliament. That does not mean that Pan-African Parliament does not do or cannot do silent diplomacy before and even after the delivery of that speech. Again, probably focus now is on institutionalizing that appearance before PAP, and there will be time where that could be followed by actual debate, but some diplomacy is done and takes place around the corner. Secondly, on the second judge, Madam Judge, thank you so much for the feedback. And that was a comment. And lastly, pour Madame la juge encore, respect de la souveraineté.
The judge who spoke in French, respect for sovereignty. Maybe there was a small confusion. What we wanted to say was that the intervention of the PAP in terms of implementation and follow-up of the implementation of the decisions on human rights, especially while using the national organs such as the parliaments, is a way to take advantage of the sovereignty of these organs. You see these organs, just like the mechanism on oral and written submissions. Each country has its own mechanisms. So it is a way of taking advantage of sovereignty of each country to ensure implementation. But this, of course, should not we used to question the legitimacy rather of the court. Thank you. Yes.
I ask you to thank the panelists. I had just two brief comments. This morning, Professor Nkata mentioned about the demographics of the youth in Africa, and I want to commend the participation. You know, having been in this space for the last 20 years, I can see the transition, and I think we should clap for the youth who are around here. Yes, I know the participants on the last 15, 20 years ago, and when I look at the new faces, I'm really encouraged. I thought I should mention this. And secondly, I had mentioned about my client, my friend, a victim, Mr. Kobe. I wanted you to be acknowledged to be here. Daniel, can you stand? This is the representative of the OGIEC. So when you are reading the OGIEC decision, you have him in flesh, blood and flesh. Finally, please, if you could thank our panelists with a big round of applause. And here I bow out, Madam Facilitator, you're welcome. Thank you, thank you.
I did say that I was going to do a quick icebreaker. So I will not let everyone stand because I know we're still very full, but I'll just ask randomly. The first question, describe how you feel currently using the weather. Let me see who I can choose. Let me go to the OGIEC community person. Describe how you feel using the weather. It's raining, it's sunny.
I'm feeling hot already. Very hot from everything I'm hearing. I'm getting hot every time. Thank you.
All right, thank you. The last question. How do you feel about the conference? Describe that using a color. Why did you say green?
Just green, just green, yes. Because really we have many new ideas, many new challenges, many new, yes, it's okay for me.
Okay. Agreed. Green. I know Justice Anukam says fruitfulness, which we agree. Now we can officially go to the session, the next session, which is session 4, comparative analysis on the challenges of implementation decisions of international human rights bodies. So this session will focus on the challenges of implementing decisions of the African courts for state and non-state actors. The discussions will be guided by a comparative analysis of implementation challenges of decisions of other international and regional human rights bodies, particularly the African human rights mechanisms, the United Nations, the Inter-American and European human rights system. So on that note, I would like to call on stage the chairperson of this session, Dr. Zainab Monisola Olaiton, who's a postdoctoral fellow, Center for Human Rights, University of Pretoria. And then I'd like to call on the panelist, Dr. Philippa Osim Inyang, who will be discussing the role of technology in ensuring stronger implementation of African court judgments, leveraging regional best practices. And Dr. Inyang is a senior research fellow in the Division of International Law at the Nigerian Institute of International Affairs. Last but not the least is Mr. Ikechukwu Uzoma, who is the staff attorney for Africa at the Robert F. Kennedy Human Rights. And he will be discussing the role of the reparation of public acknowledgement of responsibility in improving the impact of decisions of the African courts on human and people's rights, lessons from the Inter-American system. And this is to acknowledge Advocate Tom Nyaduga, who actually said that there were a lot of young people in the room. And to actually see 3 of them, young, vibrant, and also doctors. It's so scintillating. It's really beautiful to see. So over to you, Dr. Olaitan. Hello, everyone. How are you feeling? The food is still working. Thank you. So I would need your indulgence for the next 40 minutes, and then we can go for the tea break voluntarily. So this session would be on comparative analysis of the challenges of implementation of decisions of international human rights bodies, considering that most of the challenges that we talk about, the African human rights bodies have, they are not unique to the African continent. Other mechanisms also have their own challenges, and that's why we have this panel to also help us engage on that. The presenters have 12 minutes each, and then the floor has 10 minutes to engage with them, so we don't keep you further than you want to be here. Thank you so much. Dr. Philippa.
Your Excellencies, distinguished ladies and gentlemen, good afternoon. In its 2023 activity report, the African Court revealed that out of the over 200 decisions delivered since its establishment, only 10% have been implemented. What this means is that the majority of victims in these cases have yet to receive remedy or redress. Now, commentators, can you hear me now? I'll begin again. In its 2023 activity report, the African Court reported that out of over 200 decisions delivered since its establishment, only 10% have been implemented. This means that the majority of victims in these cases are yet to receive remedy or redress for violations of their human rights. Now, commentators, practitioners, scholars have mentioned several reasons for these poor levels of implementation. However, for the purpose of my paper, I focus on two primary challenges: the absence of a comprehensive, effective mechanism to effectively monitor state implementation of the African Court's decisions, and the lack of established compliance benchmarks, making implementation and compliance standards relatively subjective. Now, my paper highlights how technology can be deployed within the African Courts system to improve the monitoring and implementation of African Courts decisions and set appropriate compliance benchmarks. I draw examples from the European Court of Human Rights and the Inter-American Court of Human Rights. Okay. Now, under the European Court of Human Rights system, the Committee of Ministers, which is an intergovernmental body of the Council of Europe, composed of government representatives of 46 member states, is actually responsible for supervising the implementation of the European Court's decisions, much like what the Executive Council does for the African Court. Now, once the European Court delivers a judgment, the court transfers the monitoring of that judgment or of the implementation of that judgment to the Committee of Ministers. Now, from this point onwards, the progress of the judgment can be traced through the HUDOC execution database. Now, the HUDOC execution database is a database that was established in 2017 as an upgrade of the HUDOC database. The HUDOC database was basically a database where the European Court just uploads details of its judgment. But the HUDOC exec takes it a bit further. Instead of just uploading the judgments of the court, it now also details the implementation process of such judgments. Now, this HUDOC exec database, it provides a centralized, publicly accessible database that enables the public, including states, NGOs, and other stakeholders to track the implementation process of the court's judgment. What happens is that once the court issues a particular decision, the state is required within 6 months to upload or send to the Committee of Ministers its detailed action plan. The detailed action plan includes the steps it has taken or the steps that it intends to take to comply with the judgment. Now, all of these communications are uploaded on the website for everybody to see. Then stakeholders like the injured parties or their legal representatives, NGOs, CSOs have the opportunity to respond to these state reports, either confirming or, controverting whatever reports the states have uploaded online or the COM has uploaded on behalf of the states on the HUDOC execution database. The states also have what they call the right of reply to actually respond to these reports by these other stakeholders. Now, once the state executes all measure that has been detailed in the action plan, it then turns the action plan into an action report and then invites the Committee of Ministers to end the supervision of the implementation process. Now, available data from the Committee of Ministers annual reports indicates that since the adoption of the HUDOC exec database, there has been more than a 65% decrease in the number of pending cases in the European Court of Human Rights. Now, in the words of the Committee of Ministers activity report, I quote, the 2023 report, this is a clear indication that the improved transparency and increased involvement that the database provides for submissions and communications from civil society and other stakeholders have greatly impacted the level of implementation of the judgments of the European Court of Human Rights. I think there's a problem with the slides. I'll just go on without them. Now, the Inter-American Court of Human Rights has also adopted a similar pattern on its website, even though it's not as advanced as what the European Court of Human Rights has. It now takes responsibility for tracking and publicizing the implementation and compliance with its judgments. So it has begun to publish states and other stakeholders' briefs and submissions regarding implementation and compliance following the adoption of Decision 119 on clarifications on the publication of the information contained in the files of cases at the stage of monitoring compliance with judgment. Now, on the 1st of November 2023, the Inter-American Court launched a jurisprudence database developed with artificial intelligence, where users, the general public, can actually search and analyze its judgments, offering a streamlined process compared to traditional methods of sifting through clunky archives. So now stakeholders can utilize key searches, advanced search options, improved user interface features that enable the categorization of judgments, states involved, the violated rights, and the legal reasoning applied by the courts. Now, these tools enable the users to easily track and understand the reparations being monitored by the Inter-American Court of Human Rights and those already executed by the states. Now, these improved access empowers stakeholders to streamline their actions to pressurize states towards implementing the Inter-American Court of Human Rights decisions. There is no publicly available data at the moment on the measure of the impact of the deployed technology tools in the Inter-American Court system. But I think this is due to the fact that it is quite recent. I'm sure in the coming few years, we would see the impact of the introduction of these technology tools in the Inter-American Court. Now, for its part, the African Court has an advanced interface for publishing its judgments with good visualization of its data. But what is lacking are detailed records on the process of implementation of its decisions. It does not have an electronic database that can serve as a single repository like the European Court of Human Rights does, for recording all data on judgment and implementation in an organized format. Such a database is important, it's crucial actually, as it places such information on a publicly accessible platform, enabling injured parties, their legal representatives, and other stakeholders to track the status of the judgment implementation, fostering transparency, and providing a basis for analyzing the veracity of states' reports. Research has shown from the experience of the European Court of Human Rights that when states are inclined to actually implement or comply with judgments of international courts or regional courts, when implementation or compliance steps are made public. So a publicly accessible database, like what is obtainable in the European Court, is accessible to injured parties, to NGOs, to CSOs, to independent investigators, would create a platform for challenging misleading information and providing evidence of states' failure to take effective action. Now, what exactly does the African Court need to do to the website to enhance the use of technology in implementing human rights decisions of the African Court? You can begin by creating case profiles. Case profiles includes the publication of judgments on the African Court's website, together with the state's action plans, a clear outline for execution of those action plans, reports from other stakeholders, including injured parties, CSOs, NGOs, and the like. Creating a section for stakeholder engagement tools like the Inter-American Court has done, providing progress indicators, adding search and filter functionality features like the Inter-American Court has done, providing customized driven data reports. So this could include the implementation of data analysis tools that actually help to analyze implementation challenges that states commonly face, whether it's due to economic reasons, political reasons, the categories of rights that have been more violated than others, the amount of time that it takes for particular decisions or judgments to be implemented. The collation of this data can help, to actually provide a kind of benchmark for analyzing the level of compliance. Now, if these things are set in place, there are certain benefits that it can produce for the African courts in its implementation efforts. It can provide a level of visibility and transparency that will foster state accountability and help identify common implementation challenges that can inform policy changes and targeted interventions, can provide clear benchmarks and expectations to guide implementation and measure compliance. It can help determine implementation priority based on collated data, and can help promote the right level of engagement that can draw state attention and compel action. Now, despite the seeming benefits that having enhanced technology tools on the website can provide for the implementation of the African Court's decisions, there are some challenges that the African Court might face. One is financial constraints. Setting up and maintaining a database of this sort, with the data analytics tools that are proposed, require significant financial investment in technology, personnel, and the African Court may not be adequately funded for such a project. So to address this challenge, the African Court can consider engaging with tech giants like Microsoft, Alphabet, and IBM, as well as the major telecommunications companies that operate in Africa, to support the proposed project by financial donations or their tech expertise at training of personnel, as these companies offer such assistance as part of their CSR initiatives. Another challenge might be limited internet access. Internet penetration in Africa remains below the global average. As of this year, 2024, the global rate of internet penetration is about 62%.
One more minute.
Just about 43% in Africa. So this will invariably limit the access of so many people to this database. To address this concern, I recommend a complementary system for offline access to key information in the proposed database through downloadable reports or mobile applications. The Human Rights Measurement Initiative actually has developed this offline accessible data portal to provide comprehensive measurements to track the human rights performance of countries. So the African Court can actually adopt the HMRI's model. There's another issue of language diversity. Over 2,000 languages spoken in Africa. Such diversity can be a communication barrier in relation to the proposed database. However, the African Court can actually develop localized summaries of its judgments in at least 3 of the most widely spoken languages, and subsequently scale up to be able to reach a wider audience. Now, in conclusion, I state here that although there are real challenges that exist to the establishment of this database, the benefits of establishing a comprehensive and publicly accessible database for monitoring the implementation of the African Court's decisions outweigh the obstacles, I believe, by strategically collaborating with partners, with the relevant partners that possess the expertise, infrastructure, vested interest, and funding. The African Court can unlock new opportunities to improve the prospects of implementations of its decisions. Thank you for listening.
Thank you so much for that presentation. And good evening, ladies and gentlemen. Good evening, honorable justices. My name is Ikechukwu Uzoma, and I'm the Africa Staff Attorney at Robert F. Kennedy Human Rights. Robert F. Kennedy Human Rights is an international organization based in the United States that was established in 1968 to carry on the unfinished work of Robert F. Kennedy, who at the time of his assassination was running for presidency and was the past Attorney General of the country. We work with partners, most of whom are in this room, both in Africa and in Latin America. And given our activities or our engagement with partners in Africa and in Latin America, we bring a comparative perspective to our work. Most of our work focuses on strategic litigation and advocacy around civic space and other human rights issues. And of course, implementation of decisions of regional and international mechanisms come up a lot in our work. It's in that connection that today I present a paper on the role of reparation of public acknowledgement of responsibility and apology on implementation of decisions of the African Court. My topic, for the purposes of this presentation, I'd like to address a slightly different topic, which I feel is a precursor to the stated topic in the materials you have and what I just mentioned. I'd like to discuss the feasibility and potential impact of the introduction of the reparation of public acknowledgement of responsibility and apology to the reparations ordered by the African Court on Human and People's Rights, and to make that feasibility and think about the potential impact with lessons from the Inter-American Court. In general, as we've discussed today, the responsibility of states to ensure access to remedies for victims and survivors of human rights violations fall or flow from the positive obligations that states have to protect human rights, and by so doing to provide remedies when human rights are breached. And we know that there are 5 classes of remedies or reparations that mechanisms such as the African Court orders when they find a violation of human rights. It could be compensation, rehabilitation, restitution, the guarantees for non-repetition. But in particular today, I would like to focus on the satisfaction measures that are ordered by courts. The African Court and other courts across the world order satisfaction measures. And these measures of satisfaction could range from the orders to publish decisions of the court, the orders to identify the fatal remains of individuals who were either assassinated or individuals that were disappeared. So we see a lot of satisfaction measures being ordered. However, the reparation of public acknowledgement of state responsibility and apology is one of the measures of satisfaction that we find ordered across the world. And typically it goes alongside with other satisfaction measures, like I've mentioned, publication of judgments and establishment of memorials. And under international law, there are many forms of public acknowledgement of responsibility and apologies by states. We have the interstate apologies, where states apologize to other states for violations of the rights of their citizens. And we have many examples, including the apologies from the United Kingdom to the Maori population in New Zealand and a few others. But we also have interstate apologies or intrastate apologies, where states apologize to citizens for human rights violations that the states at some point have committed against those victims. And in the context of orders made by human rights mechanisms towards public acknowledgement of responsibility and apologies, we are talking about the intrastate apologies. As with many concepts, this reparation doesn't have, there's no consensus on the definition. But most soft law instruments that unpack legal provisions of treaties that establish substantive rights describe this reparation of public acknowledgement of responsibility and apologies. A key feature of the public apologies is to acknowledge the fact that the state is responsible for the violation, and the articles of state responsibility of international law presents this reparation as formal state apologies. The United Nations Basic Principles and Guidelines on the Rights to Remedy and Reparation describes public apologies as including acknowledgement of facts and acceptance of responsibility. The African Commission's General Comment 4 also mentions this, and there are a long list of other soft law instruments that mention this particular measure of satisfaction. The United Nations Special Rapporteur on Truth, Justice, and Reparations, Fabian Salvioli, preferred what he described as a more fulsome definition of public apologies for past human rights violations. And in his definition, he identifies elements of this reparation. The first element that he identifies is acknowledgement of the wrongful act. And then it goes further to say that it requires the public apologies must focus on addressing a specific wrongful act and not a generic reference to intermediate acts. Secondly, apologies require a truthful admission of individual, organizational, or collective responsibility. Next, apologies should include a public statement of remorse or regret related to the wrongful act or omission. They must be delivered with due respect and dignity to the citizen. It goes further and further, as you will see in the final paper. Now, what is the experience? Now, the point of departure for our study is the fact that in looking at the range of reparations ordered by the Inter-American Court on Human Rights and the African Court on Human and People's Rights, we realize that both courts order measures of satisfaction. But while the Inter-American Court orders this specific remedy on public acknowledgement of responsibility and public apologies, the African Court doesn't. So the study goes first to determine whether or not it is feasible for the African Court to include this reparation in its list of reparations. And the reason this is important is because studies have been conducted, and this was recorded in the African Court's comparative analysis that was published in 2019, that this particular reparation enjoys the highest level of implementation in the Inter-American system. And in the Inter-American system, as we have mentioned today in terms of the numbers, we find that there's a 36% full implementation of decisions by the Inter-American Commission and by the Inter-American Court, and 14% partial implementation. And in the Inter-American Commission, we have 64% partial implementation and 12% full implementation. So when you stack the numbers in the Inter-American system with the African system, you see that it seems like they are doing a bit better. But it may be because of the types of remedies that they order. And in that regard, we question whether the inclusion of this remedy may actually help with implementation. Now, what is the experience in the Inter-American system? Now, since 2001, the Inter-American system, the Inter-American Court in particular, has ordered these remedies. In fact, in the Altos case against Peru, the court ordered that the state should include the resolution ordering the publication of the agreement, a public expression of apology to the victims for grave damages, costs, and ratification of willingness not to allow this type of event occur again. So the courts, in its routine, when you go through decisions of the court between 2001 and date, you would find that there are over 30 cases where this reparation has been ordered. I have all of them here, but I can't go through all of them. But just to mention that over the years, the court has also added more detailed qualification to the public act of recognition and apology, including the requirement for the public act to be done in the presence of the victim's family with the participation of the highest authority of the state, that the act be done in the official language, but also in the native languages, and that for it to be a live event. Now, with the goal of making this also a non-repetition measure as well, the Inter-American Court has ordered the public act of recognition of responsibility to be broadly disseminated. And as observed from the case law, the Inter-American Court has not only embraced the importance of state acknowledgement as a form of redress for victims of human rights violations, but has given additional instructions to ensure that it is done not like just ticking the box, but is actually done to reach the victims. Again, one point to mention is the fact that satisfaction measures as a whole, a significant role in actually redressing the harm caused.
1 minute.
To one? Fantastic. In redressing this harm that is caused. So, and it's important. On the feasibility, we developed a 4-factor framework to check feasibility. And this includes the normative foundation, procedural and practical receptibility, presidential authority, and dignity and political context. Normative foundation is we check the normative foundation of the Inter-American Court and the African Court. And we try to see if everything is similar on both sides, then introducing this remedy may be feasible. We checked the procedural and practical receptibility of introducing a remedy, and we saw that the African Court has used its inherent powers, has used the decisions of the Inter-American Court, has adopted the interpretations of the African Commission in its jurisprudence. And the African Commission has indeed ordered public acknowledgement of responsibility and apologies in communication 393/10 IHRDA against the Democratic Republic of Congo. So we go through all of that. Then the third one, we look at presidential authority, which is what I just described, but also looking at desirability and political context. In these other three parts of the framework, we find positive correlation between the practices in the Inter-American system and the African system. And it's our way as using this as proxies to determine whether or not this reparation can actually be introduced and if there are any limitations, and we find no limitations. And then finally, in terms of desirability, that is to say, do victims desire this reparation? Do they ask for this reparation when they approach the court? Because the court, even though it uses its inherent powers, as it did in terms of the publication of decisions. Now the court orders publication of decisions in most cases, but the first time it ordered it had to do that by its inherent powers. And I think it was in the Norbert Zongo case. And so do these victims and survivors request this? And do they, within the context of the, so we developed this construct called the reparations triangle that has the state at the top, the victims on the left, and the mechanisms on the right. And in the normal course of reparations, they flow from the states to the citizens, to the victims. And the mechanisms put pressure on the states for reparations to flow as human rights, as the human rights relationship is developed. When violations occur, we created a concentric triangle within that reparations triangle, which now pushes pressure from the citizens or the victims to the mechanisms, and the mechanisms put pressure on the states for the reparations to flow. So the question we try to determine is whether or not the states are willing to make this reparation. That we looked at state practice. Have states in Africa ever apologized for anything? And we find slim examples of apologies, but mostly in the realm of international humanitarian law. And then we ask, do the victims or do the survivors ask for these remedies when they approach the court? We do all that analysis to check, the political will and the political context within which the courts operate. And we come to a set of conclusions, and I'll wrap up now. We come to a set of conclusions which include the fact that litigants and stakeholders on the demand side have a great role to play in ensuring that these reparations are ordered. Relatedly, states must, in the flow of their responsibilities to their citizens, ratify the protocols for the courts and make the articulated 4.6 declaration, because we argue in our paper that the failure of states to make that, and someone has mentioned that, to make that declaration actually limits access to justice for their citizens. And we want to argue that the access to justice should be, expanded that much. And then for the court, in implementing or using its inherent powers, in relying, because in the first decision of the court, first reparation decision of the court referred to 6 decisions of the Inter-American Court, and the court continues to, consider the decisions of the Inter-American Court to draw inspiration where it sees fit. And we are increasingly seeing also on the other side, the Inter-American Court identifying decisions of the African Court in its own deliberations. And so we see that the African Court can in its inherent powers, introduce these remedies because we believe that it has the impact that we have seen it have in the Inter-American Court. So I hope we are able to complete this paper at some point and have you all engage with it, because we do believe that this remedy is one that, if included, would definitely have an impact in terms of addressing the the violations that are being done, but may also have an impact on implementation broadly. Thank you.
Thank you so much, Ikechukwu and Dr. Philippa. The floor is now open for questions. Of course, the African Court has the first right of reply. Okay, Justice Stella, you can go.
Thank you very much. I just wish we could further applaud the paper presenters. They have done very well, and truly I can see a generational shift for good. My first question, perhaps also a comment, is to the first presenter, where she talked so much about the HUDOC database. And my concern is this: does she not think that it has such a high level of acceptability because it is driven by the Committee of Ministers, not the court? Because it seemed as if she was giving us that responsibility. Whereas we also have a body, by virtue of our protocol, equivalent to the Committee of Ministers, which is the Council of Ministers. Because indeed, in the European Court on Human Rights, we actually have visited the court. We are a sister court, you know, and we observe that the Committee of Ministers is a whole full office of its own, independent of the court. It's a standalone. So the responsibility of the court is just to deliver its judgment, and that's it. So it transcends, it now goes to the Committee of Ministers to see to its implementation. So giving us that responsibility, I think, is an extraneous one to start with. Resource availability, as she has rightly noted, and also I think it's beyond the mandate of the court. I so submit. Thank you.
Thank you. Let me associate with my sister and congratulate our young presenters for the good work done. My first comment is on the remedies that the courts award. We know that the African Court, we have reparation, restitution, rehabilitation, satisfaction, guarantees for non-repetition. Then we have injunctions, declaratory. We have all these things. But it is the circumstances that will permit you to grant or award any one of them. For example, in the European Court, the just satisfaction is premised on violations that is violation that aim to provide a sense of justice and recognition of harm suffered. So here it is about when they see that, yes, your human dignity has been violated to the extent that even after compensation, the state must come and say, we are sorry. And so there is a bit difference between the cases before the African Court now and the cases in which the European Court administer just satisfaction. Then my second one to my lady. Yes, you talk about our database being inadequate. As a result of that, we'll find it difficult enforcing our judgments. But that is not the case. The case is this. If you look at our system, we have the executive committee. They have only one power: to monitor the implementation of the court's decision. They do only one. But let's look at what the Inter-American, the Council of Ministers, they do 4 things. 1, to monitor the implementation of the court's decisions. Number 2, request information from states on measures taken to comply with their decisions. Number 3, adopt resolutions and decisions to ensure compliance. Then the 4, impose sanctions on states that fail to comply with the decisions, because they have these powers. And therefore, if they have them at their website or in their database, it gives them information that this country has failed and we can do 1, 2, 3, 4. Unlike ours, where they have only the power to monitor. That is all. So in that case, how do we address it? Thank you, moderator.
Justices, any other person questions before I? Okay.
Merci de me donner la parole.
Thank you for the floor. I would like to clarify certain issues following the presentations, because it is worth noting that out of these presentations, we see that monitoring mechanism of decisions from the African Court is not well known. In the first presentation, for example, we have seen that they have insisted on database, that within the African Court, especially within the registrar's office, there is a database that was put in place and is actually being finalized, and has the different decisions and the different states where the decisions were issued, and also has the different measures ordered. There is also at the level of implementation, and this is present within the registrar's office of the African Court. So this is underway, and recently it was presented for finalization. So there is a real evolution with regard to the monitoring mechanism for the implementation of decisions of the African Court. I would also like to say that during the presentation made by the focal point from Malawi, he said that collaboration with the focal point is not yet up to the point. So I would like to correct a little bit on that point, that since the court received the list of the focal points of about 22 focal points, the court organized on 20th May a meeting, the first meeting with the focal points to discuss a framework document to formalize the working relations with the focal points, because it was the registrar to orient the focal points on the scope of their commitments or of their functions. And during that meeting, this draft framework document was sent to the different focal points for comments. And some states have already sent back their comments. For example, Tanzania, Ghana, Senegal, all sent their comments already. Therefore, this commitment with the focal points is already underway, and to strengthen their capacities, be it in such online or physical sessions. The registrar is also trying to issue the different instruments to the national focal points. And all this is geared towards strengthening in a continuous manner the collaboration between the court and the national focal points. Therefore, there are already some efforts that have already been mobilized and underway with regard to the monitoring and implementation mechanism of the African Court. So you need to regularly visit this website of the African Court, and the focal points are quite clearly noted there. So this was just to clarify, to show that our presence here also is to ensure that we clarify any information that you might not be having or might not have received in the different communications. Thank you.
So I would give the presenters 1 minute each to just respond so we can wrap up this panel. Thank you.
Okay. I'm sorry to take the floor again. I just want to ask one more question so that the response will be together. This is regarding the second presentation. And in asking my question vis-a-vis this presentation, I want us to look again at Article 27 of the protocol, which says if the court finds that there has been violation of a human or people's right, it shall make appropriate orders to remedy the violation, including the payment of fair compensation or reparation. And my question is, yes, we do as a court do appreciate satisfaction as a measure of reparation. But the question is, will the applicants be satisfied if only the respondent state is asked to apologize? We do see, like in the Ogie case, there were a lot of reparation methods that were requested for, including apology, public apology. But most time it's not a standalone. It's in the midst of so many others. So it's not, you cannot generalize that the African court is not making good use of that measure. We do, but most time it forms part of other reparation methods that we do order. Just to reiterate that point. And also to ask if it candidly thinks that an applicant will find satisfaction as sufficient remedy for a violation that in most cases is very grievous. I thank you.
Thank you very much, Your Excellencies, for your comments and your questions. I agree that it is not the African court that has the mandate under the protocol establishing the court to implement its decisions. It's actually the Executive Council. And I think I mentioned that, although briefly and in passing, when I was speaking about the European Court of Human Rights and the Committee of Ministers with the HUDOC database. And I think the Executive Council has already sort of begun this process of establishing this database with the framework, the draft framework on execution. I know that they actually gave the African Court the task of meeting up with engaging a consultant to come up with the framework, and one of the suggestions of the consultant was the depositing of the state reports and CSO reports into a specific database, but it doesn't actually elaborate on what features this database should have. I think this is one of the reasons. I expand on this in my actual paper, but because of time, I couldn't include that in my presentation. So what I'm proposing is that this database that is envisaged by the draft framework could actually be developed to, be somewhat like what the European Court of Human Rights has with the HUDOC executive database. I know that the Executive Council may not have the powers for enforcement, but my suggestion for a publicly accessible database is not necessarily for the Executive Council to enforce after reviewing the publications. It is the power of scrutiny that the public database has, that I propose would serve as a kind of influence on states who want to sit up and do better in their implementation process.
Thank you, Honorable Justices, for your questions and comments. I take the first comment around just satisfaction and the appropriateness of applying the remedy depending on the facts of the case. I would argue that in most of the cases where the court has ordered the states to publish the decisions or has ordered the states to make some legislative adjustments, cases that have to do with the killing of journalists or human rights defenders. I think strongly about the Norbert Zongo case and the others. I believe strongly, and an argument can be made and sustained, that in these circumstances, public apologies and acknowledgement of responsibility would have gone a long way to further redress the wrongs or the violation against the victims, and in the case of some of them, against the families that had lived without them. So I think it's arguable where this remedy in particular would be found to be appropriate as the protocol provides. However, the overarching general principle of international law is that the remedy is effective, and the effectiveness of a remedy goes to the heart of the heart of the impact of the violation. And most times when other forms of reparations may not address the hurt or the impact, measures of satisfaction do, and in particular, we argue that this particular measure does. And to the question by Honorable Justice Nokam, I agree with you wholly that in the practice internationally, and as we've seen also with the African court, is to combine measures of satisfaction with other remedies. And we've argued and we support the literature that states that measures of satisfaction alone cannot sustain the threshold for effective remedies. And so they go hand in hand with other remedies. However, in the particular Ogek case, and I'm glad that the Honorable Justice mentioned this, that the applicant's prayer for apology was, the applicant made a prayer for apology. I'd like to read the court's decision. It said, in respect to the applicant's prayer for public apology, the court reaffirmed that a judgment can constitute sufficient form of reparation and also sufficient measure of satisfaction. In the instant case, the court held that the judgment both on merits and reparations are a sufficient measure of satisfaction, and that therefore it was not necessary for the respondent state to issue a public apology. The same, and the court reached the same decision around a public monument and a few other remedies. But this exactly is the point that we're making, that in the Oge case, for example, and I'm glad that the representative of the community is here. Maybe we can ask him if he would have loved a public apology. But this, in this context exactly, is where I urge the courts in their wisdom and in keeping with their history of engaging their inherent jurisdiction to push the needle a bit further. In one of the cases, and I'll just wrap up with this. The IHRDA case communication against DRC, where the commission ordered this remedy. No. In the Norbert Zongo case, there was the respondent states, in response to this remedy, argued that remedies or reparations should not embarrass the states. And the court engaged on that question, but went ahead to order the publication of the decision, as that was the remedy. I think with respect to violations, the potential for embarrassment of states would rank quite lower than the impact of decisions for the victims. And that's why we urge the court to consider this reparation, because indeed it goes far to make the other reparations ordered really have the effect that on international law we would want to see. Thank you.
Thank you so much, everyone. Can we give them a round of applause, please? Thank you. And we move to the next session.
Thank you very much. So can we please give the panel session, the young generation, another round of applause, please? So as you would have noticed on the program, we had actually skipped tea break. And this is really because I think we are following Justice Shafika's notion that the mood is green, and we are worried that we don't want to break that. And also in the interest of time, we would just proceed to the final session for today. But just before I introduce the session and call the panelists and the chair of that panel, I would just like to say that we've got tea and coffee outside. We can just go one and just take, but we are continuing the session. We are not having like an official tea break, but just to say it's there just in case if it is absolutely necessary. So this last panel session for today is quite an interesting one because it is really a session that we try to bring together the very essence of this conference, where we want to listen to the body that issued decisions, and we want to listen to the people that participated in the case, and we also want to listen to the opinion of academic scholar. And that is really what we are going to see happen during this panel session. So for this panel session, it's a very unique one to us because you would have noticed by now there have been a lot of references to the Ogier case, and Advocate Tom Yandugad said someone is his client. And now we are actually going to move to that phase where we can engage in all of this discussion. So this panel session is on the role of the African Court itself in monitoring the implementation of its decision. And for this session, I would like to invite Honorable Justice Ajay to the podium. Honorable Justice Ajay of the African Court. Can we please give him a round of applause? And also, I would like to now call upon, I think, someone who is fast becoming the most popular person in this room, Mr. Daniel Kobe, who is a representative of the Ogiek community. Oh. Maybe he's getting overwhelmed by the popularity. So while we wait for him, I would then call on our two academic paper presenters, Dr. Raisa Njurogo, who is a postdoctoral research fellow at the Center for Comparative Law in Africa at the University of Cape Town in South Africa. Can we please give her a round of applause? And then I would call the other academic presenter that we have for this session, Dr. Asin Nene, who is a teacher researcher in public law at Alassane Ouattara University in Bourg, Côte d'Ivoire. Can you please come to the podium, Dr. Nene? Can we please give him a round of applause as well? So I would then invite the final person, Mr. Daniel Kobe. I think you're back in the room. Can you please join us on the podium? I think there's been a lot of attention to the Ogier case, and there've been some express requests from you. So maybe you do justice to that for us in this session. Please come to the podium. Can we also give him a round of applause, please? And last but not the least, I would like to invite the chairperson for this channel, for this panel, Dr. Tarisai Muntagi, who has tried to unpack political will in the morning. I think it will also be interesting for you to chair this session. Thank you. Can we please give him a round of applause as well?
Thank you, Director of Ceremonies. It's becoming stylish to associate yourself with a younger panel. As you can see, it's getting younger and younger and younger by day. It's my pleasure to moderate this session on the role of the court in monitoring implementation of its decisions. May I add a comment that is the tragedy of our times, that a court must render a decision and then have still the responsibility to ensure that it is implemented. The courts speak through decisions, and we expect that once a court has spoken, everything must fall in line. Everyone must comply in terms of the timeframes and the specific measures that the court has ordered. Nevertheless, that is not the case. We had since morning that the court has a role to monitor implementation of its decisions. But let me give an opportunity to our panelists to share with us their ideas. I'm told that not more than 10 minutes. Judge, I apologize if I have to cut you off during your speech. I won't be in contempt. We just want to ensure that we finish this in time. Let me first of all call upon Dr. Raisa Nyirongo in terms of the order of speaking, who will come. She is a postdoctoral research fellow at the Center for Comparative Law in Africa, based at the University of Cape Town. And she'll be sharing with us the paper towards effective enforcement, analyzing the proposed monetary framework of the African Court on Human and People's Rights. Doc, you've got 10 minutes. Thank you.
Good afternoon to everybody that is here today and all protocols observed. My name is Raisa Nyirongo, and as mentioned, I am a postdoctoral fellow at the Center for Comparative Law in Africa at the University of Cape Town. Today, I'll be speaking on the proposed monitoring framework for the African Court on Human and People's Rights. I do have a PPT, but I will go ahead without it, just so that for the interest of time. So the proposed framework for the monitoring of the implementation of decisions of the African Court of Human and People's Rights was presented for adoption a few years ago, but to this date has not yet been adopted. And the matter of compliance, the matter of Okay, I thought I was loud enough. But the matter of compliance, the matter of implementation and monitoring continues to be a matter that affects a lot of decisions in African regional integration. So when the draft framework was actually put forward, I found this as a very big step forward, as a very, very important step towards actually making progress in this issue. And so what I'll be looking at today and what I'll be touching on is just looking at this framework that has been proposed and analyzing its strengths and its potential weaknesses. So just to go through it briefly, just in case not everyone has had the opportunity to read this draft framework. So what the framework proposes is the establishment of an implementation and monitoring unit within the court. And this unit would then be exclusively responsible for monitoring implementation of decisions of the court. And so the unit would be responsible for communication of decisions to the parties, to the Executive Council, and to any other relevant African Union institutions as well. And then what the states would have to do is to submit a report to the report on the progress that has been made. However, a timeframe as to when this report should be submitted hasn't been included within the framework. And then so what the monitoring unit will also do would be to classify cases depending on the gravity of the case as to whether the case needs to be subject to enhanced monitoring or to standard monitoring. So depending on the gravity or severity of the case. So a state can request from the African Union organs any assistance it might need. So what the court would do would be to notify the state of different organs or institutions of the African Union that might be able to provide assistance to the state towards complying. So then once the state has submitted its reports, the monitoring unit would then have the responsibility of determining whether a state has actually complied fully, partially, or not at all. And so the unit can also hold compliance hearings as well. I think we heard about this earlier. They can conduct site visits, and then they can also request reports from other stakeholders. And then once the unit or the court has made a decision as to the compliance of the state as to whether it's fully, partial, or not at all, the matter is then handed over to the Permanent Representative Council and the Executive Council to make further decisions. And so this is in line with the protocol that exists. And so with the Executive Council and with the Permanent Representative Council, it's not that once the decision has been received or the report or the status on the status of compliance has been received from the court, it's not that the Executive Council then just makes a decision whether you have complied or not, but there are different avenues that would then be available through the Permanent Representatives Council for the state to further comply if they haven't. So they would look at, for instance, the possibility of establishing a fund to assist the state to comply, and also looking at things such as whether or not there was any consultations with African Union organs and whether there was any interventions. But ultimately, the decision as to whether or not a state has complied and also the measures to be adopted if a state hasn't complied falls to the Assembly. So the Assembly has the authority to implement sanctions. So in analyzing this system, this proposed framework, I looked at it from an angle of compliance system or the design of a framework or a system in a way that can promote compliance. And so what this compliance system has, it has three components to it. So it has a primary rule system, a compliance information system, and a non-compliance response system. So with the primary rule system, it focuses on the actors, the rules, and the processes that must be followed in order to achieve the objective. In this case, the implementation of the decision. And then the compliance information system then focuses on the collection and the dissemination of information relating to the compliance or the implementation of the decision. And then finally is the non-compliance response system, which looks at what happens or what is done in the case that a state has not been able to comply or to implement a decision. So in looking at the proposed framework, there were some strengths that I had identified, which is, first of all, the drafting of this framework in and of itself is progress. So as mentioned, that there isn't necessarily a framework that exists at this point that enables this type of monitoring and detailed and clear process to monitor. So the existence of this draft in itself, even though it hasn't been adopted, is progress. And then also within the draft, we'll see that there's a very detailed procedure of steps that are to be followed from the time that a decision is communicated to the member states to the time that it is finally decided or dealt with by the Assembly, whether or not there's a need for sanctions or whether or not there's been compliance or not. So there's a very clear steps that can be followed. Additionally, there's flexibility that you find within this draft framework. So for instance, states can request extensions in terms of the time frame or the time that they have to submit a report, but also there is a possibility of funding, there's a possibility of financing. And this flexibility is important because it does also reflect the differences that exist in the member states that are impacted and the different circumstances that they find themselves in. Additionally, there's also the multiple avenues that are used to gather information. So not only would the state report, but then the court would be in a position to request reports from different stakeholders, therefore giving the court a a broader overview as to what the actual state of compliance and implementation is. And then also there is a clear step and processes to be followed in the instance that, or after the state of compliance has been assessed. That being said, through my analysis, I did identify a few weaknesses that can be improved upon so as to further enable this system to promote compliance and implementation. So first of all, when we look at the primary rules system, one thing that I noticed in the framework is that there is no time frame indicated as to when reports should be submitted to the court. And so this can be problematic because it's discretionary then to a state. And so different states can interpret this very differently, which can also then have an impact on the duration as to when compliance is actually finalized or when even interventions can start taking place. Another aspect of the rule system was that the framework requires an execution report rather than an action report. And so the difference between these two would be that with the action reports, the state is reporting on the progress that's been made towards compliance. But with the with the execution report, it would be reporting on the progress that's been made, but an action report would be a preliminary report on the state or by the state indicating what steps it will take for it to actually implement the decision. And so such a report can be very valuable for the court, but also for the member state in itself to be able to identify where it might need assistance, what the weaknesses might be in its system to actually complying with the court's decision. And then also another weakness that was identified in the rules system is that there wasn't any clarity, at least in the framework document, as to how cases will be clarified to say this one requires enhanced monitoring, this one requires standard monitoring. I think it only states that depending on the severity of the case. So that was also a possible weakness that could lead to ambiguity. And then in terms of the compliance information system. So as mentioned earlier, and this also links to the primary rules system, is that the initial report would be an execution report.
Yep.
So this
3 minutes.
I will finish. So this also creates the weakness that there isn't time or opportunity for the court to be able to see where the gaps might be, where the challenges might be actually, and where interventions might be needed to help the state to comply. And then in terms of the non-compliance response system, once the state of compliance has been determined, it shifts over to the executive organs of the African Union. And so the court in that instance has very limited authority, so which is the reality that we find ourselves in. So in terms of these weaknesses that were identified, I have a few recommendations. That might seem simple, but I do think that when it comes to African integration and African integration efforts, doing the basic things can have a very big impact. So first of all, I would recommend that there's a clear provision for a time frame that is indicated within the framework. So I understand that the court's decision will already indicate the time limit within which a state should comply. However, the time frame in the monitoring framework would be a time frame to indicate from the time that you receive the decision, how much time do you have to submit a first report, or how much time do you have to submit the execution report? Then at least in that way, the court is also able to assess where or how the situation might go, or where the state might need assistance. And then also just having a clear category for categorizing cases as whether they'll need enhanced monitoring or standard monitoring within the framework as well would be very useful. And then thirdly is to require an action plan. So the framework mentions an action plan, but it is optional. So a state may submit an action plan, but rather what is required from them is an execution report or an execution plan. So my recommendation would be to actually require an action plan. And I think this has worked really well with the African peer review mechanism, because the states have to go into a process of assessing their national ability to meet the requirements of the African peer review mechanism. So I think this aspect can also be adopted to help the state to analyze and to assess its ability to actually comply, and also determine if there's any assistance that would be needed, where will it be needed from, and how can the African Union organs and institutions come in to assist. And then also an issue of capacity for the court. And so from my understanding, the reporting unit would be established specifically to focus on this. And so I would then recommend that the units be staffed to kind of meet the needs for monitoring its decisions. And then also I would recommend, as earlier mentioned, just an introduction of some sort of peer review element to the monitoring framework, just to enable states to be able to learn from one another, as other states might comply and make changes in ways that other states could actually learn from. And then lastly, and this is not something that the court can do, but perhaps something the court can include within the framework, is the provision of positive sanctions or positive sanctions for states. So if a state has been found to not have complied with a decision or to not have implemented, perhaps recommending positive sanctions or decisions that can be taken to provide assistance to the state. So I think a lot has been mentioned today about capacity of states, be it from a human resources perspective or finances perspective, but having some sort of positive sanctions that can then be put in place to assist the states to comply. Because as was also mentioned, there are states that would like to comply, but they are limited in their ability to do so. And so as the court and the African Union framework as well, there can be elements that they can assist to actually help states to comply. So in as much as the responsibility or obligation to comply is on a member state, I do, and it is my opinion to say that the framework for regional integration should also assist states to comply. But that is the end of my presentation. Thank you so much.
Thank you, Dr. Nyarongo, for highlighting to us some good aspects of the framework that the court has adopted, as well as some areas of improvement where you think that can be done. Now that is pending for formal adoption, I'm sure that the court will be able to read in some of those amendments that are necessary to make it stronger, because I don't think withdrawing it and resubmitting will be probably an option. But that's not for me to answer. It's for our colleagues from the court to chip in later. May I quickly move on to call upon the Honorable Judge. He is my father-in-law. He will tell you why, but he's here to take us through the role of African Court in the implementation of its decisions. Thank you.
Good evening. Yes, he's my son-in-law. And inference, you can make inference. Ghana, Zimbabwe. Yes, I will not read my paper because it is a bit voluminous and I have only 10 minutes. So I'm going to talk about the salient points. The first one that we would like to address is that the court is created by a treaty. And if you are created by a treaty, you must operate within the treaty. Otherwise, you'll be acting ultra vires. The treaty has established the court. It has given the court the power to adjudicate and deliver decisions. The court delivers its decisions. When it comes to enforcement, then it becomes a problem. So what do we do to ensure that these decisions rendered by the court are enforced? Let me talk briefly about the essence of treaty and why our decisions should be enforced by the state parties. If you look at the Article 26 of the Vienna Convention, it says that every treaty in force is binding upon the parties to it and must be performed by them in good faith. So here, the state parties, you have established the court and you have assured everybody that we shall comply with the treaty in good faith. And that is why if you look at the protocol, it is a bit scanty. Now, we have the basis, the judgments have been delivered, enforce them, then they are not enforcing them. And if you look at the treaty, it says that if judgment is delivered, the AU and all the parties, state parties shall be served with the judgment. we comply, we serve the judgment. It is up to implementation and enforcement. And the enforcement is to be made by the state itself. The enforcement is to be made by the state itself, to be monitored by the Executive Council, the Council of Ministers. So here, the Council of Ministers too, they do not have authority, strong authority, to say that you have not done A, B, C, D, and therefore we are going to sanction you, as pertains in the Inter-American and the European courts. They have strict legislation saying that if they fail, they can sanction them. We don't have these provisions. So what do we do? That is why in the wisdom of the court said that if you are reporting, if we must report, yes, we are going to report. So what do we do? To inform the Council of Ministers, the Executive Council, that indeed we have, that judgment has been delivered, the state party has been informed, and before that, the state party took part in the decision, the rendering of the decision. Either you came or you did not come. The position was that at any stage, whether it is even judgment in default, the state is notified. So the state knows the progress report of the case from the beginning to the end. And at the end, you have been notified of the decision of the court. Now, when it comes to the monitoring, what the court has introduced into the rules is compliance hearing. Now, we are going to take evidence to ensure that the judgments delivered have been complied with. Then we inform the Executive Council. At times, some states which are not willing to comply with the laws may say that, oh, the decision is against our fee, the decision is against this. This position is not acceptable in international law, because international law, the law is that at the moment that you are ratifying a treaty and you have a declaration or reservation, you must make it there and then. If you look at law like the International Covenant on Economic, Social, and Cultural Rights, Egypt, Algeria, at the time of signing, they deposited declaration to the fact that any interpretation that will affect Sharia law is not acceptable. And if you look at ICCPR, Gambia, Article 14.3, Gambia deposited a declaration that we can only provide free legal assistance in cases of capital punishment, and therefore others are not binding on us. You did not take any reservation. You did not make any declaration. Then the judgment has been rendered. Then you are saying that it cannot be enforced. Why such a judgment cannot be enforced? Is there any justiciable ground? There is no justiciable ground. And therefore, the judgments delivered by the court does the compliance hearing, then it is given to the Council of Ministers or the Executive Committee. They must ensure that the judgments are enforced. At times, some countries may come to say that the operative part of the judgments are not clear. They are a bit ambiguous. And the court would interpret, and one of them, the one from Côte d'Ivoire, it was a bit funny. They wanted the court to review the entire judgment instead of talking about the operative part, which was unclear. And the one from Kenya, the Kenya one, he said, yes, use all available measures to enforce this one. Then they asked, what is the meaning of that one? The court interpreted, even though it was basic, yet the court went ahead to interpret. So if the court does all these things, comprise with all the requirements of the charter, the ICCPR, Universal Declaration, as well as the protocol and the judgment, we've done compliance hearing and we submit to the Executive Committee, and it is left with enforcement. What do we do? It is about number one. Number one is that we do not have we must have political will, because we have entered into our own treaty by saying that this treaty is binding on us, and any outcome of the treaty shall bind us. And a judgment has been delivered, and the law says enforce it yourself, and you are not enforcing it. What do you expect the court to do? And what we must understand is that when people are aggrieved, they come to courts, they file their application, they go through the trial, they get their judgment, and they cannot enjoy the fruit of their labor at the end of the day. Wouldn't that even prevent people from seizing the court? It will prevent them, because what they will say is that I will go through the trial, I will get everything. At the end of the day, the judgment will not be enforced. So we are here this evening saying that once the court has done and prepared its basic rules, basic norms, and it has exhausted the available procedure within the court and delivers its judgment, and the judgment is submitted, the court's power ends there, because the protocol that created us did not give us power to sanction anybody, and we cannot sanction. And therefore, we urge every member here that the Council of Ministers and our own head of states, our own presidents, what do we tell them? To respect their own treaties. If they fail to return their own treaties, then the establishment of the court will not be of any importance to Africans who may seize the court and potential Africans who are willing to seize the court. How many minutes? All right. So on the whole, the court complies with the regulatory framework. It makes sure that its decision is clear, unambiguous. Then if it is clear interpretation and the court is seized, the court would interpret. When the court does the interpretation, then it puts in all the mechanism to enable the state to enforce the decision rendered against it. Then when we give some judgment, we give time frame. For example, where you are to amend your law, we know that you cannot amend your law within a week or two. So in most cases, 1 year or 2 years, enough time for you. Even if you start and you are unable to complete within the time, you must come to the court and ask for extension of time. This they don't do. And when we ask them to pay reparations, compensations to victims, some they will not pay. And we have stated that if they fail to pay, it shall attract interest. Even the principal will not pay. The principal will not be paid. What about the interest? So the whole thing will not be paid. So here, what we are saying is that without the assistance of body like you, appealing to our presidents, our head of states, and appealing to Executive Council that you have set up your court, obey the treaty, you accepted to comply with any decision rendered by the court, and all the decisions by the court are enforceable. They are enforceable. Nobody can say that we have delivered a judgment that is not enforceable. All the decisions are enforceable, and therefore they must ensure to comply all the decisions of the court to support the basis upon which the court was established. Otherwise, it will suggest that the court was established to satisfy UN that Africans will respect human rights. But in reality, you respect human rights, a decision has been rendered, and you are not complying with it. Is that the position of the law? And the answer is no. We must respect our treaties and the orders of the court. Thank you.
Thank you, Honorable Judge, for your remarks on the role of the court in the implementation of its decisions. They have shared with us the good faith principle and what the court is doing to monitor execution, compliance hearings, and the competence of the court to interpret its own decisions. But you ended up with a clarion call to say all stakeholders who are gathered here should do their part to remind states to abide by their legal obligations that arise from the treaties as well as from the decisions of the court. Thank you very much. Let me move on to call upon Dr. Asen Nene to speak on the African Court on Human and People's Rights, the agency of an emergent reform. There's a bit of semantics there, some rhyming language. Please, you have about 10 minutes.
Mesdames et messieurs,
ladies and gentlemen, all protocols observed. I would like to greet you, taking into consideration the fact that we don't have time. I reviewed the title of my presentation. I also reduced it in terms of pages. So the new title is going beyond the resistance of the states with regard to the execution of the decisions of the court, going beyond the resistance by the states to apply the decision of the court. We've been reminded today that the monitoring mechanisms with regard to the decisions is ensured by the Ministerial Council that reports to the Conference of the Heads of State. The issue is that the mechanism as it is not functional for the simple following reason. The Ministerial Council and the Summit of the Heads of State, with regard to the states that are not party to the protocol to Ouagadougou and were not accepted this mechanism, we have a system where the states that refuse to adhere to the African court makes it very hard, actually, to sanction this kind of states. So in this kind of states, how do we have an efficient solution? That's why I would like to talk about the contribution of the African court, going beyond the decision of the resistance of the states, simply because the states are not answerable before the court. Now, how do we ensure that states execute the decision of the court? According to us, the execution of the decision of the court incumbent on the capacity of the African court to ensure that the states understand these obligations. The court needs to convince the states to actually go beyond this resistance, to understand the importance of the execution of these decisions. And of course, we cannot, the African court, force these states to execute these decisions. And we need to cultivate this culture of implementing the decisions, encouraging the countries, the states, to implement the decisions. The court cannot force the states, but only rather to persuade, to encourage the member states. It's these member states that thought it was necessary to create this court, and the court, of course, has to convince the states on the well-foundedness of implementing these decisions. And with regard to Article 28 of the Protocol of Ouagadougou, this is very important to convince other states and facilitate the implementation of the decisions. But sometimes the court does not have enough arguments to convince the states to execute this. The lack of motivation leads to the non-execution of these decisions. Madam Judge this morning talked about the issue of sovereignty. I'll come back to this issue because I have a certain number of questions that I would like us all together to get solutions. Finally, now with regard to the court, we have people whose rights are violated and who are not in a position to get a reparation, given that the states are not in a position to actually execute these decisions. And we need to ensure that the different actors at the state levels are sensitized to understand these decisions. The national courts can actually back jurisprudence on the different cases if they are well sensitized on this. And there is just an opportunity for learning with regard to the different jurisprudence given by the courts. For instance, in the decision with regard to the case relating to Benin, the court decided to enjoin the Benin to postpone municipal elections. As a professor of law, I asked myself a certain number of questions, the link between the international law and the national law. This is something, we have two schools of thought. We have a school of thought that says that the international law surpasses the national law. There's another school of thought that says that it's the national constitution that supersedes the international instruments. Now, in the constitution of Benin, it is provided for to have elections, municipal elections every 5 years. And we saw that the country was not respecting this. We are in a situation where the country is not respecting its own constitution. And this particular case, the citizens rather says the African courts and how need to understand that the international instruments supersede the national laws if these instruments have been ratified by the states. We have need to really think about these kind of things. The court should also intensify dialogue with the states and other stakeholders with regard to the implementation of the decisions. These dialogues can happen in different areas. For instance, the court can hold sessions outside Arusha. This will help the court to work in close collaboration with the national authority and also to improve their visibility at the civil society level, without which the court cannot work. When we have these sessions outside Arusha, we need to understand that it need to happen in different countries. And in the European Court of Law, the court has organization in different countries, planning working activities with different national authorities, encouraging them to use their decisions as jurisprudence. So the African court should get inspiration from this. The progressive institutionalization of the dialogue with the different stakeholders is important. Court should actually put in place mechanisms to convince countries that have not ratified the protocol to do so. Under the election of a new president and a new VP of the African court should present a good opportunity. So the election of these two new judges should be an opportunity for the court to come up with a new approach of cooperation to move things forward. During a visit of the court in Cotonou, Benin which had withdrawn, expressed its interest to work in collaboration with the court. And in conclusion, I would like to say this. I would like to simply say that the implementation of the decisions with the court cannot happen in a confrontation between the court and the states, but rather with the institutionalization of intelligent cooperation supporting the court or rather other states. Thank you very much.
Thank you very much, Dr. Nene, for sharing your thoughts on going beyond the resistance of states and sharing with us your views on how the court should interact with the states through decisions, how they should interact with the states in the implementation process, the role of national actors, the relationship between national and international law. But you wrapped up by underscoring the point that implementation can only happen outside of the context or within the context of cooperation instead of confrontation. Thank you very much, and I'm sure there will be reactions to the thoughts, your views that you've shared with us. Last but not least, let me call upon Mr. Daniel Kobe, who is the Ogiek community representative, to talk about raising community voices, implementation status of the decision of the Ogiek case. Mr. Kobe.
So I hope being the last person to speak does not mean marginalization, because this has been one of the issues which has been happening in my country, whereby some of the indigenous people, some of the tell us all the time that you are marginalized. I will just say, I'm from Ogiek community. I've been born and brought up in Mau Forest Complex. And today, I am one person who came last to be admitted to attend this meeting. Foluso, who is not here, is the one who told me at the last minute, I think you can attend, but you don't need to prepare a paper. So I have the freedom to give my story. Since 1997, I've been in these litigation processes to date. So more than half of my life, I've been going through talking about the Ogiek case. Today, I'm just only asking the court to engage us and maybe stop a lot of bureaucracy in terms of getting information from us. More so in terms of violations. From the time we came to court, we came because of mass violations as a Ogiek community. Now we are turning back to mass violations, where we are being evicted in our land and territories under the disguise of forced climate change and conservation forced decisions. That is in terms of carbon credit issues which are making us to be thrown out of our lands because there are things coming up called carbon credit and carbon market. The government of Kenya are very dynamic. When they hear there is some money coming, they change their mind about us because something is happening and the chances for the Ogiek community is diminished. This has come many times when our lands and territories is being given as a place where politics plays a role. Political dimensions, and today my brother was the one talking about political goodwill. We have suffered political goodwill because we don't have political goodwill, because we don't have a PS, we do not have a senator, we do not have a member of parliament. This makes it very hard for us to reach there. Personally, since 2017, after the merit judgment, I've met the current president, who then was the deputy president, President Ruto, and he told me, why go to court? We have solutions. I say, yes, we have solutions, but we want community land. He said, Kobe, that is wrong. I said, it is in the constitution. It is in the Kenyan constitution for customary titling. Because we know Mau Forest, the place where Ogega is very fertile, everybody wants it. The moment you give the community to take 1 or 2 acres, they will sell it and they go back again without land. So that's why we requested for community titling. This has changed over time because politics change. I met again with him. He said, now pray for me, I become the president. We prayed, he became the president. He said he's going to ensure to implement the Ogier case. Now he cannot talk to Ogier case. The thing he did after the African Climate Summit, he said the whole of Mau to be fenced, everybody out. 700 Ogier are out right now, and more children. Last week I received a list of 32 children in primary school who cannot go to school since January. 17 in secondary school. They are now homeless. They tell them move, but they don't say move where. All the time when this thing happened, there were task forces which were formed. Another one was formed. I think there are 3 task forces so far, and none has materialized to become a true implementation of the Ogier case. This takes you to the court to say, how much are you monitoring? It was supposed to be done after 1 year. We are now going to 2 years. We have not had implementation hearing, which we are still waiting. As I tell you, the issue of reputation, which was part of the orders, that there's usually non-repetition, it has become common. 2020, before the reparation of 23rd June 2022, there was a disguise of trying to implement the Ogier case. Somebody wanted to fast track it before the reparation judgment. And we said, no, we went back to court again in Kenya. So there'll be now domestic litigation being restarted, which we are doing it again. And now everybody says, oh, we don't understand about the African Court. So you should do capacity building, because you hear even lawyers and people in Kenya saying East African Court of Justice. They don't know the difference between African Commission, East African Court of Justice, and the African Court. I've been educating them. I'm not a lawyer, but I've been educating them free of charge, because they don't seem to understand the dynamics and the changes. And thanks to many of you, Professor Rachel Murray, Tom Nyanduga, Don there, and many others. And of course, my brother Horace, who has always been making me to go to court and receive very good welcome in court. You know, it's not very common to receive very good welcome in court, but I have come to the African court, I have many friends there. So today, as I'm telling you, it becomes very hard for us to see things happening because of the challenges as a community. The story of the Ogier not be told because it is over 20 years. Cannot be told in 10 minutes. But I can tell you, there is a lot to learn. There's a lot to be documented. And I wish the court should come to Mau and witness for themselves so that they don't stay in Arusha, come to Kenya, come and see for yourself where Ogier are, so that when you are making some decision or even future decisions, you will know where we are and the challenges we are facing. As I'm talking, the politician make fun of me. They tell me, Kobe, wait, African court will give you your land. Now, where is African God to give you me land, and yet it is the government of Kenya who is supposed to give me my land, my home? Recently, when there was floods in Kenya, one young man was swept away. We had nowhere to bury him. We had to buy a place to bury him. While we say there are many who are already there, why could we take him and bury with his ancestors where he has been? What is the difference with one body being taken to stay with the ancestors in Mau Forest Complex? So we felt we have been violated, and it is time for you to come and strongly, let's join hands. We have started moving. We came up with a committee of external experts trying to advise Ogiek on how to implement the case. We have even visited the embassies in Kenya, talking to them to talk to Kenya. Maybe they can listen to the embassies. Maybe they can listen to those people who are giving Kenya money. Probably they might one day say, give Ogiek their land rights. God bless you.
Thank you very much, Mr. Kobe, for telling your story. You said no paper, but you're telling a story. When you go to court, we are telling the court a story of the violation that takes place, and the court will believe the story and will grant an order. The government of Kenya does not have to listen to embassies. It just has to listen to the court's decision and implement it. And that is what we are here, discussing and trying to come up with strategies of ensuring that implementation takes place. It's a different thing to hear about the Ogiek people and so on and read the newspapers and in our colleagues' papers. But when we hear the story from those who own the story, those who are the story, then we should be even more motivated to participate in ensuring that that decision is implemented. So thank you so much for sharing that story and for the privilege you had to speak to the actors in that story. Your lawyer is here and other stakeholders are here to hear the story and what needs to be done. I will not spend more time here. I would like to invite the representatives of the court. They are written here as the court respondents. I see my friend here, Grace Wakio-Kakai, the Deputy Registrar of the court. I also see Dr. Misha here. Is there anyone at the back? I see the two of you. But of course, the first instance goes to the court, and I'm sure I can see, I recognize your hand, Honorable Justice. Can you take the floor, please? Please.
Thank you. Oh, dear moderator, I would like to thank Dr. Reiser for her intervention, as well as other colleagues. What she talked about really touched me. All the proposals she made should be taken into consideration with our focal points. Everything she said should be executed with regard to our relationship with the focal points. What she said, we're not going to tell it to the states directly, but talk about it with the focal point. It's a wonderful strategy. So I would like to thank her. Now, I would like to pose a question to my colleague and friend Ajay, just a reflection. Is it possible to show to this council to make pressure to the state to execute decisions, to make proposals to change the rules of the protocol, to say that the African Union should be in a position to sanction the states if they are told that a given country has not executed decisions. The court should be given, or rather the Council of Ministers should be given the power to sanction the states. It's not enough to say that such and such a state has not executed this decision, but go further and say, we're going to sanction you, you will no longer participate in such and such an institution. I would like this colleague to give an idea regarding this. Thank you very much, Chair.
Thank you very much,
Merci beaucoup. Madame la juge, à la fois pour le commentaire, pour la question que vous venez de poser. Y a-t-il une autre intervention? Le collègue de la Cour, vous avez la parole. Thank you for giving me the floor. Provide some clarifications. Whenever we're talking about the monitoring mechanisms, it's also necessary to talk about the different internal initiatives that are not very well known with regard to the differentiation of the action report, or rather action plan of action and the execution report. The unit of the monitoring unit came up with a model action plan. This is a tool. This is a tool that's part of the monitoring mechanism and of the execution of the decisions of the court on the 72nd session. The court adopted a certain number of tools, a certain number of models, and we also have a model action plan for the states. I'm saying talking under the control of the deputy registrar. This is some progress that have been made and that we should also talk about with regard to the monitoring mechanisms for the execution of the decisions of the court. Thank you very much.
Sure, Dr. Nyirongo might have something to say about it. Another intervention? Yes. Deputy Registrar, you have the floor, please.
Thank you very much. Thank you to the presenters for the papers. I also wanted to react to Dr. Raisa. Yes, as Serge had said, the unit has already been established and it's already started engaging with the focal points that have been appointed. However, that framework is still under consideration by the council. And of course, the points that they have raised are going to be looked at in the discussions whenever that will happen regarding the adoption of the framework. So we've taken that, we've taken note of those recommendations about the terminology, action plan, execution plan, etc., execution report, and the rest. Yes, for now, that is what I can say. Thank you.
Thank you. Thank you, Deputy Registrar of the Court. I see Dr. Misha's hand is up. Over here, over there.
Good afternoon, everyone. I also just wanted to thank the speakers, and I was also designated to comment on their various presentations. But first, in the bigger context of this conference, I wanted to highlight a point that I had shared earlier with a colleague here. It was an idea shared by a friend of mine who says that theory without practice is as lifeless as practice without theory is thoughtless. And I was just looking for a way on how to connect the different ideas presented in this panel. And the first thing that I noticed by Dr. Reza was this idea of a managerial approach to implementation. On like how can we better manage it through better systems, better procedures, better processes, timeframes, etc., which is fantastic. But what I would also push on is some of the ideas that came earlier during the discussions today about this multi-actor constellations. And I think within that framework, which I believe is also a little bit older now, because we're still waiting for implementation on that as well, is to bear in mind the various levels of governance, including the UN, who has their own human rights principles that need implementation and decisions. At the continental level, different actors, at the regional level, different actors, at the national level. And all these constellations, all these different partners have to speak to each other. And that all their demands of all these different actors also put the burden on these different states, which can then lead to fatigue, that they're just, also overburdened with and have capacity challenges in addressing those demands, those requests from all these different perspectives. And then about that idea of fatigue and states' perspectives, I think Dr. Arsene was talking about the crisis, the resistance from states, which is absolutely true. And that's also why I believe we need to think more on what are the... And that brings me to Dr. Tarise, what you were discussing about earlier today, on how can we mobilize states to want to do things rather than because they have to do things. And that also ties into Dr. Ajay, Honorable Judge, on what I felt like his presentation was essentially about, as what is the point of the African court? If it didn't exist, what would that mean? And the importance that it exists only is there if it actually makes a difference, right? And that brings me then finally, the full circle to Daniel, where I believe his story, which was highlighted by Tarise, and what the room responded to, the room was responding to the story from a victim on how the presence of the African court and what it does and doesn't do, how it succeeds and fails, how that affects people's lives. And I think that this is something that's too often overlooked, where we focus on the legal challenges, maybe some political challenges, but we don't focus on the stories. And I think as a human rights court, we are human beings, and all of us respond to storytelling. And I think that's something we could develop further on how to connect with people through the stories, what's behind it, rather than simply focus on institutional challenges and how to better manage them. So that's what I would appeal towards, for recording these stories, sharing these stories, and then especially the success stories. And then they can also hopefully be emulated in other cases. So that would be my final comment. Thank you.
Thank you very much, Dr. Misha, for tying up, the golden thread that runs through all the presentations. Do I see another reaction from the room? We have completely relegated the, commenting on presentations to the court. I don't see much movement from colleagues who are outside of the court. I've said so much in my moderation. So at this point, let me give each presenter a minute, two at most, to respond. I'll just follow the sequence, starting with the Honorable Judge. And
there is someone who's asking for the floor on this side.
Yes. To respond to the question posed by my sister Chafika, whether an amendment can be made to the protocol to give powers to the Executive Council to be able to sanction states that default in complying with the orders of the court. The amendment can be amended, but the problem is, would the members accept the amendment? Because even when it comes to declaration, instead of depositing, how many of them have deposited? And how many of them have withdrawn? We are left with only 8. So it can be done. But the problem is that whether the political will be there for them to amend. And just a minute on this issue. Some of us advise our countries, please, there is clear position that when there's a conflict between international court and a national court, the international court overrides, unless the statutes provides for mechanisms for addressing same. But if you look at the instruments we use, the African Charter, ICCPR, the International Covenant of Economic, Social, and Cultural Rights, and our international customary law, that is Universal Declaration, they haven't provided mechanism to resolve such a conflict. And in that sense, international law overrides national law. Thank you.
Thank you to the comments that I received as well. I'm very grateful for the input. Just being in the academic space, something that I realize is that it is also a bit challenging to get information as to the current status of things. So it was very insightful to hear what the court is doing and implementing in terms of the framework for monitoring. Yes, so thank you so much for that. And then in terms of the comment of looking at not moving away from the managerial approach, but looking at the different actors and what they can do with respect to promoting implementation, I think that is a very valid point. And as we see, there are many stakeholders that are involved in the implementation, or at least ensuring that the implementation of decisions is actually followed. And so that is also certainly an area that I will look into. But thank you so much for the comments.
Merci, je voudrais réagir également.
Thank you. I would also like to respond to the question about the sanctions. Yeah, this is a good idea, but as the Council of Ministers is constituted right now, there will be a problem. Because if you look at Europe, there is a council that is constituted of all the member states. But for our case, it's not the case. There are some countries in our continent who have not ratified the protocol, who have not done the declaration, and therefore cannot be members of the council. So giving the power to sanction states who have not even ratified the protocol, that would be a bit complicated. Having said this, without really raising a debate, I would like us to concentrate on the issues of relations between international and internal laws. As just said by the Honorable Judge, we can always review the African treaty so that we can add the superiority of the Constitution, and probably this would probably resolve the issue. For example, in the European Union, there are 3 jurisdictions that are supreme: the national constitution and the French constitution, for example. So this is a question that requires a lot of reflection before we can move forward. Thank you.
Thank you very much. I think from morning to now, there are a lot of information which have been passed, and unless they are effectively used for the implementation, that the communities like some of us have a lot of confidence in the court, the African court. And if you go to the village where I come from, and the people will also say that we are still waiting for the implementation of the African court judgments. So it is also upon the court to see that they can even get an investigative way to understand the situation on the ground, so that they can see how the communities are feeling. Because some of us have been threatened many times because they feel like we are delaying some people's issues because of leases, because of the situation on the ground. And all this comes about because the government finds that you have embarrassed them by bringing them to the African court and such like. So I think as these papers, I think we should see it at the practicability of what we are presenting. For layman like me and others, we want to see when you mention this, what does it mean? In my own mother tongue, because some of the people, I was a student of accounts, and one time you had to be told you should say what mean debit and credit, what this means in your language. So some of the things must be practical, otherwise we'll just be presenting some theories on this ground. Thank you.
And last but not least, I'm told that someone wants to make a final comment. They are online. Please go ahead if you can hear me.
Pedro. So Pedro, please unmute yourself and your video. This guy.
Please take the floor on our online participant.
So Pedro, please unmute yourself.
Merci beaucoup.
Please go ahead.
Thank you very much.
Je profite de l'occasion pour saluer les honorables juges
Take the opportunity to
la Cour africaine des droits de l'homme et des peuples.
thank the judges of the
L'institution qui
African
m'a
Court,
appliqué pendant plus de 6 ans.
the institution that
Je demande la parole pour dire
I
deux
have
choses.
requested for the floor for to say a few
D'abord,
things.
normalement, quand on parle
Normally, when we
de
talk
qui a
about
violé les droits de l'homme,
who has
nous pensons
violated
immédiatement à l'État.
human rights, we always
La
think
question
about the
qui se
impact.
pose,
And the question
c'est
that
qui est l'État?
arises is, who is the state?
Dans un système où
In a
l'épuisement
system where
des voies de recours internes est obligatoire,
local remedies is obligatory,
l'État, c'est le juge.
the state is the judge.
Parce que les recours internes sont épuisés devant un
Because
juge.
internal remedies or local remedies are important.
Si le juge avait
All the
interprété
judges
bien
have
la charte
well interpreted the
et
charter
intégré l'application de la
and
charte dans la décision
integrated the application of the
qu'il a
charter in their
prononcée,
decisions as they
normalement,
render decisions, and
il
normally
devait corriger la violation
they should
initiale.
the violation.
Si le juge n'a pas appliqué adéquatement
If
la charte,
the judge does not apply the charter,
donc c'est lui qui a violé le droit de la personne
then
en
it's
cause.
him who has violated the right of the person in question.
Dans l'abstrait, on peut dire que c'est l'État, mais en
In
concret,
abstract, we can say this is the
c'est le
impact that
juge.
we are creating, and therefore it is created by the judge.
Si
in
c'est
question.
vrai que c'est le juge qui viole le droit
If
des
it's
gens,
true, it's the judge who violates the human rights.
quand il s'agit de l'exécution des décisions de la Cour,
Send the decision of the court to the executive.
le juge doit être un acteur
Must
clé.
be a key actor,
Surtout quand il s'agit de
especially when it's about
l'application du principe de non-répétition.
application of the principle of non-repetition.
Si la Cour africaine ou la Commission, le comité ont
Court or
produit
the commission or
des
the committee
jurisprudences
have
qui va
produced some
répliquer
jurisprudence which are going to replicate
la jurisprudence au niveau national, c'est le juge
going
lui-même.
to replicate the national jurisprudence, then it's the national judge himself.
Donc, quand
And
il
therefore,
s'agit de l'exécution des décisions de la commission,
about
de la
implementation
Cour
of the decision
ou
of
du
the
comité.
commission and the
Quand il
court,
s'agit de parler de l'impact
when
de ces
it comes
décisions,
to talking about
le
the impact of
juge est
decisions, the
l'acteur
judge
clé.
and is the key actor.
Mais en réalité,
But in
le
reality,
focus a toujours été sur l'État.
the focus is often
L'État in
towards the
abstracto,
state,
ou bien l'État, le ministère des Affaires étrangères.
the state or the Ministry of
Donc,
Foreign
je
Affairs.
pense que nous
So
devons
I think that we need to
changer de focus
change the focus
et être un peu plus concret
and be
et
a bit more
travailler
concrete
directement avec le
and
juge.
work directly with the judges
Et
or
ça,
with
c'est
the
possible.
judge in question. And this is possible.
Ça doit être fait à travers la formation.
So we need to
Depuis le centre de formation des magistrats, il faut que
carry
le
out
système
training
africain des droits de l'homme et des peuples soit
so that
présent.
the African system and the actors be present.
Si les juges ne sont pas
If the
familiarisés
judges are
avec
not
le système
familiarized
africain,
with the African system,
naturellement, ça ne vaut pas la peine de parler
naturally,
de non-répétition.
it is
Parce
not
qu'ils vont
necessary
continuer
to
à
talk about
répéter les
non-repetition
mêmes
because they are
erreurs
going to continue to repeat the same
qu'ils
errors
commettent quand ils analysent des
that
cas et quand ils disent sur les
they
cas parce
commit
qu'ils
when they
ne
are
sont pas des
analyzing
juges des droits de
cases
l'homme.
because they are not judges, human rights judges.
On peut dire que c'est l'État qui est le responsable pour la formation
So
des
you can
juges.
say it's the state that is responsible for the training of the judges.
Oui, mais il y a la possibilité que
Yes,
le système africain
but
lui-même
there is a
s'engage
possibility
directement
for
avec
the
les
African
juges
system itself deals directly with the judges
de façon à ce que sa jurisprudence soit
to
connue par
ensure
les juges.
that these judges are aware.
Donc, je vous remercie de m'avoir donné
So
la
this
parole.
is what I wanted to
Merci beaucoup.
say. Thank you very much for the floor.
Very much for, to our final comment of the day. Please, let's put our hands in the African way and appreciate the views of our colleagues on the panel. And I am looking around to see to whom I should hand over. Oh, there she is, our director of ceremonies. I don't know how I can miss such a colorful lady. Please, you can come and take over the proceedings. Thank you very much. Yes, the panelists, you're excused. You may resume your seats in the room. Thank you.
Thank you so much to the last panelists and the chair for the last session. I think every time I see you now, Dr. Tarisai, I always think about political will. I think that's something that you really spoke about and emphasized. But without further ado, we've come to the end of day one of the conference on the implementation and domestic impacts of the decisions of the African Court on Human and People's Rights. Just a bit of housekeeping. Tomorrow, we arrive here we leave the hotel at 7:45 for those who are in the Palace Hotel. And it's going to be the same. We arrive here and then the program starts tomorrow at 9 a.m. in the morning. Dinner would be at the hotel. It will be the same as yesterday. And yeah, so I think that's about it. I wanted to ask a question, but I know that everyone wants to leave. So maybe I would leave my question for tomorrow or the icebreaker for tomorrow. But I noticed also I had not introduced myself when I started. So I don't want tomorrow all of you to call me the colorful lady. I do like color. But my name is Mary Izobo. and I am the Advocacy Program Manager for the Center for the Study of Violence and Reconciliation, where we actually work around post-conflict issues and transitional justice. And on this note, I would like to tap out, and I would say thank you so much, merci beaucoup, asante sana, and good night.